Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning and happy Mega Motion Day to those of you who celebrate. Happy Mega Motion Day. Emily C., if you're here, I think you should do write a poem. 'Twas the night before Mega Motion Day when all through the house. I'm sure you can make something really funny out of it. If you do celebrate, it's not a fasting holiday. Today is a day to eat, drink, and be merry. And if you can name that tune, you might be one of my best friends. How's everybody doing? First thing I want to just catch you up on is to let you know, today's Thursday, right? Yeah. Today's Thursday, September 18th of 2025. And the Joshua Hubert trial is still going on. The jury is still deliberating. They've had that case since, I think, Monday. Hang on a second. And then yesterday, one sec. Why can't I? Oh. So this is an article from Mass Live from today's the 18th, from yesterday. No verdict has yet been reached after 2 days of deliberation in the trial of Joshua Hubert, a Worcester man accused of kidnapping, graping, and throwing a 7-year-old girl off a bridge in 2017. The jury began deliberations in the case at 11:25 a.m. on Tuesday, following a week of testimony in Worcester Supreme Court. They've now accrued about 11 hours of deliberation since, and this was from yesterday. It says the jury asked 3 questions yesterday. Hang on a second. One second. The jury asked 3 questions yesterday, 2 about technical language and information on the cell phone data. The 3rd question was about a lack of a unanimous decision, which indicates to me they may be heading toward a hung jury, but you know how that goes, because in Massachusetts, the judge has to give the jury the Tui Rodriguez charge, which is what we call an Allen charge in New York. Some states call it a dynamite charge, and give them like one last chance to go in there and get it done, because nobody can get it done better than you can. Quote, a question has arisen about what happens should a unanimous decision not be reached on an indictment, Judge Karen Bell said Wednesday afternoon. David McSherra, a Worcester County prosecutor, argued the jury was saying they were not deadlocked yet and that deliberations were too early for the judge to provide more instructions based on ambiguity of the passive wording. Defense attorney Kevin Larson agreed with the prosecutors that jurors weren't saying they were deadlocked and asked the judge to tell them their verdict must be unanimous. And so there's that. We'll see if they reach a verdict today. Should be interesting. As you know, Court TV asked to televise that trial, and they were told no. Let me see if they just have anything more recent here. Mass Live is the only one reporting on this. Does anybody know if like Boston 25 or Boston 10 or anyone else is reporting on this? Because I haven't seen it. What I did see, and I commented on it on YouTube, I think it was yesterday, was it Boston 25 released a video of a reporter standing outside a courthouse talking about the indictment of a Worcester man throwing a girl off a bridge who was 7. And I was like, oh my God, it happened again. And they just published it without telling anybody that it was the original news reporting from 2017. So I wrote in the comments, I'm like, this is from 2017. The jury's deliberating on this case right now. It was weird. It was so weird. I don't know why they did that. And so we wait. Yeah, I don't know. That was stupid. All right, everyone smash the like button on your way in, please. Because, it's the nice thing to do. It's like, it's like wiping your feet on the mat when you walk into somebody's house. And that's the way we roll. All right. So that was weird. And then I also saw an article that indicates that maybe this was published yesterday too in Boston 25. Brian Walsh may be looking for a change of venue out of Norfolk County. Court records reveal his lawyers are researching media coverage of his case, and that research could be used to request a change of venue. But we had heard that for a long time. There was there's been a lot of rumblings about Brian Walsh potentially asking for a change of venue. His trial is scheduled for October 20th. So if Larry Tipton's going to do it, he should do it quickly. You recall Brian Walsh was from Cohasset, or they lived in Cohasset when such as something like that happened. And I don't know what the people with the okay, I'm gonna say this again for like if you're blocked for some reason, I don't know why YouTube is doing this. They're like randomly blocking people. If you send me an email that just says I've been blocked, can you unblock me? I can't do it. You have to send me the link to your actual YouTube channel. Even if you're not a creator, you have a YouTube channel. Sending me an email with just your name on it doesn't help me. Sending me an email with your username doesn't help me. It has to be an actual link to the actual thing. And I apologize for that. And I don't know why YouTube is doing that, but it seems to be happening to at least a couple of people. Okay. So I cannot do anything for you without a link to your actual channel. Oh, okay. All right. Well, this is interesting too. It appears, thank you, Kyle Sharkey, that Lindsey Gaetani has filed a motion for a finding of criminal contempt and imposition of sanctions against defendant Aidan Timothy Kearney for willful and knowing violation of the protective order. And this looks like it was filed today. It is docket number 101 in his case, and that it may not be scanned yet, but if it is scanned and anybody has seen it, certainly send it to me. It will probably wind up in my inbox at some point during this stream. Thank you, Tracy, for your Venmo. She says, can you please explain today how the attorneys know what has to be redacted? It seems so random, and I'm just curious. Thank you. Actually, so what the things that are under the protective order are certain text messages and communications between and among, let's say the NPCs in this case. If anybody plays video games, you know what an NPC is. It's like the extras, like the background. It's communications between anyone, basically, I guess that's not Aidan. And those communications, many of them regarding Lindsey Gaetani and Jennifer McCabe and Carrie Roberts and other players in the case are subject to a protective order, which means that they have to, right. They know they have, thanks, Emily, here you are. I don't know if you heard me, but I said you should do like a little, 'twas the night before Mega Motion and all through the house. And I know you can make it really funny. Today is the holiday for those who celebrate of the mega motion. And I said earlier, it is not a fasting holiday. It is a holiday to eat, drink, and be merry. And also, we're going to play a little game of like Mad Libs. Remember Mad Libs when you had to like fill in the blank? And Emily says they know they have to redact the sentence if it starts with Jen McCabe, ... So there's that. All right. So Lindsey Gaetani filed a motion for a finding of criminal contempt and imposition of sanctions against Timothy Kearney, or A. Timothy Kearney, as he prefers, or doctor or daddy, for willful and knowing violation of a protective order. I don't know. I don't have the papers on that yet, so I can't tell you what it's regarding. But I seem to have heard, and I haven't seen this, and I refuse to click on any links that purport to contain this, that somebody, oh, thank you, Mass Dad, somebody has released Lindsey Gaetani's entire cell phone extraction, even though that is supposed to be subject to a protective order, but it's Aidan who's not allowed to release it. And apparently it may be some other people who have released it. And so therefore, let's just take a look at this motion because Massad has just sent it to me. And since it's hot off the press and we're here for Aidan today and all of his motions and things and stuff, this will be one that I guess many of you have not seen yet. So I haven't seen it either. It's 46 pages. I don't think I can read the whole thing to you right now because, of course, my thumbnail is for something else, the mega motion. But since we're here and since it's hot off the press, let's take a look. Somebody just said, I have YouTube Premium and I better not get ads. I have no control over that. I don't show you any ads, but I will tell you this, Sharon T., formerly Abby and Rosie's mom, that if you are a YouTube watcher and you watch YouTube all day long, your money is very well spent to pay for YouTube Premium. I don't know how much it is right now. Does anybody know how much it is? But I venture to guess that it is less than Netflix. So it is well worth it if you don't like the ads. So good luck, Sharon. Congratulations on your upgrade of your YouTube Premium subscription. Somebody says it's $18.99. Somebody says $15. $22 for 5 users. It includes music too. Everyone says it's worth. It's totally worth it. All right, here it is, hot off the press, my friends. Although it looks like it was, it's stamped September 17th. Lindsey Gaetani's motion for a finding of criminal contempt and imposition of sanctions against defendant Aidan Timothy Kearney for willful and knowing violation of a protective order. Now comes Lindsey Gaetani, victim. Oh, the victim. Always the victim. Or, maybe a willing participant in a setup / conspiracy to incarcerate Aidan Kearney, in my opinion, some might say, based on the text messages between Tully, Mello, Lindsey Gaetani, and Kay Peter, to set him up and incarcerate him. But, that's my opinion. Opinions are protected by the First Amendment. And so that's my opinion. I'm sticking to it for now until somebody can convince me otherwise. So let's see what she's squawking about today. If I can find my cursor. Okay. Where'd you go? Oh, and she's pro se. Okay. Really? She's pro se, meaning she's representing herself without an attorney. And yet she's looking for attorney's fees because we saw that in her last wacky filing. And she herself drafted a 46-page motion. Well, this should be interesting. Never a dull moment over here. Never a dull moment over here in Massachusetts, is it? Is there? This is not a fly on your screen. Please don't break your TV and send me a bill. This is my cursor and I need it because I got to scroll through this thing. Lindsey is proceeding pro se, pursuant to the court's order dated September 26th of 2024. Judge Katie Rayburn granted her leave to file pleadings and respectfully moves this honorable court. I mean, is this a chat GPT thing? I mean, really, what do you think? Do you think that there's a that there's an attorney or a wannabe attorney or a law student working behind the scenes with her? Do you think she's using ChatGPT to draft these motions? Do you think, I don't know. I don't know. I'm confused. But she wants a finding of criminal contempt against defendant Aidan Timothy Kearney for his willful, knowing, and repeated violations of the protective order dated December 27th of 2024, issued by Judge Krupp. Ms. Gaetani further requests an expedited evidentiary hearing. Oh, she wants an evidentiary hearing? By all means, let's give it to her. Let us give it to her. There's nothing we'd like more than to see her on the stand. Imposition of sanctions and such other relief as the court deems necessary to vindicate its authority, protect Ms. Gaetani's rights, and preserve the fair administration of justice. You know what I'm going to do? You know what I'm going to do? Because I'm here for you and I love you guys with all of my heart. I'm going to make a little banner. So if anybody comes in and they're like, what are we doing? What are we doing? You can direct them to the banner that will be scrolling along the bottom. Hold on. Talk amongst yourselves for a second. I can't talk and type at the same time. I don't know. Okay. So it's Lindsey Gaetani motion for contempt against Aidan Kearney filed yesterday, and it is scrolling along the bottom. So feel free to tell your friends when they're saying, what are we looking at? Send them right to the bottom of the screen. This motion is supported by an affidavit of Lindsey Gaetani. Okay, we should learn something from watching me. And I know she watches me because she's been in the chat quite often. Hey, girl. Hey, if you're here. And a memorandum of law. Well, by all means, let's check this out. In support of this motion, here's the introduction and procedural posture. And I'm going to kind of summarize as we go through. The protective order was issued by Judge Krupp December 27th, 2024, to prevent irreparable harm to Ms. Gaetani by prohibiting the unauthorized dissemination of her unredacted cell phone extraction, a forensic image containing over 15 years of sensitive, privileged, and irrelevant data, including attorney-client communications, medical records, personal photographs, and other protected material. The order explicitly bars defendant and his counsel from disseminating any extraction material, whether directly or by means of any third party, except for strictly limited litigation purposes among the defense team in the instant matters only. It mandates destruction of all copies, certification of compliance under penalty of perjury, and safeguards for court use. Well, here's what happened. Tully, either by mistake or on purpose, turned over a complete and total extraction of Lindsey's phone to the defense. No redactions, no date, no restrictions of date, and it's 15 years of her private information. And you know what? I'd be pissed too. But she should be pissed at Tully because Tully's the one who did it and they were working together. And then apparently he double-crossed her. This is like, you know, an Agatha Christie thing, or maybe give me somebody else who does like double-crossing plots all the time. Cross, double-cross. She's been double-crossed by Tully. Then he turned it over and then Memo gave it over. And so, you know, like maybe what you should be doing is trying to place the blame on somebody as such, like Tully or Memo. And she is trying to sue them or, you know, cross-claim against them, counterclaim against them, even though they're not defendants yet, but they have immunity. And so maybe she's directing her anger at the wrong person and in the wrong proceeding, but we'll see. On September 5th of 2025, Judge Doolin upheld the order rejecting defendants' challenges, affirming its necessity to protect privacy and prevent prejudicial publicity. Defendant has brazenly defied this mandate, though, through a pattern of violations culminating in the September 11th, 2025, public release of the entire unredacted extraction on X, formerly Twitter, by Jason Broyles, aka HW on your case, a known proxy to whom defendant has admitted leaking public materials. And then she attaches some posts that say that they provide direct links to the extraction, flouting the court's ongoing prohibition. Well, I don't know that Jason Broyles, aka Haley Walbrecht, or not Haley Walbrecht, or whatever, is working for Aidan Kearney. I don't know that she can prove that. But I do know that I have heard Aidan say on his shows recently that he cannot release her extraction, and he knows he can't. That extraction has been out there since before the protective order was in place, if I recall correctly. And so you can tell me that if you know that, but I have no idea. Jason Broyles used to go by Haley Walbrecht and had a female profile picture and befriended apparently a lot of people pretending to be a woman named Haley Walbrecht. And if you don't know the lore behind that involves me, is that when I started reporting on this case in January of 2024, this Haley Walbrecht account was very active on Twitter and very hateful and being mean to, I guess, a lot of people that were on the other side of Free Karen Read. So the anti side, I don't know what you call it. And then kept threatening to do things and threatening to release Lindsey Gaetani's private information. And then the trolls thought that it was me behind that account. And people like Grant Smith Ellis and Lindsey and all of these other people, Kate Peter, the Mass Hole Mafia Not So Confidential informant, and all of those people and all of their fake accounts started coming for me. And I didn't even use Twitter. I had an account that was like a decade old. They started doing such things as posting pictures of my children, posting pictures of where my children went to school, posting a picture of my children's bus stop, as if to say, we know where your kids are and we know how to get to you, so you better shut up. And this Haley Walbrecht person, although they denied being me on the cesspool of Twitter, did not ever reveal their true identity until sometime way later. Yeah, he caused a lot of problems for a lot of people, not just me. And then before they thought it was me, they thought it was someone else, like a priest, and they went and they attacked him. And then they went and they visited people. Like it was wild. I left Twitter. I'm like, I have no time for this. I don't know what this is about. It has nothing to do with me. But when you go posting a picture of my kid's bus stop, we got a problem. I've got everything saved. It's all archived, because when all this comes out about who was doing what, and I'm dying to know too, because I have not clicked on any links about her cell phone extraction. I don't care, but I want to know if she was talking about me, if she was having people look up my address, and if she was having people post these pictures. And that's horrific. And this Haley Walbrecht person who claims to be a victim advocate should have seen what was going on with me, because was, very involved over there. I left Twitter. I was like, I'm getting out of here. They thought it was funny. They thought that I rage quit Twitter because I was whatever behind this account. No, not true. I don't have time for it. I'm an adult. I don't sit on my phone all day and spew hateful things about people from a fake account. And by the time that Haley Walbrecht revealed himself to be Jason Broyles, and I don't know if he was outed or if he decided to just, do the right thing and let everyone know that, it wasn't Melanie Little, it was really him. Grant Smith Ellis was calling for people to have me disbarred, calling for people to write letters to the New York Bar Association. It was wild. And they all got involved. Jennifer Coffendorfer, all of them. And it's all documented. So when you say ignore the troll, I'm not ignoring the trolls. They are going to be called out. They are going to be held to account. And, shit like this shouldn't be allowed to go on. You shouldn't be allowed to just, get out there behind a fake name and think there's never going to be any ramifications for your behavior. And then I saw Nan Gallagher posting something today that was very cryptic. It's like, I don't know, something about, you guys, somebody sent it to me, something about when the hunted becomes the hunter, you better watch out. So I don't know what that's all about, because she was kind of not so blatantly accusing me of being behind some other account named John Barron and coming for her. I don't have time for that. I don't have time for it. I don't care. I don't care about the drama, But again, when the drama is going to involve me and they're going to try and involve me and pretend that it's me, and then when people are saying to her, oh, you're saying it's Melanie Little, and she's saying, I'm not saying it's, I'm not naming any names, I'm not saying anything. It's a problem. So I can't wait to see what comes out. But you know, I don't know what Nan is up to, but it has nothing to do with me. And maybe an apology would be nice. Okay? So there's that. You can't ignore it. You can't ignore the trolls when it involves kids. No. And you can't ignore the trolls because if you ignore them, they're just going to keep doing it. Right? So there's that. I don't know. I don't know why. You know why they started dragging me originally? Because I didn't think that John O'Keefe was hit by a car. That is exactly why. It is no reason other than that. Because you know me, I do documents, I do facts, we did police reports, we did everything in the Kearney case, public documents that we were going over, and they were scared, and they were scared, and they, after this filing, not this one of Lindsey's, but the ones that Bederow drafted, the same people should be very scared. They should be. And so that is what it is. Okay. Okay. So there's that. Thanks for coming to my TED Talk. All right. So again, Lindsey now is blaming this guy, Jason Broyles, Haley Walbrecht, on your case for releasing on Twitter with links her entire 15-year cell phone extraction, claiming that he is working for Aidan and trying to get Aidan on contempt charges. She says, even if Broyles obtained the files before December 27th, their dissemination now, while the order remains in full force, constitutes a willful violation attributable to the defendant, given his established agency relationship with Broyles. Well, I don't know. That's a tenuous connection. But maybe what you need to do in your evidentiary hearing is subpoena Jason Broyles, who apparently lives in Connecticut, because you tried to counterclaim against him, even though he's not a counter defendant, and have him come into court and swear under oath about whether or not Aidan Kearney told him to do that. I don't know. I have no inside info there. Jonathan. So I just don't know, but this might be a little bit misplaced. Again, I don't know. And then she says, compounding these violations, on September 14th of 2025, mere days after Broyles' release, Aidan did a YouTube episode, 807, Wilbur Show overview, Cosgrove won't give phones back, Dever update. Well, I guess she learned from the mistakes of others to maybe properly title his shows, where he admitted to previously distributing the extraction to multiple individuals, discussed its contents in the context of the protective order, and effectively directed viewers to access it, now widely disseminated by files, noting it's all over the effing internet and implying they can find it independently. These statements not only reinforce defendant's role in the initial leaks, but also encourage further dissemination, constituting additional willful contempt. Massachusetts courts possess inherent power to punish such disobedience through criminal contempt. Oh, and look at the case that she cites. Isn't it ironic, don't you think? It's called In Re McCabe. It's from 1991. Because, like, there's nothing that you could make up in this case that would make it more interesting than it is. Hang on. Ms. Gaetani respectfully urges swift action by the court to deter further misconduct, uphold its prior orders, and remedy ongoing prejudice. Okay, well, what does she want the court to do? Statement of facts, the inadvertent disclosure and protective measures. On or about April 24th of 2024, Brian Tully negligently and in quotes inadvertently disclosed the unredacted extractions to defense counsel Timothy Bradel, who shared it with defendant, despite the Commonwealth's immediate clawback request. I don't know about a clawback request, but again, Aidan Kearney is entitled as a defendant to have access to all of the discovery materials in his case. And so there is nothing wrong with him being able to look at it. Ms. Gaetani surrendered her cell phone in December of 2023 based on then special prosecutor Ken Mello's oral assurance of screening by a reverse taint team to protect irrelevant privileged data. Despite repeated requests, she has not received the signed consent form. Oh, so she turned it over on consent. because, she wanted him to go to jail. So they probably told her, if you want him to go to jail, I will give you my phone. And apparently she signed a consent form, but they won't give it to her. And as you know, or may have forgotten, Ken Melo has since been disqualified by court order from the case involving Lindsey because he is going to be a witness because of these four-way text messages as such. 3, following defendant's initial unauthorized dissemination, this court issued the protective order on December 27th, 2024. Okay, so it was a full year later. A full year later. No, I'm sorry. All right, on April, she gave her phone over willingly. December 23. April 24, Brian Tully gives the entire extraction to Bederow. 7 months later, the court issued the protective order. So for 7 months, these materials were not under a protective order. And, they went all over wherever they went. September 5th, Judge Doolin updated the order. And so now they're under the protective order again. And somebody asked earlier, boil your bunny. Somebody asked earlier, what is subject to the protective order? And all of these text messages are again. And then she, of course, goes on about his patterns of violations, which I will scroll through slowly. And then the alleged grape report. We've been through much of this before. And then there's a September 11th, 2025 violation. Well, she's saying here that in a show, August 10th of 2024, again, which was before the protective order, right? That was in December 2024. That Aidan said on a show, I provided the report to Broyles for posting. She says he said that. I don't know if it's true. I'm sure you can go there and find out for yourself. On September 11th, 25, Broyles released the full unredacted extraction on X. And here are the posts and links, but are they hyperlinks? Well, it's a PDF, so I can't click on any hyperlinks. Broyles' reference to his source and prior collaboration with defendant confirm agency. Exhibit D purports to be a reply from Broyles that says, I published exactly what my source represented was what the Commonwealth provided. I don't know whether Aidan is his source or not. These posts, viewed thousands of times, caused Ms. Gaetani severe emotional distress, harassment, and safety risks. Ongoing violations, regardless of when the files were obtained, even if Broyles obtained the extraction before the protective order's issuance on December 27th, 2024, meaning between April 24, 2024 and December 27, 2024, the dissemination on September 11th of 2025 violates the order. Well, here's the thing. The order is against Aidan Kearney, not against the general public. If you're just getting here, yeah, I'm just reading this because this just dropped yesterday. Lindsey Gaetani is moving for contempt against Aidan. And so she wants an evidentiary hearing, and we're just kind of going through it briefly to see. Then she says he violated again on his September 14th show. I just want to know. Oh, and then here, there's a live chat section. Erica Walsh posted a direct link to the extraction. It hasn't been removed. And then she's saying these statements not only confess prior violations, but also encourage ongoing dissemination by directing viewers to the files, et cetera, memorandum of law, what you need to show to get criminal contempt. This is a cold read, so I just want to kind of flip through it now, and then we'll see what she wants. Here's what she wants. She wants an expedited evidentiary hearing within 7 days. Excellent. Get Tully on the stand, get Melo on the stand, get Jason Broyles on the stand. Get Lindsey Gaetani on the stand. Get them all on the stand. That's great. Aidan's been fighting for an evidentiary hearing for a very long time. For a very long time. How many times have you heard Mark Bederow say Melo's a witness? He needs to get on the stand. All of them. Did you ever think that in a way Lindsey and Aidan would be on the same side? Because that's what she's doing here. She's helping Aidan by asking for an evidentiary hearing. She's telling them, let them tell us everything. Find Aidan Timothy Kearney in criminal contempt, impose sanctions, including, incarceration up to 90 days. Oh, she wants him to go back to jail for 90 days or until the violation is purged, meaning removal of posts and files and websites. Well, he doesn't have access to Jason Broyles' accounts. A fine of at least $20,000 she wants. Now, remember, she's just asking for this stuff. That doesn't mean she's going to get it. Matt's dad pointing out the judge and court staff would be paid regardless. So while this motion is trash, it is not by itself wasting tax dollars. That's correct. I will agree. Exclusion of all extraction-derived evidence at trial. Yeah, no, that's not how that works, sweetie. It's on a text by text basis. D, an adverse inference jury instruction against the defendant regarding that evidence. I guess she's resigned herself to the fact that this is going to trial. An award of Ms. Gaetani's cost, fees, and damages for emotional distress. Well, you'd have to prove emotional distress at trial. Considering that you filed this in the case of Commonwealth versus Aidan Kearney, first of all, does she even have standing to file this motion? I don't know. She's a witness, an interested party. She's not a party. So I don't know if she's got standing to file this motion. I don't know if she's got standing to demand that the court do all of these things. I don't know how she's going to approve her emotional damages in a case that she's not even a party to. I think I should get damages for emotional distress for having to read this. And she also, standing is questionable. Thank you, Mass Dad, who is in Massachusetts and knows a lot, everything about procedure, case law, and all of the things and stuff when I have questions. In addition to that, she also wants, she wants it to be referred to the Norfolk County District Attorney or the Attorney General for prosecution. Well, that's interesting. First of all, the Norfolk County District Attorney has been conflicted out of Aidan Kearney's cases. So that's why Ken Mello was involved. That's why Cosgrove is now involved. And that can't be done. And the Attorney General, where's the jurisdiction for the Attorney General? I have so many questions. Mozzie says, this tells me she's big mad about the Wilbur Theater show's success. Yeah. She wants to speak to the manager, says Charlotte. She does. Thank you, ladies and gentlemen. Ladies and gentlemen, LawTube's most hated mod is here to remind you to please keep it classy and try and leave the mental health comments out. Yeah. Let's try not to defame anybody in the chat because YouTube does have AI and they go through the chat and then they shadow ban us. And we don't want to be shadow banned because we want everyone to know about this. Look at Mike Crawford is here. And he says, I was Haley for a bit too. And those trolls did all the same stuff to me. Went to local courthouse to find and post my parents' 1972 divorce, photo of where I live, threatening my dog walk business. Okay. All right. You too, huh? Hell hath no fury, my friends. Hell hath no fury. Sorry that happened to you, Mike. Not only that, she wants to issue and she wants the court to issue an interim order directing the defendant to cease violations, including any further public discussions. Oh, she doesn't even want him to be able to talk about it. Or encouragements to access the extraction on YouTube or other platforms, and cooperate in removing the posts Linked files, websites, unrelated broadcasts. Oh, so he should take down all of his YouTube shows in which her name is mentioned or the extraction is mentioned too. I mean, Dad, make him stop. This needs to stop. This needs to stop. Extend the protective order to any and all future or prior discovery provided to the defendant in the incident matter involving Ms. Gaetani. Well, that's a little overly broad, isn't it? And Grant, I see Grant had to get his name in there somewhere. Grant such further relief deems just improper. XOXO, Lindsey Gaetani, pro se, dated yesterday, filed yesterday. And she served it on Cosgrove and Bradle. And she's got lots of exhibits and YouTube transcripts and screenshots of his live chat and her own affidavit. And, it's 46 pages long and it was hot off the press. So I thought we'd take a little peek at that one first. Oh, Lindsey. Oh, Lindsey. All right. I thought what we would do first today, since we're a legal-based channel, let me take that. Look at the memorandum of law, because I don't know if Aidan went over that on his show last night. I think he only went over, or you can tell me. I didn't watch. I was too tired. Yesterday was a hell of a day. If he went over the memorandum of law also, or if he went over the affidavit in support. The affidavit in support is 88 pages. The memo of law is 36 pages. I'm more interested first in the memorandum of law because that is going to tell us what we're looking for, what we're looking to prove in the affidavit, which is 88 pages. Okay. Okay. XOXO. All right. So this is, I just got to change this banner. Talk amongst yourselves for a minute. All right. So we're going to first look at the memorandum of law in support of the motions to dismiss the indictments of Aidan Kearney. Bederow has some of the finest legal writing that I've ever had the pleasure of reading to you. Get your drink, get your coffee, get your popcorn, get whatever it is that you're going to need to get you through this 36-page masterpiece of deliciousness. Love you guys so much. Char wants to know, can anybody help me? My cousin has her 50th birthday tomorrow. What should I bring as a present? Well, even when people say no gifts, you should bring a gift. Don't show up arms a swinging, okay? Showing up arms a swinging is never a good idea. I don't know. I don't know what your cousin likes. You're not even, oh, it's her. It's a her, gift card to Sephora. That's always nice. It's always nice to bring a gift card to Sephora. A lot of people bring bottles of booze to parties, but cash. You can give cash. Remember when Elaine got so mad on Seinfeld because Jerry gave her cash for her birthday or something? She's like, "What are you, my uncle?" Yeah, arms a swing. You can't show up arms a swinging. It's never a good look. You got to bring something: cookies, a cake, a rugula, a babka, a marble rye. I mean, you don't show up arms a swinging. Hang on. Flowers die and they're expensive. And then, also when you bring someone a bouquet, they got to find a vase. They got to do work. I think a Sephora gift card is nice because a lot of times, you need makeup, you need stuff, but you're like, oh, do I really need to spend $100 on myself today? And then that gives her something to, an opportunity to buy it on herself, to buy something for herself. Yeah, a marble rye. Okay. Let's go. Give your cousin a Melanie Little membership. There you go, Emily C. I like it. I'll allow it. Here we go. Argument. Point 1, the indictments must be dismissed because the Commonwealth impaired the integrity of the grand jury presentation. Okay, this is a good time to point out to you that 2 states do not use the grand jury system at all, Connecticut and Pennsylvania. Of the 48 remaining states, half of them are required to use the grand jury. In New York, we are required to use the grand jury, New York, New Jersey. Many other states, the grand jury system is optional. So for example, if you were watching the press conference from the DA in Utah the other day with respect to Tyler Robinson, he said, we are not going to use a grand jury. We are going to have a preliminary hearing. We have also seen that in other cases that we have followed where we were waiting for an indictment or we were waiting for a preliminary hearing, and then instead the state convened a secret grand jury, and then the defendant was indicted. And I don't remember exactly what case that was. A grand jury is made up of between 12 and 23 people. They usually sit for an extended period of time. In some states, they can sit for up to a year and hear many cases. They come in maybe once a month, and they hear many, many cases. In other states, they maybe just come in for one case. Was it Koberger? Yeah, maybe it was Koberger. Thank you, Law Office of Andrew Myers. We were waiting, right? We were waiting for a preliminary hearing on Koberger, and then instead what they decided to do was indict him by grand jury. Thank you. Thanks for coming in. In Massachusetts, Arkansas is the other one. Thank you, Grace Base. That's exactly what I was going to say. So Arkansas is the other one. And that is why you saw recently in the Aaron Spencer case, the attorneys for Aaron Spencer made a motion to try and have his indictments dismissed because they did not use a grand jury. But Arkansas is one of the states in which it's optional. Yep. Also Corey Richins in Utah. Yep. The difference is that a grand jury is secret. A grand jury proceeding is one-sided, meaning there's no judge. It is just the prosecutor in there presenting whatever evidence he or she wants to the grand jury. The grand jury is allowed to ask questions. They can ask the witness questions too. And then if the grand jury finds probable cause, a true bill or an indictment is issued. And that is how the defendant is charged. In a preliminary hearing, both sides are present, and the judge will listen to arguments from both sides, and then the judge will decide whether or not there's probable cause and whether the case can proceed to trial. Okay. In this case, in the Aidan Kearney case, they went to a grand jury. It was secret. Usually when a grand jury is convened, the defendant doesn't even know anything about it. And like, for example, in the case where they tried to indict Aidan Kearney and Karen Reed for conspiring to commit witness intimidation, that grand jury was convened or maybe concluded in March of 2024. I don't think Karen's attorneys even knew about it until her first trial was ongoing. And so they didn't know that it went to the grand jury, and the grand jury refused to indict Aidan and Karen. We did a show the other day on a motion made by Cosgrove to try and get a taint team to re-examine or to examine for the first time Karen's phones that were seized in January 24 to try and indict her on some more charges. Because apparently when they went to the grand jury, there was one witness. It was Tully. Memo brought it to the grand jury. I'm talking about the Aidan and Karen case now. Tully was the only witness, and apparently they didn't have any cell phone extractions. So I don't know what the hell evidence they presented, but just because they already went to the grand jury once and tried to indict doesn't mean they can't do it again. You can do it again if you have more evidence. So there's that. Will they? I don't know. Does Cosgrove even have standing to make that motion? I don't know. I'm hoping somebody did a FOIA request to get all of Cosgrove's contracts, because I would love to know if and when if ever Cosgrove was hired to prosecute Karen Reed. Every time I cover something in this case, I feel like I'm again in the Twilight Zone or the upside down, inside out Narnia of Massachusetts or Land of the Lost. And so sometimes that's why Chaka has to go up in the upper right-hand corner, because we're in the Land of the Lost. Okay. So the first argument is that, oh, Matt's dad did it, requested Cosgrove's contracts. I am sitting on the edge of my seat waiting with you for that. Okay. The indictments must be dismissed because the Commonwealth impaired the integrity of the grand jury presentation. A, the applicable law. An indictment must be dismissed where the integrity of the grand jury proceeding has been impaired by an unfair and misleading presentation, citing Commonwealth v. Odell. And if I have a PDF version of this, but if I didn't, Olivia Lambo, Olivia Nile in chat is amazing. She's working on Aidan's team now with Tim Bradel and Mark Bederow, and she created a document for the court in which all the court has to do is click on this hyperlink of Commonwealth v. Odell, and that window will open for the court. Everything is right there for the court. Talk about making the court's job easy, huh? It's amazing. And Tim Bradel is so amazed by it. When I met him on Friday, he was gushing about Olivia and what a genius she is and how he's never seen this done before. And it's amazing. And I agree because we love Olivia. If the Commonwealth knowingly uses false testimony to procure an indictment, the integrity of the grand jury proceeding has been impaired and the indictment must be dismissed. Must be. That is not optional. It must be dismissed. And that is citing a case called Commonwealth versus Mayfield from 1986. A prosecutor's reckless disregard for the truth that leads to the admission of false or deceptive evidence may also warrant dismissal of an indictment. Citing another case from 2024. Dismissal of an indictment requires a finding that the false or deceptive evidence, quote, probably was significant and that it was presented to the grand jury with the intention of seeking an indictment. Citing Commonwealth v. Brown, which says improper evidence resulting from the prosecutor's design is more problematic than evidence received in response to a grand juror's question. A prosecutor's introduction of part of a defendant's statement, but which excludes a favorable part, which changes the context of the admitted portion, may impair the integrity of the grand jury proceeding. Citing some cases again, because Bederow brings receipts every single time. And here's a case right here, Commonwealth v. Blakeney, which was just decided August 29th of 2025. The, quote, clearly undesirable admission of uncharged crimes or alleged bad acts of the defendant before the grand jury may impair the integrity of the grand jury proceeding. The serious risk of prejudice, which requires dismissal of the indictment, increases where improper evidence of uncharged bad acts is, quote, offered gratuitously by the police or by the prosecutor rather than admitted in response to a grand juror's question. The risk of prejudice is also increased by a prosecutor's failure to curtail the line of improper questioning or by a blatant attempt to whet the juror's appetite. WHET. Who's going to change their username to whet my appetite? WHET. It's a race. With the uncharged evidence, citing Commonwealth v. Rakes, prosecutors' clear and relatively contemporaneous instruction mitigated prejudice caused by introduction of unrelated bad acts. B, the impairment of the integrity of the grand jury proceeding. The facts which establish that the Commonwealth impaired the integrity of the grand jury are straightforward. The critical issue for the grand jury's determination was whether Aidan Kearney intended to intimidate witnesses. But rather than let the grand jury, the exclusive judge of the facts, resolve this key issue through its evaluation of accurate and truthful evidence, Special Prosecutor Kenneth Memo intentionally misled the grand jury with false and misleading testimony and evidence and introduced evidence of uncharged crimes to smear Mr. Kearney and increase the likelihood that he would be indicted. That's not good. As an initial matter, Mr. Memo and Massachusetts State Police Detective Lieutenant Brian Tully didn't mince words, making it clear to the grand jury that they expected an indictment. Both expressly stated their belief that Mr. Kearney intimidated witnesses. It's the affidavit of Mark Bederow, which we're going to read after this. That's the 88-pager. December 19th, 2023 transcript. And December 20th, 2023 transcript. So those would be the grand jury transcripts. Without more, Mr. Mello's and Tully's blatant attempt to improperly influence the grand jury impaired the integrity of the grand jury proceeding by exploiting their prominent status as a, quote, special prosecutor here on a special case, footnote 1, and the lead investigator, dun, dun, dun. Footnote 1 says, Mr. Mello informed the grand jury that he was appointed by the Norfolk County District Attorney as a special prosecutor and that he, quote, came up here on a special case, end quote, and then emphasized the high profile nature of cases involving Karen Reed, Aidan Kearney, Turtleboy. And that is from the November 28th, 2023 transcript, page 3. Now, I want you to take special note of the dates of these grand juries, okay? We've got November 28th, December 19th, and December 20th. Remember, the subpoena that Lindsey Gaetani was served, the grand jury subpoena, we know from other papers that we've read recently that this grand jury returned an indictment. I don't remember the exact day, December 20th, December 22nd, maybe he'll see in these papers, or he'll say in the papers. But when Lindsey Gaetani was allegedly served with this fake, in my opinion, grand jury subpoena on December 22nd, it was for her to appear in front of a grand jury on something such as like December 27th or 29th. But take note that Aidan Kearney's grand jury was already done. It had concluded. The crimes for which he allegedly was accused of committing against Lindsey Gaetani on December 23rd or 24th had not occurred yet when she was served with that grand jury subpoena. And that's a major problem. I don't know if he brings that up in here, but I can't wait to see. November 28th, 2023 transcript, see Commonwealth v. Williams, improper for prosecutor to place full force of his office behind witnesses' credibility by providing unsworn testimony. Mr. Mello bolstered his and Tully's improper opinions of Mr. Kearney's guilt by intentionally and repeatedly eliciting false and misleading testimony from Tully. 28 separate times, Mr. Mello and Tully misled the grand jury by giving it the false impression that Mr. Kearney's video episodes were admissions of his alleged witness intimidation. And then there's a whole chart in the attached affidavit, which is going to tell us the titles that Mello and Tully said Aidan's YouTube presentations were called and what the actual titles were. Specifically, Mr. Mello elicited patently false testimony from Tully, which inaccurately suggested to the grand jury that Mr. Kearney's innocuously named hours-long episodes in which he discussed numerous topics unrelated to his interactions with witnesses in the Karen Reed case were little more than brief statements about his interactions and or commentary about the witnesses, which he named in a manner evincing his intent to intimidate witnesses. Mr. Mello and Tully knew prior to the grand jury proceeding that none of this was true. Oh, you got some explaining to do. What the grand jury didn't know was that the exhibits introduced by Mr. Mello and described by Tully as Mr. Kearney's episodes were, in fact, edits of Mr. Kearney's actual episodes created by Tully at the behest of Catherine Peter, an enemy of Mr. Kearney, whose atrocious credibility included at least 2 instances in 2020 and 2023 where she literally manufactured and forged evidence to harm him. Oh. There it is. For those of you who don't know who Catherine Peter is, aka Kate Peter, aka KP, aka Mafia Masshole on social media, including YouTube, Twitter, and yes, I'm always going to call it Twitter because I just can't get on board with the name change. I don't know what other socials she has, but if you don't know the lore, she worked for Aidan Kearney many years ago. He says that he fired her because she was stealing money or something such as like that. And since then, she has made it her life's mission to try to destroy him. And in an effort to get his YouTube channel stricken, she submitted falsified federal court documents to YouTube as purported proof that she was suing him, when what she really did was take someone else's lawsuit and then just do a scratch and sniff on the names and dates. But she forgot to change the index number, which went back to like 2013 or something. I don't remember. But she falsified documents, submitted them to YouTube, and I think succeeded in having his channel stricken. But I can't remember all the details. So isn't submitting false federal documents kind of a crime? Well, she submitted them to YouTube, though. She didn't submit them to a court. So I don't know. Okay. Okay. I'm just gonna say it again. You can say I'm being mean or not. I don't. I am the only one who has access to my email. My mods don't. If you're blocked, I'm not going to drop what I'm doing in the middle of the stream to look at your emails. I will look at them later when I'm done here. Okay. Thank you very much. Following Ms. Peters' guidance, Tully clipped what she flagged as relevant portions of Mr. Kearney's episodes. So wait, so Kate Peter is guiding Tully, not the other way around? Following Ms. Peters' guidance, Tully clipped what she flagged as relevant portions of Mr. Kearney's episodes, renamed his edits so they sounded as if Mr. Kearney created them to emphasize his intent to intimidate witnesses, his purported intent, and placed most of them in an intent folder he created. He had a whole intent folder. In other words, Tully created a folder containing edited clips of what Ms. Peter believed constituted evidence of Mr. Kearney's intent to intimidate witnesses. Oops, there it is. These edited and nefariously renamed videos depicting Ms. Peters and Tully's biased opinions were the exhibits presented to the grand jury ostensibly as Mr. Kearney's episodes and as proof of his intent to intimidate witnesses. Before Tully described this misleading evidence to the grand jury, Mr. Memo and Tully twice expressed their opinion that Mr. Kearney intended to intimidate witnesses. How do they know that? Because they have the transcripts. And the transcripts of grand jury proceedings are required to be turned over as automatic discovery from the prosecutor. I don't know how long it took them to get these grand jury transcripts. He made a folder named intent. I mean, you can't even make that up. Says nothing nefarious here. Good luck with your roots, Vanessa. Good luck with your roots. But you know, Vanessa, you can wear earbuds while you're getting your roots colored. You don't have to leave the show. You can, I mean, I go in the supermarket with my earbuds in. I go everywhere with my earbuds in. I'm always listening. Without telling the grand jury that he created and named the intent folder with Miss Peters' input, Tully misleadingly informed the grand jury 14 separate times that these videos were maintained in a folder of Mr. Kearney's episodes named intent. Mr. Memo exploited DL Tully's crafty testimony by purposefully not introducing Mr. Kearney's actual episodes into evidence, which further misled the grand jury by concealing the complete substance and context of Mr. Kearney's statements, the admission of which would have diluted the impact and exposed the falsity of Tully's testimony, in addition to providing the grand jury with the accurate context of Mr. Kearney's statements and intent, which would have been favorable to him. Memo further bolstered his and Tully's misconduct at the conclusion of the grand jury proceeding by marshaling already admitted and distorted evidence. First, Memo again informed the grand jury that he and Tully believed that Mr. Kearney intimidated witnesses. Yeah, you're not supposed to do that. You're not supposed to do that. Here's Melisa. What? She says, I wrote one last night. 'Twas the night of the mega when all through the town, all the villains were screaming, please don't unimpound. Then I had a dirty verse about KP I'm too embarrassed to share. Thanks, Emily. That's so funny. Great minds, right? Emily C is amazing. If you don't, and 80% of my audience says they're not on Twitter, but if you are, follow Emily C SEE on Twitter. And also she has a YouTube channel now, and I think she should start posting some more YouTube content. And also she's on TikTok, I think. And also she did a thing the other day of Bradel and the crazy judge on the Kelsey Fitzsimmons thing, right? That was awesome, Emily. I saw that. Justice is not free. Thanks for your super chat. He then instructed Tully to replay 3 of the most prejudicial and misleading videos that Tully edited from Mr. Kearney's actual episodes, and again told the grand jury these exhibits came from the intent folder. December 20th, 2023 transcript. Memo ended his presentation of evidence by having Tully play and describe an irrelevant video of Kearney discussing his disappointment with the O'Keefe family. Well, that's interesting because Kearney is not accused of intimidating anybody in the O'Keefe family. So talk about, I mean, wow. Just like Mr. Memo's presentation of the alleged wiretapping evidence, which will be discussed on page 12 to 15, this edited evidence was nothing more than an uncharged bad act, as there were no allegations before the grand jury regarding the alleged witness intimidation of any member of the O'Keefe family. Turtleboy bad. Look what he said about the O'Keefes. He's disappointed in them. Therefore, he must be guilty of all these other things. This prejudicial evidence clearly was introduced to make Mr. Kearney look bad and to generate sympathy for Mr. O'Keefe and his family shortly before the grand jury began its deliberations. Lest there be any doubt that Mr. Memo expected the grand jury to return a true bill, immediately before he formally sought Mr. Kearney's indictment, Mr. Memo again testified as an unsworn witness. What? Oh, testified in quotes as if his commentary is testimony. Yeah. Okay. Mr. Memo again testified as an unsworn witness, unequivocally instructing the grand jury that, quote, we believe that evidence has been presented to you that would allow you to make the determination that Mr. Kearney intended to intimidate witnesses. In these circumstances, Mr. Memo's pervasive introduction of false and misleading evidence, which he bolstered with his own improper and unsworn opinion, wasn't made in good faith or otherwise accidental. Mr. Memo's conduct was antithetical to his obligation to act as the legal advisor to the grand jury with a duty of fair dealing to Mr. Kearney. Mr. Memo abandoned this duty in furtherance of his specific aim to mislead the grand jury in furtherance of seeking an indictment. Does anybody know if Memo was ever a prosecutor, or was he a judge? Was he in private practice? Has he ever conducted? Was this his first grand jury ever that he was in charge of conducting? I have questions. Questions. Before the grand jury, and that citing Commonwealth v. Walzak, he was a defense attorney. Okay. Scott McGinnis says, no, just a terrible private practice lawyer. Well, ignorance of the procedure and the law is really no excuse for Memo. Like, you have an obligation of fair dealing when you're a prosecutor conducting a grand jury because there's no judge and the other side is not present or able to participate, right? Aidan said, not a prosecutor. Thank you, Scott McGinnis. Oh, Mrs. Sarcasm. Turtleboy said it was his first grand jury. Okay, good. All right. Bo, Adam Lally resignation says private practice was sued by previous clients and was often neglectful in representing his clients. Oh, right, because I did see a hyperlink to that in the other papers. Commonwealth v. Walzak says before the grand jury, the prosecutor has the dual role of pressing for an indictment and being the grand jury's advisor. In the case of conflict, the latter duty must take precedence. Okay, so it's more important to be an advisor than it is to press for an indictment. But as we've said in all of these cases, Karen Reed, Aidan Kearney, they're not looking for justice. They're not looking for the truth. They're looking for a conviction. And they're going to stop at nothing to get it because they just want to shut people up and or protect other people who may be more powerful and have more to lose, right? There is irrefutable evidence that Mr. Memo and Tully knew that they repeatedly misled the jury by concealing their collaboration with Ms. Peter before Tully sliced and diced Mr. Kearney's episodes into out-of-context exhibits to support their view of his intent. For months before the grand jury proceeding commenced, they were familiar with the actual names, length, and content of Mr. Kearney's episodes. Mr. Memo justified his discounted invoice by explaining that he spent, and discounted is in quotes, hundreds of hours reviewing 8 months of Mr. Kearney's online content. Oh my God. Could he also be in trouble for fake billing, for fraudulent billing? Hundreds of hours reviewing 8 months of Kearney's you can't have it both ways. You can't use it as a shield and a sword. You can't say, I didn't know the real titles because I had someone else do the research and that's how they titled them, and then bill for hundreds of hours reviewing 8 months of content. You can't pick. Wow. He didn't slice and dice anything. There's a user in the chat, usually it's called like Babalessi's Slice and Dice, and that's an amazing name too, because you guys are having like a contest for who can have the best username, and you're all winning. I have Charlie Sheen on the brain because I watched the documentary. Winning. Tully accurately describes some of Mr. Kearney's episodes in the charging documents he signed and filed in court. That's right. Remember the probable cause affidavit, and it had some of the actual titles. But don't worry, because if you don't remember, there's hyperlinks right here. Nevertheless, Mr. Memo and Tully relied upon Ms. Peters' guidance to assemble evidence for the grand jury. Is that why she was getting paid, allegedly, or why she told somebody that she was getting paid $1,500 a month? For no discernible purpose other than to mislead the grand jury, Tully edited and renamed these episodes and then misleadingly told the grand jury they came from a folder of Mr. Kearney's episodes named Intent. This is bad. This is bad, you guys. This is bad. And, it begs the question, how many other people have they done this to? I mean, Dave Matthews' neighbor also, my personal favorite username. What name could only be appropriate but the one and only? Yes, you are Dave Matthews' neighbor, and you really are Dave Matthews' neighbor. And you're very lucky. No, did you know that I went to Cancun with Alan Jackson to see Dave Matthews? That's another thing they did to me when this whole thing was going on about the Haley Walbrecht thing. Grant Smith Ellis chased down Alan Jackson. Here's the lore. I'll tell you the lore. I have merch. Hi, Olivia. Olivia's here. We love Olivia. Congratulate Olivia on her amazing hyperlinks, everyone, and her redactions. When they were thinking that I was Haley Walbrecht and releasing all this private information about Lindsey and Common for Me, Grant specifically, I said we were covering one of the pretrial hearings of Karen Reed, and Alan Jackson had on this cool bracelet. It was like a rope bracelet with like a silver like disc on it. And I said, oh, check out his bracelet. That's so cool. It looks like one that I just got when I went to see Dave Matthews in Mexico. I don't even know if he likes Dave Matthews. He didn't know who I was at that point at all. And so they started a rumor, the Twidiots, that I was in Cancun with Alan Jackson. And it got some legs and it grew. And then there's video of it. I have it somewhere. I don't know where exactly it is. If anybody has like a link to that video. Grant Smith Ellis was outside the courthouse with his cell phone as a microphone or whatever. And the team is heading into court and he chases Alan Jackson down, chases him down. And he goes, Alan Jackson, did you have fun in Cancun with Melanie Little? Or Mexico? Maybe he just said Mexico. He didn't even know it was Cancun. And then shoves his phone in front of his face. And I don't even remember if Alan Jackson like looked at him or whatever. And then they keep walking and he chases him up the stairs again. And then repeats the same question, yelling at him and shoving the mic in his face. It was hilarious. I have merch that says I went to Cancun with attorney Melanie Little because not only did I do some live streaming when I was in Cancun last winter for you guys who love Dave Matthews to enjoy the concert a little bit with me, but also, yeah, my name also happens to be the same as Eliza, right? But there's no relation to me and Eliza. And that's crazy. And so I'm thinking, yeah, they said it was Alan Jackson with me that we went together. Yeah, I don't know if there was a photo of him with the bracelet at a beach party. I don't know. It was wild. I don't remember like exactly all the details because I kind of forgot. But he was spreading the rumor that I was having an affair with Alan Jackson. Now, listen, there are certain categories of defamation that are defamation per se. And one of the categories is if you accuse someone of like unchastity or something, like of having an affair. And so of all the questions he could have asked, he had one of the greatest trial lawyers of our time in front of him, and that is what he chose to ask him. It was wild. It was wild, but it really happened. Many of you may remember, but that's the lore. Hold on, I'm getting patched. Yes. Oh, that's right. That's right. Dave Matthews' neighbor says, so wait, the first affair that was caught at a concert was me and Alan Jackson, not the one we just saw. Yeah, not that poor guy at Coldplay and that woman. And by the way, if those two just acted normal when they were caught on the Jumbotron, that video never would have went anywhere. Like it was the fact, their reaction to it is what made it go viral. Right? Crazy. Bay State says, will Mello and Cosgrove know how to open the hyperlinks? No, no way. No way. Thank you, Mitchell. You didn't know. Cancun lore, A+. A+. And to Dave Matthews' neighbor and all of my friends who do love Dave Matthews, they're coming back. They're coming back to Cancun. They do it every year. It's 3 concerts on the beach in Cancun at a resort. It's amazing. I highly recommend that you go. I would highly recommend. I'm sure the package is still available. This year, it's in January. Sometimes it's on a holiday weekend, sometimes not. And this year it's January. It's the weekend of January 23rd. And so highly recommend. Like it's a bucket list item. All drink and food included. The food is really good at this resort. The resort is really good. Nobody, if you're not at the resort, you can't go. Gabagool, gabagool, gabagool. That is great. Gabagool. Cupcakes Take Cancun 2025. I'll be there if you guys want to come hang out. Let's do it. All right. Moving on. There was no legitimate reason for Tully to edit and rename Mr. Kearney's episodes or for Mello to conceal from the grand jury the full context and substance of Mr. Kearney's statements unless they intended to keep the grand jury ignorant of circumstances which undermine the credibility of evidence that is likely to have affected their decision to indict. Citing some cases and what they stand for. And Bederow is on point. I'm not going to read every single word of this because, again, it's 36 pages. But you can come back and read it at your leisure if you'd like to know about these other cases. The circumstances here are worse than in Blakeney, where a few weeks ago, that's the most recent case from August 25, the court dismissed an indictment for multiple rapes of a child under the age of 14 because the prosecution misled the grand jury about the full context of the defendant's statements. There, the prosecutor admitted a portion of the defendant's statement and introduced into evidence a flash drive containing a copy of the defendant's entire statement. The prosecutor didn't play the full recording before the grand jury, but the flash drive was available for the grand jury during its deliberations. The court dismissed the indictments, holding that the prosecutor intentionally misled the grand jury by attempting to conceal the full context of the defendant's statement by hiding it in plain sight. Well, that's interesting. And that is a case that is directly on point because there, the grand jury was actually given the whole story, but it was not played for them. They had to, the onus was on them to play it backstage and during their deliberations. Here, totally different. They played little snippets, titled these YouTube presentations in a very derogatory manner, or things, titles that infer intent. And it's worse, in my opinion, than this very recent case. And also, rape of a child under 14 is also a much more heinous crime than alleged hurting the feelings of a couple of people who may or may not be involved in the murder of John O'Keefe, by the way, since Karen Reed was, acquitted and all. Mr. Mello's conduct was far more egregious than the deception that required dismissal of the indictment in Bleakney. Mr. Mello and Tully didn't just hide the ball like the prosecutor in Bleakney. They distorted the actual evidence and then destroyed the ball. See? I knew what he was going to say. I didn't even read this yet. Mr. Mello introduced only cherry-picked out-of-context statements from edits of Mr. Kearney's actual episodes, which ensured it was impossible for the grand jury to consider the accurate context of Mr. Kearney's full statements and his episodes, even if it desired to do so. Mr. Mello and Tully's subterfuge tricked the grand jury into believing that the statements Tully edited from Mr. Kearney's episodes with Miss Peters' assistance provided the full context of Kearney's statements, such that it even appeared Kearney used the context of Tully's edited clips to name his episodes before he filed them in a folder named Intent, when they knew the exact opposite was true. It'd be interesting to hear from some of the grand jurors who sat on this case. I don't know if they're allowed to talk about their grand jury experience after it's over, like a regular trial jury is. Short of literally instructing the grand jury that as a matter of law, it must find that Mr. Kearney intended to intimidate witnesses, a line Mr. Mello approached with the unsworn testimony, it is hard to fathom a more compelling example of how a prosecutor's misconduct impaired the integrity of a grand jury proceeding on the critical issue for the grand jury determinations than Mr. Mello did regarding Mr. Kearney's alleged intent to intimidate witnesses. But Mr. Mello engaged in additional misconduct to make sure he secured Mr. Kearney's indictment for witness intimidation. He dedicated the entire first day of the grand jury proceedings to a topic that had nothing to do with alleged witness intimidation, smearing Mr. Kearney with irrelevant and prejudicial allegations of uncharged bad acts. Mr. Mello examined 3 witnesses, introduced an unauthenticated and unreliable recording provided to Tully by Kate Peter, and bolstered Stephen Scanlon's irrelevant testimony by having Sergeant Yuri Buchanan regurgitate Mr. Scanlon's testimony by reading into evidence the full contents of his hearsay interview with him, all for the purpose of making the grand jury aware of an uncharged wiretapping allegation against Mr. Kearney. Wow. Wow. Just wow. Prejudicial much? You just can't make it up. You just can't. You just can't. So when Aidan Kearney's indictments against all of these alleged victims are dismissed, are they going to go after Mello, these people? By going so far outside the bounds. Yeah, that's what I thought. In Massachusetts, whet my appetite. You're not allowed to speak even after being dismissed from a grand jury. So they're sworn to secrecy forever. Forever and ever and ever. Forever and ever and ever. I thought maybe Massachusetts had some weird rule. They got a lot of weird rules. Like, in Massachusetts, you're allowed to, because that would be, typical for Massachusetts. Catherine says Mello should be disbarred. Involved. Period. This is out of a movie, mob movie. Pure Duckery says, how dumb can these clowns be? Didn't they realize all this would come out? No, they didn't. They didn't think it would, because you know what? They've been doing the same stuff for decades. Decades. In that specific county and others in Massachusetts. And my Massachusetts residents of a certain age who have lived in Massachusetts for decades will tell you that. And they've been doing it for decades. They've never been caught before. And why would they think they were going to get caught now? They thought the girl was going to take a plea. Pin it on the girl. Let her take a plea. Maybe they thought Kearney was going to take a plea too. Maybe they thought Karen Reed was going to be convicted of second-degree murder. And that would strengthen Aidan Kearney's charges, because that would make the things that he said about these people or accuse them of doing untrue. But now that she's been acquitted, interesting, right? DK says what I was thinking. I could never be a grand juror. I can't keep a secret forever. I can't keep a secret for 10 minutes. Like, I buy presents for my kids or I buy something for somebody and I get so excited that I just have to tell them, because I'm bursting with excitement. Jason says, I don't think they care. Most of them have immunity and plausible deniability. Oops, sorry, it's disgusting. Yeah, but if there's criminal acts, they don't have immunity from that, right? Rather than conform his conduct, let me just highlight this here. Rather than conform his conduct to what was required from the legal advisor to the grand jury, Mr. Mello was so out of control that he instructed Tully to read the full text of the wiretapping statute into evidence, including the portion which states that a violation is punishable by up to 5 years imprisonment, presumably to make sure that the grand jury was acutely aware of the seriousness of the uncharged wiretapping allegation. Mr. Mello himself read the definition of wiretapping to the grand jury at the conclusion of his presentation of this uncharged evidence. We're only on page 13, and I don't see how the judge can let these indictments stand. And we're only at page 13, and we haven't even read the affidavit yet. So let's keep going. Standing alone, Mr. Mello's obvious intent to smear Mr. Kearney through the introduction of uncharged bad acts was flagrant misconduct that impaired the integrity of the grand jury proceeding and compels dismissal. There's no reasonable view of Mr. Mello's presentation of the uncharged wiretapping evidence that enables the court to conclude that its admission was inadvertent. See Commonwealth v. Jenks Brown Freeman. Quite the contrary, Mr. Mello's intent to prejudice Mr. Kearney with uncharged bad act evidence couldn't have been any clearer. Mr. Mello spent an entire day on this irrelevant issue. He called 3 witnesses, including the civilian who allegedly was wiretapped. He bolstered that witness's testimony with rank hearsay from his interview with the MSP. Who is he accused of wiretapping? Lindsey? But I thought the wiretapping allegations were not until like late December, which would have been after this grand jury. Scanlon. Okay. Scanlon. Gotcha. Okay. See how many NPCs there are in this story? It's hard to keep them all straight. Okay, so they had Scanlon testify at this grand jury too? Stephanie Sweedler says, Scanlon, Kate Peter clipped off 1 minute and 9 seconds at the beginning of the interview where Aidan says, I am recording you. Of course. Of course. But he also didn't she also allegedly do that with the Lindsey Gaetani recording? Because his version of the recording says, I'm recording this, right? And then she's, flailing and screaming. And I think that also was edited. He bolstered that witness's testimony with rank hearsay from his interview with the MSP. He introduced unreliable electronic evidence in support of the allegation. He didn't provide any instructions to the grand jury explaining the purported relevance of the evidence. He didn't caution the grand jury about how to consider the evidence and its limitations. He didn't instruct the grand jury to disregard the uncharged evidence when considering the charges against Mr. Kearney. The only instructions he provided on the uncharged evidence were having the text of the wiretapping statute read to the grand jury twice, one of which involved him purposefully alerting the grand jury about the prison sentence associated with a violation of the uncharged crime. This is so outside the bounds of what is proper that there are not even any words to explain to you how out of bounds this is, because I'm trying to think of an example. It's like, okay, let's say we're trying to indict someone for, I don't know, let's say we're trying to indict someone for illegal possession of a kilo of cocaine with intent to distribute. Let's say that's what we're trying to indict a person on. That's like on the first day of the grand jury, calling in a witness who says that she was graped by this guy. Say it's a guy. And telling her story about having been graped by this guy, completely unrelated to the charges involving the possession and with intent to distribute, and then reading the grape statute and saying how much time the person could spend in jail for grape, but then there's no charges involving the grape. Do you see how prejudicial that is? Well, if he graped her, then he must be guilty of possessing the drugs. I mean, it's just insane. There is never a judge in a grand jury hearing. No. That's how out of bounds this is. At bottom, there's no reasonable explanation for why Mr. Memo introduced all of this uncharged bad act evidence without any cautionary instructions, but did not seek an indictment for wiretapping other than he meant to influence the grand jury by prejudicing Mr. Kearney with an uncharged and irrelevant bad act so that the grand jury would have a negative opinion of Mr. Kearney while it considered whether to indict him for unrelated acts of witness intimidation. Footnote number 2. At a minimum, Mr. Memo should be compelled to explain under oath why this court shouldn't conclude that his pervasive misconduct was intentional and for the purpose of seeking Mr. Kearney's indictment. Just another snark in the tank. Well done. In high school, Kate Peter was voted most likely to need a shovel to clean her cutting room floor. Well done. Got milk for me. I'm going to star that for later. Oh, and you guys both said that in a row. It's a federal crime to knowingly mislead a grand jury. Oh, that's the problem. Given these irrefutable facts, Mr. Memo's brazen introduction of uncharged bad acts impaired the integrity of the grand jury proceeding, substantially prejudiced Mr. Kearney, and considered alone or cumulatively with his other prejudicial misconduct, requires dismissal of the indictments. C. Letter C. The cumulative prejudice caused Mr. Kearney requires dismissal. Put simply, Mr. Memo, who vouched for his own credibility by telling the grand jury that he was designated to present a, quote, special case, made such a mockery of his responsibility as the legal advisor to the grand jury with his pervasive misconduct that the entire proceeding was a sham. I love how Bederow does not mince words. Sham proceeding. Accordingly, the indictments must be dismissed because the cumulative impact of Mr. Mello's impairment of the integrity of the grand jury proceeding, quote, probably introduced the grand jury's decision to indict Mr. Kearney, because that's all that's required is probably under these cases, Brown and Mayfield. As noted above, Mr. Mello intentionally admitted the prejudicial evidence for the purpose of gaining Mr. Kearney's indictment, and at no time did he attempt to mitigate the prejudice he caused by even providing a single cautionary instruction. See Brown, Rakes, Jenks, Freeman. If anything, Mr. Mello's instructions, in quotes, to the grand jury, you can tell when Bederow is being snarky and or sarcastic is when he puts things in quotes. Unless it's case law being directly quoted. If anything, Mr. Mello's instructions to the grand jury did the exact opposite and caused more prejudice, as did his bolstering of his misconduct with improper, quote, evidence that he, Tully, and other witnesses believed Mr. Kearney's intent was to intimidate witnesses. I mean, it seems so basic that I shouldn't even have to say it, but as a prosecutor, you're not supposed to get in there and tell the grand jury your opinion of whether the person's guilty or not, or your opinion of their intent and state it as fact. You're not supposed to do that. It's exactly what a district attorney or an ADA or a prosecutor should not do. But then again, if the head MF in charge is a guy like Marcy, who went out and released that hostage video in August of 2023 about Quallen was never in the house and this needs to stop. That hostage video, as I called it, because it looked like he was reading a script and somebody was off camera holding a gun to his head while he did. That video is being used in law schools to teach law students how not to be a district attorney. It is. And I remember David Yannetti saying that in open court. The prejudice caused by the cumulative impact of Mello's impairment of the integrity of the grand jury proceedings easily satisfied the, quote, probably influenced the grand jury standard. It's hard to comprehend how the grand jury couldn't have been improperly influenced by Mr. Mello and Tully's and Ms. Peters' opinions of Mr. Kearney's intent, which was bolstered and marshaled by D.L. Tully's false and misleading testimony regarding evidence from an intent folder, which grossly distorted the evidence of the names, length, content, and context of statements purportedly indicative of Mr. Kearney's criminal intent. Combined with the shocking amount of uncharged bad act evidence, there's 7,474 people in the chat right now, which means, you know what I'll do? I got to get the numbers book. I got to get the numbers book and look up 74 because it's there twice, 74. Everyone smash the like button. Thank you. Combined with the shocking amount of uncharged bad act evidence introduced against Mr. Kearney at the beginning and end of the presentation, there can be little doubt that the Commonwealth's intentional or reckless misconduct impaired the integrity of the grand jury proceeding to the extent that it probably influenced the grand jury's decision to indict. Probably influenced, that's the standard. Point Roman 2. The indictments should be dismissed due to the Commonwealth's failure to properly disclose specifically requested exculpatory and automatically discoverable evidence. I think there's probably still some automatic discovery they still haven't turned over. Hold, please. A, the applicable law. It is axiomatic that due process entitles a criminal defendant to disclosure of all favorable or exculpatory evidence in the possession, custody, or control of the prosecution under Brady v. Maryland from 1963. That's how long Brady's been around. This includes impeachment evidence, or other evidence that may impair the credibility of a prosecution witness, citing Giglio, which goes all the way back to 1972. Both U.S. Supreme Court cases, both seminal cases in this area, and something that every first-year law student, two cases that every first-year law student learns about in constitutional law. An individual prosecutor has a duty to learn of any favorable evidence known to the prosecution as a whole, including the police. Thus, the prosecution is obligated to disclose any exculpatory evidence in the possession, custody, or control of the police and/or prosecutor's office, even if any individual prosecutor may be unaware of its existence. The prosecution has an affirmative obligation to disclose exculpatory evidence, irrespective of whether it is alerted to its existence by the defense. However, courts are less forgiving to the prosecution when it fails to disclose exculpatory evidence in response to a specific defense request for Brady material. When a prosecutor is uncertain whether evidence may or may not be favorable to the defense, the prosecutor must err on the side of caution and disclose it. The prosecution's duty of inquiry and subsequent failure to disclose evidence is based on an objective standard. Citing McFarland, which is one of Judge Cannoni's favorite cases because she would cite it all the time, McFarland and Graham, and Commonwealth v. Diaz. In addition to its constitutional obligation to disclose evidence favorable to the defense, the Commonwealth is required under Rule 14 of the Massachusetts Rules of Criminal Procedure to automatically disclose to the defense in a timely manner certain evidence in its possession, custody, or control. And remember, Rule 14 was amended after Karen Reed's first persecution. The committee was spearheaded by none other than Judge Beverly Cannoni. And so Bederow says, prior to March of 2025, this obligation included mandatory disclosure of any written or recorded statements made by the defendant, any facts of an exculpatory nature, material and relevant police reports, and statements of persons the party intends to call as witnesses. In March of 2025, Rule 14 was amended to expand the prosecution's obligation to disclose any evidence in the possession, custody, or control of the prosecution team, which includes persons who have investigated the case or evaluated it and reported to the prosecution. The amended rule also mandates disclosure of any written or recorded statements of persons the prosecutor may call as a witness, and any notes of interviews of these witnesses and all relevant video and audio recordings. The new rule explicitly defines favorable evidence to include information that establishes a defense theory, corroborates the defense version of facts, calls into question the prosecution's version of facts, and regarding a possible prosecution witness, any information reflecting bias or prejudice against the defendant. A court has the inherent power to issue sanctions, including up to dismissal of the indictments, if the prosecution fails to comply with its obligation to provide timely discovery to the defense. Dismissal is appropriate where A, the defendant is prejudiced by the non-disclosure of evidence to the extent he has suffered irremediable harm, or B, the prosecutorial misconduct is so egregious, deliberate, and intentional that it gives rise to the presumption of prejudice. You may recall a case out of New Mexico. This is my favorite case to talk about when we talk about failing to turn over evidence and whether or not a district attorney is allowed to decide what they think is relevant and what they think is turned over. And that was the case of Alec Baldwin. in the shooting case involving the filming of the movie Rust. The judge in New Mexico, what was her name? Mary Marlowe Summer. Was she the New Mexico judge for Alec Baldwin? During that case, there was also a special prosecutor involved. Special prosecutor's name was, coincidentally, Morrissey, Carrie Morrissey. It came out in the middle of the trial that Carrie Morrissey had received some evidence by somebody who came down to the DA's office at the police station and turned in some ammunition that may or may not have been similar to the ammunition used in this case and whatever. Carrie Morrissey took the evidence and just put it in a file under a different case number, not the Alec Baldwin case number, a different case number. She decided it wasn't relevant and she didn't turn it over. Well, all this came out like in the middle of trial and it was wild. And Carrie Morrissey put herself on the stand. And I was like, oh, girl, don't do that. Don't do that, girl. Like, you're going to get yourself self-disbarred. What are you doing? And Mary Marlowe Summer had had enough, the judge. And she right away, after this special prosecutor put herself on the stand and started asking herself questions and talking about why it wasn't her fault, Mary Marlowe Summer said, Mr. Baldwin, your case is dismissed. You are free to go. And that's the way that these cases are supposed to be fairly adjudicated. And I think, and I didn't follow the Rust case closely enough, but I did watch that day and that was wild. But I think that there had been some other, questionable failure to turn over discovery materials and stuff. But in this case, it was specifically because that special prosecutor determined that in her view, it wasn't exculpatory and she wasn't required to turn it over. And the judge is like, yeah, no, that's not how it goes, girl. Not up to you to decide. Whether or not it's admissible is a separate issue. But whether or not you turn it over, you got to err on the side of caution. Moving on. The Commonwealth's, this is B, the Commonwealth's failure to disclose evidence. Since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligations to disclose evidence to the defense. I mean, have you seen the baby? You got to see the baby. You got to see the baby. The baby's breathtaking. Elaine gets all mad because the doctor called her breathtaking too, and the baby was not breathtaking. The baby was ugly. If you know, you know. And I'm sure that Bederow knows. When we see breathtaking indifference, it has a whole new meaning. This has included Mr. Mello's patently false representations about the state of discoverable evidence and his failure to comply with a court order to complete discovery by May 8th of 2024, which is consistent with his extensive history of being disciplined for neglecting his professional obligations. And if you click on this hyperlink and you're not in a PDF, it will take you to, I guess, a decision in which he was maybe admonished by the Bar Association or the BBO, whatever they call it in Massachusetts, because maybe he's got a history of it, an extensive history of being disciplined. May have been a disciplinary proceeding against Memo. 18 months after the court-ordered deadline, the Commonwealth still hasn't satisfied its Brady and Rule 14 obligations, even though since 2023, numerous of its agents have had actual possession of undisclosed, favorable, and discoverable evidence, including, but not limited to, Robert Cosgrove, Mr. Mello, D.L. Tully, Sergeant Buchanan, Lieutenant John Fanning, other members of the MSP, and ADA Adam Lally. Oh, I can't wait to read and see what Lally had or knew and didn't turn over. Irrespective of whether Rule 14 required disclosure of any of this evidence before March 1 of 2025, any evidence in the Commonwealth's possession, custody, or control, which was favorable to Mr. Kearney substantively or with respect to undermining the credibility of Ms. Peter, other witnesses, or the prosecution's case against him, was required to be disclosed as a matter of constitutional law as Brady material. Okay? I'm going to repeat this again. I'm going to say it a little loud for people in the back. It must be disclosed. Whether or not it's admissible at trial is a completely separate determination and issue, but it is required under the Constitution that it must be disclosed. And they got a history of not disclosing stuff, as many of you know, not only in the Karen Reed case, but in how many decades before that, in how many other cases. We're looking at Miles King right now, right? Miles King took them 6 years to turn over basic search warrants. Lally was on the stand being questioned about it. When the judge quickly called a close to that hearing, and we didn't get to hear Lally's explanation about why he didn't turn over search warrants that he had for 6.5 years and why it was just being turned over now prior to trial. And Rosemary Scapicio is my new spirit animal, and we love her. But this ain't new. It's not a new problem over there in Norfolk County. And I would submit to you and many other counties in Massachusetts and other states too. It's not just Massachusetts. I'm just calling it Massachusetts now. Maybe we need Massachusetts t-shirts. I don't know. Footnote 3 says evidence related to Ms. Peter. Oh, here we go. Cold read. Evidence related to Ms. Peter and Jennifer McCabe's Facebook Messenger messages required disclosure under the old Rule 14. The Peter-related materials. That's kind of funny. Peter-related materials. Included statements made by Mr. Kearney, statements made by Ms. Peter, which may have included substantive exculpatory evidence and certainly constituted exculpatory evidence given their content and her history of manufacturing evidence and her clear motive to falsely accuse Mr. Kearney of crimes. Ms. McCabe's messages with either Mr. Kearney or others on his behalf, as she alleged, which she provided to the Commonwealth as proof of his witness intimidation, clearly were discoverable. Oh, wow. So Jen McCabe willingly handed over Facebook Messenger messages between her and Aidan or others on his behalf. She willingly turned those over to the Commonwealth. The Commonwealth never disclosed those to Kearney's attorneys. Yeah, that's the problem. Oh, I can't wait to see what those say, but they're probably impounded and we can't read them or under a protective order. Indeed, the U.S. Supreme Court has noted that evidence which tends to support a defense attack on the competence or bias of the investigation is favorable to the defense. In addition to demands for discovery on February 23rd and March 19th, 2024, so 18 months ago, the defense made 3 extraordinarily specific and well-sourced demands for discovery, Brady material and Giglio material, prior to the March 1, 2025 amendment of Rule 14. And I bet that those are the Bederow letters. We have a whole playlist on the Bederow letters. And oh, how we would squeal with delight every time a new one dropped and relish each word of every Bederow letter. The Bederow letters will go down in history. The Commonwealth's response to these demands as of September 12th, the Commonwealth's response to these demands of September 12th, October 8th, and October 17th, 2024, was to shrug its shoulders, even though the demands couldn't have been more specific as to the information being sought, including exculpatory and discoverable material related to Ms. Peter, Tully, Buchanan, and Ms. McCabe. C, the specific demands for exculpatory and discoverable evidence. Notice that this memorandum of law is entirely unredacted. That's why we're reading this first, because first we're going to learn about the law and what the law says. The lore, as they say. Some of those, like Hank Brennan, didn't he say the lore every time he said law? It was lore. What the law is, what has to be shown. And also then in his affidavit, Bederow's affidavit, that's where the proof comes in. And the proof is all the stuff that is redacted. That is still under protective order that the court does not want you and me and the world to know about, but the defense attorneys know about it and Aidan knows about it, but he can't talk about it and they can't talk about it. But it's all evidence of exactly what this memorandum of law is setting forth. On September 12th, 2024, the defense laid bare for the Commonwealth the basis for our contention that Ms. Peter, Lindsey Gaetani, Leah Genduso, Mr. Memo, Tully, and possibly others conspired to have Mr. Kearney's bail revoked by luring him into intimidating Ms. Gaetani after they made her a witness, in quotes, in air quotes, or real quotes is intimidating, and made her a witness in quotes. Let's name them again. Kate Peter, aka Masshole Mafia, aka not so confidential informant, because she told everyone on the internet that she was the confidential informant. Lindsey Gaetani, Leah Genduso, who I believe was another, I don't know, booty call of Aidan Kearney. Let's just say another scorned ex who may or may not have thought she was in a relationship with him. I don't really know the lore of their relationship, and I don't really know. But she also had beef with him. Let's just say beef. Memo, Tully, and possibly others. This conspiracy resulted in the 2024 indictment, Exhibit CCC. As it turns out, Mr. Memo was so personally involved in this plot that the court disqualified Mr. Memo from that matter because it agreed with the defense that he was likely a trial witness. Yes, and that just happened. That just happened. Genduso was fired because of Aidan's reporting, says KVD. I Love Dogs 1970 said Leah Genduso was MSP. Was she MSP? I don't want to spread any misinformation, so she was MSP? Who was selling? And that just happened. Memo was just disqualified because the judge agreed. Is this Judge Krupp? Remind me. There's so many judges here. Is this Krupp who disqualified? Yes. Yes. Judge Krupp disqualified Memo because Krupp is also the attorney who is hearing the issue about Proctor's text messages for Brian Walsh, right? Or is it Doolin? Doolin? Oh, Doolin. We loved. Okay. Okay, good. Thank you. And that, I know I get conflated because Krupp was on this case for a little while, right? It's Doolin. Okay. And Doolin is the one who said, Mr. Bederow, Mr. Bederow. And he's a jovial man. I kind of like him. I like Doolin. I think he gets it. He DQ'd Memo very recently. On October 8th, 2024, in a 15-page demand outlining what the defense knew about the bizarre relationship between Ms. Peter, Mr. Memo, and the MSP, that's one of the Bederow letters, the defense detailed extensive concerns about the Commonwealth's failure to disclose any evidence about Ms. Peter under Brady Giglio and Rule 14. The demand referred to Ms. Peter's direct role in the prosecutions against Mr. Kearney, documented her shocking admissions that she spoke to Mr. Memo on, oh, there is some redaction, sorry. She spoke to Mr. Memo on, and then there's a portion redacted, and another portion redacted, of her contacts with him that she spoke to Mr. Memo, and there's something in quotes that is redacted, and explained why her communications were discoverable and favorable to the defense. So Kate Peter actually told Memo that all of my communications with you are discoverable and they're going to help Aidan. So maybe she said something like, don't turn him over or delete him. Well, I don't know. We got to read between the lines, or we got to read under the black Sharpie here. I'm not sure if Doolin was the one that gave Miles King bond, but because Krupp is hearing that issue now, but right, I think I got sidetracked when I went to say that Miles King, who had been held for many years, was finally released on bail because of the 6-year delay in turning over those search warrants by Lally. And Proctor was the lead investigator also in Miles King's case. Yes, this was in a Bederow letter before. And I have a whole playlist on Aidan's case. I don't even know how many videos are in it right now already. Well over 20. Each Bederow letter got its own show. So you can go to the one from October 8th, 2024, and you will see the show on that specific letter. And I mean, we were blown away by the stuff we were reading. But again, it's been almost a year that Memo has had this information, or Cosgrove, and they've done nothing. And Bederow set it out pretty point blank, and they did nothing. This demand included all evidence and information in whatever form Ms. Peter furnished to the Commonwealth and or MSP involving the investigation or prosecution of Mr. Kearney. It demanded that all of Ms. Peter's communications with the Commonwealth or MSP about Mr. Kearney, as well as any evidence regarding statements she made to the Commonwealth or MSP, including any audio or video recordings. On October 17th of 2024, after acquiring information from a third party, the defense demanded additional evidence regarding our growing discovery of the nature of the working relationship between and among Ms. Peter, Mr. Memo, D.L. Tully, and others associated with the DA or MSP. That was Bederow letter number 2, October 17th, 2024. On March 29th, 2025, the defense sent another specific demand to Mr. Cosgrove, noting that it had been far more than 5 months since the first specific demand, but the Commonwealth still hadn't disclosed any evidence related to Ms. Peter. This demand referenced the recent amendments to Rule 14 and the Commonwealth's obligations in connection with the new rule. Among the information sought was any evidence indicative of Ms. Peter's relationship in the investigation against Mr. Kearney, including evidence of her interactions and communications with the Kearney prosecution team and the Reed prosecution team, which included at least DA Morrissey, ADA Lally, Laura McLaughlin. Oh, well, if you have misophonia, mute yourself or mute me, because I'm going to say it the way I like to say it, which is Laura McLaughlin. And I've been told that that really disturbs people who have misophonia, which is why I now mute when I take a sip of my drink, because it's really debilitating to some people, and I'm sensitive to your needs. Hank Brennan, Mr. Cosgrove, Mr. Memo, any victim advocates, D.L. Tully, Sergeant Buchanan, Lieutenant Fanning, Mr. Proctor, and other members of the DA and MSP. So, to recap, they wanted any and all communications between Kate Peter, the not-so-confidential informant, and all of those people that I just mentioned. Although the Commonwealth externally ignored these specific demands, internally, Messrs. Cosgrove and Memo were acutely aware of the significance of these demands. Oh? I'm like, Nurse Kim, oh? Oh, really? Oh, really now? Oh, by the way, did you guys see that Cardi B has announced her pregnancy? Remember, we were kind of speculating when we watched some of the Cardi B trial that she may be pregnant, and she has just confirmed her pregnancy yesterday. So there's that. People were speculating she was like walking around outside of court, covering her belly and stuff as like that. Hold on a second. Sometimes we call upon Cardi B when we're like, hello. So although the Commonwealth externally ignored these specific demands, internally, Messrs. Cosgrove and Mello were acutely aware of the significance of these demands because on December 16th, 2024, Mr. Mello forwarded some of his email communications with Ms. Peter and Tully to Cosgrove. These emails were entirely favorable to Mr. Kearney because they confirmed that Ms. Peter worked directly with Mr. Mello and Tully. They confirmed that Ms. Peter frequently sought input from Mr. Mello and that he assigned tasks to her, including just 2 days before the grand jury proceeding commenced. Oh, that's a problem. This is the person that you choose to hire, the person who has made it her life's mission to attempt to destroy Aidan Kearney. These are the people that the Commonwealth chooses to get in bed with to do their dirty work. You're assigning tasks to Mafia Masshole, whose name just about says it all, whose chosen name just about says it all? Huh. I don't know. Anybody see anything wrong with that at all? Muzzy says they deserve each other. Jason Smith says she needs a couch. Jackie Zidell says that's crazy. Lynette says, I don't understand. Kate Peters is or was a cop. No, she's not. She's not a cop. Never was. Not in law enforcement. I have no idea what her educational background is. I have no idea what jobs she's ever held outside of working for Aidan Kearney and his quote blog. Perimenopause Princess says it should be so embarrassing for them, and yet it doesn't seem to be. Because they just keep doubling down and down and down and down and down. And now they have the emails to prove it.
Hello.
Hello. Hello, I'm here.
Like, in what world are we living that they would actually hire her to do work for them? And there's emails showing that they knew. You can't make it up. You just can't. I can't wait for the movie. I can't wait for the movie because you really can't script it any better than what it is. I mean, if you tried to script this in Hollywood and you tried to like pitch a pilot to somebody like a network and you scripted this and you would go in there and they would kind of laugh you out. They'd be like, that is like so ridiculous. Nobody's ever going to believe that. It's so far afield. Like, no way. We can't. It's not authentic. It's not believable. And it's real. It's actually real. It's Chinatown, Jake. It's Chinatown, Jake. And look, today your username comes in perfect. It's perfect for today. Letteros by Bederow. Yeah, you're right, Aileen. Aileen says it's all just insane. The movie should be either dark comedy or musical farce. Yeah, I mean, Turtleboy the musical? I like it did pretty well. I mean, AutoDoc 911 says, let's see what Judge Doolin does. If he denies and allows this to continue, it will get real interesting. Yeah. What if he says, okay, let's have an evidentiary hearing and all these people have to get up on the stand and swear to tell the truth, the whole truth and nothing but the truth, so help them God. But we know that they don't care about the truth. Nobody cares about the truth. All they want is a conviction. All they want is to shut up Aidan Kearney and incarcerate anyone who tries to get in their way of continuing the corruption that has been going on for decades, in my opinion. And you can't tell me that Michael Marcy is not aware of his Brady obligations because you remember all the way back when we started going over all of the letters that surfaced from Michael Morrissey to Josh Levy, and how he started ramping up talking about, and him and Lynn Beeland were like tag teaming the letters to the attorney, the AUSA's office. We have Brady obligations. We have Brady obligations. We have to turn over everything. We need to know what you know and what you're investigating, because we have an obligation to turn that over to the Reed defense team. We know about our Brady obligations, and they are like, that is everything to them. He was all about the Brady obligations. He can't even say like, oh, I wasn't aware of my Brady obligations, because those letters belie the fact that if he tries to claim that, it's all there in writing, and we have it, and we've got the receipts, and we've read it. So there's that. They confirmed that Ms. Peter attached private links and discoverable material to Mr. Memo and D.L. Tully that have not been provided to the defense, and now, on information and belief, have been deleted by Ms. Peter. Yes, remember that came out in court in one of the recent hearings, that when the defense team was trying to like click on these links, the information had been removed. Remember? Yet the Commonwealth failed to disclose these favorable communications, which conclusively proved the prominent role Ms. Peter played in the grand jury investigation, until July 7th of 2025, which was more than 6 months after Mr. Memo provided them to Mr. Cosgrove. The emails didn't include access to the links Ms. Peter sent to Mr. Memo and D.L. Tully. The missing link. Well done, Mitchell. Oh, is that true? Cardi B's boyfriend is one of the Patriots? And that's the daddy of her baby? Oh, I didn't even know that. Kristen Pino says, of course I want this thrown out, but I fear this will all stay impounded. The trial would be juicy as hell. Other than sheer indifference to its discovery obligations, the only possible explanation for this inexcusable delay is that the Commonwealth intentionally suppressed this evidence under a strained interpretation of the old Rule 14, and without regard to the fact that they were obligated to promptly disclose these communications under Brady and Giglio, irrespective of its subjective belief in the reliability of the evidence. Well, ask Carrie Morrissey in New Mexico how that worked out for her. In July of 2025, almost 2 years after the Commonwealth knew it had actual possession of favorable and discoverable evidence, which the defense had specifically requested for almost 1 year, the Commonwealth disclosed a modest number of additional materials. But discoverable and favorable evidence remains undisclosed, and in certain cases has been deleted or destroyed. Yeah, or they turn over what they say is between 5,000 and 6,000 pages, and then it turns out that 4,000 of those pages are blank. The Commonwealth's non-disclosure, this is D, the Commonwealth's non-disclosure has prejudiced Mr. Kearney. Given the Commonwealth's pervasive misconduct and inexplicable years-long failure to comply with its constitutional and statutory discovery obligations, dismissal of the indictments is appropriate under both bases articulated in Bridgman. Mr. Kearney's defense has suffered irremediable harm due to the Commonwealth's unjustifiable failure to disclose favorable evidence, which, combined with Ms. Peters' apparent deletion of exculpatory and discoverable evidence in the Commonwealth's actual possession since September and October 2023, has left the defense without an opportunity to acquire important evidence that favors Mr. Kearney's defense. At a minimum, the prosecution knew or should have known in 2023 that much of the still undisclosed and now destroyed evidence was favorable Giglio material, because it undermined Ms. Peters' credibility, demonstrated her bias against Mr. Kearney, and supported the defense's theory that the shoddy, bad faith investigation relied upon a civilian who despised Mr. Kearney and had a documented history of falsifying evidence against him. As a consequence of Ms. Peters' deletion of evidence she provided to the Commonwealth via email, footnote 4, which I'll read in a second, which wouldn't matter if the prosecution had preserved and disclosed it as it should have. It is unknown whether Ms. Peter tampered, edited, or altered any evidence, which, if she did, is favorable to the defense and would be consistent with her track record. Footnote 4 says, there's a redaction in here. The Commonwealth hasn't provided the defense with a single email sent by Tully to Ms. Peter, even though she sent him several messages. Notably, the defense informed Messrs. Memo and Cosgrove on September 12, 2024, that the purportedly complete, in quotes, extraction of Ms. Gaetani's phone provided to the defense was missing Ms. Peter's responses to Ms. Gaetani's messages describing her interactions with Tully and Memo, which inexplicably disappeared from the extraction report on December 14th, 2023, after Ms. Gaetani texted Ms. Peter something that is redacted. Any proof that she provided tampered evidence to the Commonwealth, which is now likely unprovable because of the Commonwealth's complete indifference to its disclosure obligation, is favorable to Mr. Kearney and devastating to the prosecution. I think we can make that inference, yeah. The loss of critical evidence destroyed by Ms. Peter is irremediable, as it is hard to envision what satisfactory penalty the court could impose upon the prosecution for its deliberate failure to disclose specifically requested evidence that would severely discredit Ms. Peter and the investigation itself. It is not known when Ms. Peter destroyed this evidence, what else she may have deleted, and what, if anything, Mr. Memo and Tully know about this. Given her past record of dishonesty, there is no basis to assume that Ms. Peter will tell the truth about this issue. Either way, now appears impossible for the defense to review discoverable evidence that would answer these important questions entirely because of the Commonwealth's failure to disclose exculpatory and discoverable evidence in its actual possession. I just want to point out that I have not yet found in the first 30 pages of this document any misspellings, any grammatical errors, any misplaced punctuation, any misplaced capitalization, and that makes my grammatical snob self very, very, very happy. Consequently, the defense has been deprived of its ability to present a detailed chronological timeline to demonstrate to a jury that a woman with dreadful credibility, who despises Mr. Kearney and has a penchant for falsifying evidence against him, helped orchestrate the criminal case against him with the blessing of the Commonwealth. Is that a work of art? All in one sentence: dreadful credibility, penchant for falsifying evidence, helped orchestrate a criminal case with the blessing of the Commonwealth. In the name of the Father, and the Son, the Holy Traveling Mary. Amen. Citing Dilworth, which says dismissal appropriate where non-disclosure deprived the defense of an opportunity to evaluate and present a specific defense. The fault for the loss of favorable evidence due to the prosecution's inexcusable indifference and intentional misconduct must be assigned to the Commonwealth. The undue delay caused by the Commonwealth's ongoing failure to disclose evidence also has prejudiced Mr. Kearney. In addition to prolonging this case, which has dragged on for 2 years and counting, and requiring the defense to file demand after demand for what should have been disclosed prior to May 8th of 2024. Yes, Lee Hamilton says Mr. Bederow really knows how to turn a phrase, doesn't he? Doesn't he? And Lisa B says, Mr. Bederow is the Shakespeare of legal writing. The Commonwealth's unjustifiable non-disclosure and delay in producing the limited evidence it has is precisely what enabled Ms. Peter to successfully delete discoverable and favorable evidence that otherwise would be in the defense's possession. The Commonwealth's delay in disclosing the limited disclosure they have provided also has prejudiced Mr. Kearney in that it resulted in the defense filing its first motion to dismiss the indictments, while the prosecution kept the defense deliberately ignorant of powerful evidence that would have supported that motion, and instead is included in the instant motion to dismiss the indictments due to the prosecution's impairment of the grand jury proceeding. So he's saying we have to make this motion again because they withheld all the evidence that we are now arguing in this second motion to dismiss the indictments. The need for a second motion due to the prosecution's inactivity has created a further delay and comes at great expense to Mr. Kearney. Yeah, because he pays by the hour. And to be blunt, oh wait, no, if Bederow says he's going to be blunt, I can't wait to see what follows that. And to be blunt, considering all that has happened in the grand jury and with respect to the Commonwealth's failure to satisfactorily comply with Brady and Rule 14, there is no reason to be confident that the defense has received all of the discoverable materials that would further support the second motion to dismiss and the defense generally. The court should also dismiss the indictments by presuming prejudice due to the Commonwealth's above described, quote, egregious, deliberate, and intentional, end quote, misconduct, both in the grand jury proceeding and regarding the proper disclosure of evidence. The court can't ignore the fact that throughout this matter, Mr. Memo and Tully have engaged in pervasive misconduct, which included the intentional presentation of false and misleading testimony to the grand jury. Nor can it be ignored that Mr. Memo violated a court order instructing him to complete discovery by May 8th of 2024. Or that on July 10th of 2024, the Commonwealth assured the court and defense that it recognized its obligations to provide exculpatory evidence. Yet, it took 16 months and too many to count discovery demands for the Commonwealth to sheepishly admit that undisclosed and discoverable evidence in their actual possession was lost or destroyed by Ms. Peter. Cosgrove sheepishly, Bederow, don't tongue twist me, sheepishly admitted that Ms. Peter was to blame for the lost or destroyed evidence. Oops. And they still haven't disclosed all the discovery in their possession, custody, or control. All of this could have been prevented or explained more than a year ago if the prosecution simply honored its, quote, duty of inquiry and investigated, spoke to Tully and others, and complied with its obligation to make themselves aware of discoverable evidence and to disclose it. The Commonwealth's years-long indifference to its constitutional and statutory rights to disclose evidence to Mr. Kearney warrants a finding that its non-disclosure and loss of evidence was egregious, deliberate, and intentional. I mean, I hate to say it, but the best thing for Marcy, Tully, Cosgrove, Lally, all of these people, Kate, Peter, the best case scenario for them is that Doolin dismisses all of these indictments on the papers, because that way none of them has to get up on the stand and swear to tell the truth and technically maybe commit perjury. Maybe some of the stuff that we're going to see that's redacted in the next document will stay sealed or impounded. Maybe, just maybe, at least you're saying there's a chance. Maybe there's a chance. So isn't it ironic, don't you think, that the best thing that could happen to all of these players who could be in some real hot water would be for Doolin to dismiss all the charges against Aidan Kearney on the papers? I wonder if they're praying for it. Accordingly, the court should presume that Mr. Kearney was prejudiced, strive to create a climate adverse to repetition of that misconduct that would not otherwise exist and dismiss the indictments. Or, at a minimum, order an evidentiary hearing to determine whether the Commonwealth and its agents intentionally suppressed or delayed disclosure or caused the loss or destruction of specifically demanded, exculpatory, and discoverable evidence. The Commonwealth's pervasive misconduct before the grand jury and their years-long failure to disclose specifically requested exculpatory and discoverable evidence deserves no judicial approbation. Nor should the court avert its eyes from the fact that the Commonwealth's misconduct and blatant disregard for obvious conflicts of interest have thoroughly discredited the investigation and prosecution of Mr. Kearney. The Commonwealth's misconduct has fueled its misguided obsession to, quote, get Turtleboy. It's misguided obsession to get Turtleboy, in quotes. Get Turtleboy. Get Turtleboy. Turtleboy bad. Get Turtleboy. Get him. Shut him up. Shut him up. Lock him up. Lock him up. It has stained the Norfolk DA's office, Mr. Memo and the MSP, all of whom have been directed and or influenced by civilians upset with the fact that Mr. Kearney's reporting has exposed their alleged involvement in the death of John O'Keefe. The Commonwealth's overzealousness clouded its judgment to the point that it allowed itself to be guided by Ms. Peter, notwithstanding her recent documented history of fabricating evidence to harm Mr. Kearney. Everything about the way the Commonwealth has conducted itself here has contributed to an ongoing crisis that has led the public to lose confidence in Norfolk County law enforcement. You know what I love so much about that sentence? Come with me, if you will, all the way back to the exposure of Michael Morrissey's private email server email to all of the justices and the clerk of the Stoughton District Court. Come with me all the way back there. Don't remember the exact date of this email. But Michael Morrissey from his private email server emailed all of the Stoughton Court judges, Stoughton District Court, and the clerk with a screenshot of a text message from Jen McCabe. And it said something like, one of our citizens has lost confidence in the Stoughton clerk's office or something like that. And I can't have that. It is unacceptable. And it was Jennifer McCabe. And he attached one of her text messages that said something like, and I summarize, I know it's late, but I'm really angry that Chris didn't get it. Yes, because Chris didn't get it, Chibi. You know, you were here. We've all been here. We've seen this film before, and we didn't like the ending. And it took 2 trials to get to the proper ending, at least for Karen Reed. But we've seen this film before because Chris didn't get it. And he was trying to spank the judges in Stoughton and the clerk. Because also, Turtleboy was able to get some of the papers about Chris Albert's restraining order application. And some of those papers were allegedly released by an employee of the court in Stoughton. And that employee was terminated. And this is how stupid they are. Attached to the termination papers for this employee was something, I think, from Aidan Kearney's phone. And they were lying to the court at that time, saying we haven't extracted any of his phones. And yet they attached something that was extracted from one of his phones to fire. Was it Michelle Littlefield? There's so many players in this that it's hard to remember. Or Janelle Webb? I don't remember. Yeah, and also remember that don't forget I'm not testifying unless Turtleboy's in jail. And so there's that. Michelle Littlefield, that's who it was, right? Yeah. And that was the sum and substance. And I think a direct quote from Marcy's emails that this person is losing confidence in the Stoughton District Court clerk. Wow. Good. That was good the way he circled back to that. In these circumstances, the indictments cannot stand and should be dismissed. Conclusion. For the reasons stated herein in the affidavit of Mark Bederow, dated September 17th, 2022. Oops, I think I just found the first typo. That should probably say 7/2025. And its accompanying exhibits, the court should dismiss the indictments against Mr. Kearney, or in the alternative, grant an evidentiary hearing on the motions. XOXO. Dated New York, New York. It's up to you. New York, New York. And here, XOXO, Mark Bederow, Timothy J. Bradle. Wow. Was that a delicious piece of legal writing? I think it was. Let's go to the chat before we go to the 88-page affidavit that is attached to that memorandum of law with all the receipts. There's no court date for this yet. It could be decided on papers. However, there is a hearing coming up next week. I don't know if they're going to hear this motion then, but there is a hearing for Aidan next week on Wednesday, the 24th at 2 p.m. And I don't know that this is going to be heard then because, of course, Cosgrove has to have a chance to respond, and he's going to need a couple of weeks. He's going to need a couple of weeks to talk to his people, and see what his people want to do about this and how they're going to respond. How, if at all, they're going to respond, or if they're just going to wave the white flag and say, okay, why don't you just, dismiss the case. Just dismiss the indictments against them because we don't want to be questioned about all this stuff. Look at all these new members. Welcome to Sharon Miles, Kim Farnham, Special K, Rachel N. Good morning to Jenna Hags. Sharon T is a new member. And Hope has been here for 16 months and is so happy to spend her morning with me and the cupcakes. Thank you. People that make you say, thanks for your super sticker. Kraken Studio says Chat GPT for dummies, in my opinion. That's going all the way back to the beginning of the stream when we went over Lindsey Gaetani's new motion for contempt charges or for a finding of contempt against Aidan Kearney because Jason Broyles released her whole entire 15-year cell phone extraction with a hyperlink for people to find it for themselves. Nicole says, Mel, you're the best. Appreciate you. No, I appreciate you more. Unveiling. Welcome. Marissa says, thanks for keeping me company on my road trip. That's so great because I know that when I'm on a road trip, like when I drove to Boston and I was in the car for like 5 or 6 hours, I was just hoping someone was live to keep me company. So I appreciate you appreciating me, keeping you company, because I know what it's like to be on a road trip and wishing that one of your friends was on the tubes of you talking to you while you're doing the long drive. So it's my pleasure. Thank you, Marissa J, for your 10. Karen Reed is free. Hulda is here from Iceland and Spain. And she says, I need suggestions for a new name. Oh, we had so many. In those papers alone, maybe you found one because you sent this earlier at 10:28 and it is now 12:33. So if anybody wants to suggest a new name for Karen Reed is free, Hulda, Iceland, Spain, just tag her. Soap API, let's just put this one down to a whoopsie daisy again. Yeah. Thanks for tuning in from Australia. For your super chat. Catherine Smith, is Lindsey one of Jen McCabe's soldiers? I know she wanted Aidan Kearney to go to jail, but did she conspire with Jen? Seems like there are a lot of cooks in the kitchen. Well, I think some of your questions might be answered when we get on to this next document. So hang tight, Catherine Smith. Thank you for your 10. Rossler's mom, welcome. Redondo Beach says the black and white cookie. Ms. Bouquet, thank you for your super sticker. Oh, I have your request to sign a headshot for your son. I have it. I'm going to do it. I know you're across the pond, and I just have to send myself a mental reminder to do it and send it to you. And if you want to share with the chat, I don't want to, share your private business, but if you want to share with the chat why your son watches and why you're happy that he watches the show, you can, but I won't. Thank you, Mrs. Bouquet. Catherine says, can Tully be fired for this, misleading jurors? It could be something that he could get in trouble for. Yes, but again, it's Memo that presented all of the information to the grand jury. And so he's the one conducting it. So there's a fine line there with regard to, immunity and other things. But I think what Tully did or said in front of the grand jury is the least of his problems. That's what I think. Read between the lines. Thank you, Catherine, for your 10. Justice by Bederow said, if this isn't a textbook case of evidence tampering in Melisa's prosecution, I don't know what is, but this is Massachusetts, so who knows? Justice by Bederow. Oh, well done on the username, WHETEROW. That is so well done. I love it. Mother Oates says, Attorney Mel is my adult babysitter. I love it. 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 There's a weekend at Bevy's in the chat too. Come on, you guys. You kill me. Weekend at Bevy's. I was thinking Gerber too, but I was thinking a different color center. Oh, I don't know what you're talking about. Oh, the sunflowers behind me. Yes, those are sunflowers, actually. I got those out east when I was coming back from Boston, and I took the ferry to Orient Point, and then I drove home along the North Shore, and there's a million farm stands where you just put $10 in a little box and take your giant bouquet of sunflowers. Somebody told me the other day what kind of sunflowers they are. And they have a particular name. They're not Gerber daisies. Those are actual sunflowers. They're enormous and they're beautiful. Thank you for noticing. But also your username is awesome. Weekend at Bevy's. I mean, come on. How do you not love that? West Virginia country guy. Thanks for your 10. Aren't titles both artistic expression and literal speech? Isn't this actually a law enforcement officer, Tully, presenting wholly fabricated incriminating statements to a grand jury? Yes. But I think Bederow is saying that Kate Peter was the one who renamed him. Or did he say Tully renamed him? I'm getting very teddy bear sunflowers. Teddy bear sunflowers. Okay. I'll allow it. Aren't they awesome? So what happened? Well, what happened was they renamed the titles, and you'll see when we get to the chart, to make it look like he had the intent to intimidate the witnesses. So that is absolutely fabricated. It is absolutely prejudicial. It is not supposed to be done in the real world. And yet they did it. And they don't think there's any ramifications for their behavior because maybe, just maybe, they've been doing this for decades and decades and decades. And that is a great point. Thank you very much, West Virginia country guy. Because as he pointed out, Bederow, in that other case from, I think that was the most recent case. All right, here, Mrs. Bouquet is sharing now. She's sharing. She says, thanks, Mel. I'm happy to share. My son has a rare condition called Britson Goldberg syndrome, and he's mute. He's nonverbal until he sees this channel, and then he speaks. And she says he rocks. And how awesome is that? I love that so much. So shout out if he's watching today. Hey, hi. I love that. We're not just here for justice. We're also here for look up cases. Must be those eyes. We're not here to spread the word about cases that need to be talked about because your constitutional rights are dying all over. And for shouting out for people who have no voice, like Kelsey Fitzsimmons and Aaron Spencer, who was gagged for a long time and still can't talk about his case, and talking about the cases that people need to know about. And that's Mrs. Bouquet's son. Oh, hearts for Mrs. Bouquet's son. Yeah, that's awesome. DMB Mars became a member. Welcome. Last case, Mars, he prosecuted himself. And there's a little thinking emoji because we don't know that Marcy has ever tried a case ever. He's been elected to public office since like the 70s, before some of you were born. And that is a fantastic username. Thanks for becoming a new member. And Jenna Campbell says, like I said, we're living in a movie. We are, but we've seen this film before. We didn't like the ending. And Shannon said, that's the most touching compliment I've ever heard. Got milk for me said it's a federal offense to mislead any grand jury, either federal or state, under 18 U.S. Code 1623, false declarations before a grand jury or court. Thank you very much for the research. Proxa got waffled has gifted a membership. Thank you. Another great username. MMG Enrichment has been here for 16 months. Says, thanks. Orange looks great on you, by the way. Oh, thank you. That's very sweet. Dog Mama Adopt says, you think fake victim did this because she won Ratchet Madness? I just think, I don't know what to think. Thank you for your 10. Vicky Watkins gifted a membership. Thank you, sweetheart. Gail, aka G-Bird, says none of these players have any credibility. The whole proceeding involved lying, corruption on a massive scale. Credit to Aidan for his perseverance. He knew foul play. Melanie, you're a diamond. Oh, thank you, sweetheart. Thank you for your super chat and for tuning in from across the pond. Tracy from Florida. There's a lot of case law. Seems they have been doing this a long time. We cheat you long time. We cheat you long time. That's a reference from an old movie, except it was Me Love You a Long Time. I can't even remember what movie that was. Me Love You a Long Time. Riptide G became a new member. Welcome. Under Your Scars is here from Canada. Maybe she never got the money promised, so she's suing. LOL. Free Turtleboy. Give it up, mass. Wave from over the river. Neighbor, Ontario. Everybody wave to Under Your Scars. Ontario in the house. And Helen is here from Sweden. Hello, love to be here. Free Turtleboy. Thank you, Helena. A lot of you tuning in from outside the country, which I love. We have a worldwide, the world is watching. And we're mad as hell and we're not going to take it anymore because we're tired of the... And the only thing that we have to say at this point is...
Hello.
Oh, hold on. We got to remove this one first. Sorry. I'm going to try that again. Back to one. The only thing we have to say at this point is...
Hello, I'm here.
Let her read it. Let her say it again.
Hello.
Hello. Hello.
Hello. Hello. What are we doing here? Thank you, Jam Cracker, for gifting 5 to the new 5. The new 5 members. Thank Jam Cracker. Cat Q says, thanks, Mel, for your reading. I tried to watch Aidan read it. Oh, well, sorry, Cat Q, but I can't read the rest of that because it wouldn't be nice, and I try and be nice. Thank you for tuning in from Canada. Mamba 5 to be a fly in Bederow's brain. Thank you for your 5. I know, he's a genius. He's a genius. For the 50th birthday, get a chef. Get a chef for a day gift card. Oh, you're recommending somebody wants to know what to bring their girlfriend for her 50th birthday present. Get a chef for a day gift card. I didn't know that was even such a thing. Al Dente from Canada coming in with good ideas. Lisa B says, started watching YouTube because of the Karen Reed case. The way all the streamers collaborated and bonded together. Is that the norm before the Karen Reed case? I've only been on YouTube I had my 2-year anniversary this past July. And so the first trial that I covered, and it wasn't, Karen Reed was the first trial that I ever covered, I think, gavel to gavel, right? It is. And then before that, I covered the Maya Kowalski trial, but only like in a recap fashion. And during Maya Kowalski, a lot of the YouTubers that were covering it did collaborate and do things together. And so that's how I became familiar with Recovery Addict. I love Scott. He's amazing. A lot of people watch him daily for trial coverage. He covers a lot. He does a lot of fun court hopping and stuff, and other creators. And so, you know, I'm like a new law tuber. Like other people that are involved in LawTube have been around for a very, very long time. You know, LawTube really got its start during, I think Rittenhouse was the first trial when Nick Rakita used to run these like streams with like 10 lawyers on at a time. And then the Johnny Depp versus Amber Heard thing. And then I remember my sister and I like watching these streams with like 10 lawyers. She's like, this is amazing. You got to check this out. It's so cool. You should do this. And I'm like, well, why? How would I even do that? I wouldn't even know how to do that. And here we are 2.5 years later. So that's kind of interesting. But I can't really speak to that because I was very new to LawTube and I got into YouTube by being a guest on Duty Ron. And I was with Duty Ron and Ed. I was Duty Ron's co-host for a while when Ed was on assignment and he couldn't be there for a couple months. And so I did a lot of shows with Duty Ron and kind of got my legs there and did like, I don't know, 50 shows with him maybe. And then I just started my own channel. And so that's what happened. And I did get my plaque for 100K. And so we're doing it now. You want to open it? Why don't we open it? Let's open it. Let's take a little break because we're taking a little break before the second document. Let's open it. It's been too long. So let me just go get it. We'll do an unboxing. It'll take 3 minutes. Give me 2 seconds. Let me just go off camera for a second. Just hang on. I gotta see if I know where it is. Okay, hold on. Hold on to it because I haven't done it and I keep wanting to like celebrate and like there was never been a time, but let's do it now. Let's do it now. Here it is. This came all the way back in, I think it was during the Karen Reed trial. It comes in a nice box from, oh, well, that was probably a stupid thing for me to do. Hopefully it was blurred out. Okay, let me just make the, comes in a YouTube presentation box. And then they send you like a letter. It says, do you remember your first subscriber, your 100th, your 1000th? Chances are you do. And we know that you'll definitely remember your 100,000th subscriber. Your fans may have found you while searching on YouTube, learned about you through a friend, or maybe you showed up as a recommended video. No matter how they came to your channel, your audience stayed and their numbers increased because of you and the community you've built. We're proud to honor your impressive milestone of reaching 100,000 subscribers with the Silver Creator Award. Congratulations. We know that you have many more stories to share with your community, and we know your fans can't wait for you to amaze them even more with your commitment and creativity. So keep creating, keep building. We can't wait to see what you'll do next. We're here to support you along the way. And who knows, when you reach your 1,000th subscriber, we may just write to you to ask, do you remember your 100,000th subscriber? XOXO, Neil Mohan, YouTube CEO. Isn't that awesome? So that's awesome. They send you a letter. It's on nice thick paper. And it says, congratulations on your subscriber milestone. And it says, you can order more, I think, but they're like a couple $100 each. Okay. So here's the box. It comes nice. It's nice. Let me take this down. And this nice little foam. It comes with a little foam right here. And then underneath the foam, here it is. Oh, it has a weird smell. Dun, 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 dun. It says presented to. Here it is. Now my kids think I'm cool because Jake Paul had one of these when my kids were little. And that was the thing. If you could get a YouTube silver play button, you were really cool YouTuber. It says presented to attorney Melanie Little for passing 100,000 subscribers. XOXO YouTube. There it is. Thanks to every single one of you for subscribing to my channel. It is free. I don't know if you can even see this. I'm going to have to find a place to hang it because it comes with these little 2 things on the side, which means it requires hooks, I guess. But we'll have to find a place to put it back there because now I'm cool, according to my kids. Thank you to every single person who has chosen to hit that subscribe button because it's free. And this is what YouTube gives you at 100,000. They send it to you and it's really cool. And I love it. So thank you for all of you for hitting the subscribe button. It is free. It's free because you're the best. You're absolutely the best. And so I just opened it for the first time and now we're at over 127,000 subscribers. So I'd like to thank the Academy. I'd like to thank the Academy. I said that the other night during Aidan's roast. I said something like, I may never get this chance again, everyone. So shh. I'd like to thank the Academy. Pretending to make my, Emmy speech that I may never get. So, but I do have a YouTube silver play button and it's here. And I love you guys. And I'm so very grateful to each and every one of you who has chosen to subscribe to my channel, because without you, I don't have a channel. And without my amazing moderators, I don't have a channel either. So to all of my amazing moderators, Scott, Team Brittany, Little Cupcake, Scott Messerschmidt, Kel, Grace. I don't know who else is here today, and I don't want to forget anyone, but I couldn't do this without you, because we do have the best moderators on YouTube, and they keep it classy. No, you don't have to buy them. You get this one for free, and then there's a thing that says if you want to buy more, they're like $225 or something. And I think you don't even get another thing from YouTube until you get to like 1 million. So it's like we'd be at 128,000, but there have been several tickets to Block Island today. LowTube's most hated mod said, no, Catherine, you don't really hear back about an audition unless you actually book it. So it'll probably be a week before I hear anything, because it's supposed to shoot, I think, the end of next week. So I would probably hear at some point. But, you know, there's a lot of crickets in the world of entertainment. And so even when you're auditioning for a major network television show, you do not hear anything unless you actually do book it. So there's that. Oh, 500,000 and then 1 million. I don't even know. Yeah. Making your kids proud is the best award, right? It's the best. It is the absolute best. And it's amazing. All right. We have 88 pages to read. What I would like to do is just take a little quick break. Do you think we should take a little quick break and everybody go grab a snack and then teleport onto a different stream so that we have one stream for the morning and one stream for the afternoon, or just keep it all as one stream? If you guys want a break, we can do a break. If the mods want a break, we can do a break. No, yes, no, yes, yes, yes. Oh yeah, remember when my kids came in with the rainbow cookie cake, and they were doing me like the whole they were doing the whole congratulations, and they were singing congratulations. That was awesome. And they didn't want to a break would be good, everybody says. I think we should break it. The people who are at work are like, no break. I don't want to. I'm just saying like a 15-minute break. The link to membership is in the show notes. Let me just put up some content for you while I just take a quick break. Let me do that just for starters, okay? But again, thank you to every single person. I'm so grateful for you. I'm so grateful for your participation in this channel, for your willingness to want to listen to me scream into a mic for hours on end. And you know, sometimes I get cranky, and sometimes I'm not the nicest person to be around, but you guys get it because you're empaths too, and you understand that it can be so exhausting to have to like just feel the injustice in your soul every single day to the nth degree. It's hard. This is hard content. We try and do it in a respectful way, and we try and do it in a way that people can understand. And so I love you guys. I love you guys. You're awesome. You are awesome. Hang on for 1 second. I want to just take. Let me play this for you. This will be. I'll play you a something from. I have my history. What do I got? What do I got? Yeah, it was WCVB Channel 5 Boston that put up a video yesterday that says girl 7 choked, thrown from bridge after being kidnapped from party, police say. And it's literally, it's the old news clip. And I wrote in the first comment, I'm like, this is from 2017. And people were thinking that this was like real. This is so weird. It's like, why did they post this yesterday when it goes all the way back to 2017? I don't know, but I might as well play it for you. Let me just take this down. This is the video they put up yesterday for those of you. Well, bye, Cardi B. You got to come down, Cardi B. You got to come down. For those of you who are not familiar with the Josh Hubert case, this is on trial right now. I'm going to quickly check and see if there's a verdict, because the jury was hung But this, again, is from 2017. Don't get confused. They just posted this yesterday.
Twinette, we have just learned these details over the past couple of hours from Worcester police, and they are upsetting to say the least. As you mentioned, this involves that 7-year-old girl, and the man is accused of kidnapping her, strangling her, and then tossing her over a bridge. That man is identified by police as Joshua Hubert, and as you mentioned, he is waiting for his arraignment here at Worcester District Court. Here are some of the details as police have revealed them to us. 35-year-old Hubert took the girl from a house party early yesterday morning at about 2:30 in the morning without her parents' permission. He put her in a car, strangled her, and then threw her off the 290 bridge into Lake Quinsigamon. That girl survived incredibly, swam to shore, and was later found and then told her story to police. As of now, Hubert is only being charged with kidnapping, but we imagine more charges will be filed. More details, of course, will be learned during his arraignment here at Worcester District, which is scheduled to happen sometime soon. We will pass those information to you at 4, 5, and 6 o'clock. But for now, we are live in Worcester. I'm Reed Lamberty, WCVB News Center 5.
So dopey, right? Kind of stupid. Kind of dopey. It is old news. I know. Yeah, I got to find a way. I got to find out where to put it. We'll keep the stream going. The problem is that some people, I think I'll just play some content for you while I go, just take a break and fill up my drink and stuff. That was from 2017. Okay. So, oh, you want to watch some Paris Ray and the Crush? Because the only music that I'm allowed to play is one of my kids' bands, because, you know, YouTube is like super, they don't really like, you can't copyright strike music, you know? So they don't like that. But so I can play my kids' music, but we can do that for a minute or two. Thank you. Thank you for the congratulations. Let's do Paris Ray and the Crush. One of my kids is in this band. I'm not going to tell you which one's mine. And you don't have to tell each other which one's mine, because that is one of the things I don't like, is people like doing things or talking about my kids. But I'm a proud mother, and I'm going to play it. And we're going to take about 15 minutes. You want the tiny desk one? Okay. We're going to take about 10 minutes or so, just so I can get something to drink. All right, we'll play the Tiny Desk concert first, and then let me just put it in. I will give you after that. Let's put this in the queue. And then after that, maybe we will watch let's do Desert Baby. After that, wait, stop. All right, so first we're going to do the Tiny Desk concert. And this song is it Green Flat? Wait, hold on. Big Bang is the name of the song. Big Bang. This was their entry to get on the Tiny Desk concert series. And enjoy while we take a short break for only about 10 minutes. Go sub to Paris Ray and the Crush on all socials, including Instagram and YouTube. They have a YouTube channel as well. And Spotify. Make sure you add them to your Spotify, or, you know, whatever music service you use, and enjoy.
New York had an earthquake, a whopping 4.8 on magnitude. just 4 lines in fiction, but it got me thinking how I didn't know what to do. This lack of preparedness is making me anxious, so what else is new? A solar eclipse or the apocalypse, and I still wouldn't turn on the news, 'cause que sera, sera. Just do whatever you want. If today is our last day, I hope we go out with love. There's wildfires in the north and they turn the sky orange. The whole thing looks like something from a movie. Felt like we were doomed. We just all carried on with our lives. Not sure what to do when you're feeling like Truman and nothing feels real. Don't know what it says, it bracing for the end is the most human I ever feel. 'Cause que sera, sera. Oh, just do whatever you want. If today is our last day, I hope we go out with I was born in the desert, baby, came a few months early. Somebody gave me a chance, like it was all part of some plan. 2, 3, then my parents picked me up from the woman who made me. Cried in the hospital and swore they raised me good, give me everything they could. Well, they kept the promise, flew me all the way to New York, where I grew up having everything I wanted and more. Couldn't shake the feeling maybe I was meant for something great. My mom told me all my life how much you prayed for me. So I felt like I was born to fill a prophecy. Put in everything that I'm supposed to be go to waste. Now I'm a washed up, burnt out, gifted kid. Just another shoulda, woulda, coulda been. Golden girl, worst pain in metal. Wasted on wasted potential. When you're famous, don't forget about us. I'm not even a has-been, oh, I never was. I take living on a plateau over living in my own shadow. I was born in the desert, baby, was a long road, but I didn't let it make me cold. No, I was always told that I didn't get here accidentally. No, I'm exactly where I'm supposed to be. So when I met that boy, it felt like destiny. The universe wouldn't let me down. But I'm appreciated for believing when he said that he didn't mean it and he'll never do it again. Guess the destiny was a hospital bed. If Arizona could just see me now, I was supposed to make everyone proud. Now I'm a washed up, burnt out, gifted kid. Just another shoulda, woulda, coulda been. Golden girl was painted metal. Wasted on wasted potential. When you're famous, don't forget about us. I'm not even a has-been, cause I never was. I take living on a plateau over living in my own shadow. I was born in the desert, baby. Why the hell would anybody save me? 'Cause I'm a washed up, burnt out, gifted kid. Just another shoulda, woulda, coulda been. Golden girl, painted metal, wasted on her own potential. When you're famous, don't forget about us. I'm not even a has-been, cause I never was. I'm secret on a plateau over living in my own shadow.
And we're back. And we're back. Welcome back. And now we get to the fun part. The fun part. The part with all the redactions. The 88 pages. I don't know if we'll get to all of it today. We'll try. We'll see. We might, skip around. There might be a lot of maybe there's a lot of backstory that we don't have to go through, and maybe we can just, go to the fun parts. I haven't looked at this yet. It's 88 pages. I was so tired yesterday that I didn't get to it. So let me take down this break sign. If you're just joining, we have read so far today Lindsey Gaetani's motion for contempt against Aidan Kearney that was just filed yesterday. It just became available today. We have also covered the memorandum of law attached to this motion to dismiss the indictments against Aidan Kearney, written by Bederow. And now we have the 88 pager. The 88 pager with all of the receipts in it. All the receipts are in it. Thank you very much to hang on, Stephanie, for your very sweet, very generous Venmo. It says a little something for reading the highly anticipated Bederow motion. Thank you. Thank you very much, Stephanie. Love you, girl. Many of you may have already heard this or read it. I don't know. Did Aidan did he go through the whole entire thing last night? Or did you just read portions of it? Or did you skip around? Because it looked like he did a lot of other stuff. Thank you. You like my earrings? Thank you very much. Thank you very much. So I don't know how much he's already read, how much you've read, if you've read it yourself and stuff. But yeah, music. Music is so good for your soul, isn't it? Thank you, Melissa. Somebody just sent me an awesome picture from the Wilbur, so I want to show this to you. Anne, her name is Anne, and she sent me this picture from the Wilbur. She said, I got a picture of you signing that t-shirt. And she said, I just happened to take a picture of you signing that t-shirt. I was worried we would not get a picture with you because of all the people. And this was at the after party at the Encore Casino, which was so fun. Highly recommend. If you guys haven't been there and you live in Boston, like, why haven't you been there? It was so fun. Thanks, Anne, for this picture. I love it. And that's a picture of, I had my sunglasses on. It was so bright in there. Me, Tim Bradle. That's Courtney, Tim's paralegal. And Anne, I'm not sure if that's you or if you just took a picture of me signing that t-shirt. But there was a woman who was asking me and Tim to sign a t-shirt with a Sharpie. And it was very hard to do. It was very hard to do. So thank you, all of you who have sent me all of these amazing pictures. Maybe we'll share some more of them later because they're really fun. And I'm so glad because I barely took any pictures. And I'm so very grateful for you guys for taking pictures because it's awesome. Oh, there was another picture. Remember the other day we were talking about the Bang Bang song? The Bang Bang song. And the guy who wrote the Bang Bang song, Bang Bang, Bang Bang, you remember the Bang Bang song, right? His name is Varys. And I found the picture. Actually, Kelly had the picture because Kelly took the picture of Varys. So you guys may know him or you may recognize him, but you may not actually know that Varys is the guy who wrote the Bang Bang song. And he's awesome. And that was right outside the entrance of the Encore Hotel, and that was at the end of the night. And boy, did we have fun. We had so much fun. And that reminds me of, some nasty comment that just, again, it's like, oh, don't give the trolls, don't give them what they want. But this is great because it just shows you like how ignorant some people are. And this is a great example of it. If I can find it. And I forget what video the person posted this comment on, but I'm sure it had something to do with the Wilbur. Jump for Joy 6. Shout out. Oh my God, Melanie, not you being passive aggressive to Karen just to massage to Turtle's ego. Let me go one step further. I've seen clips from the Wilbur, and thank God, all caps, Karen didn't go. It looked incredibly cringe and mocking her murder trials that you've all turned into your entertainment and, quote, content would have been incredibly uncomfortable for her. I've never seen such pandering to a 40-year-old man as to what YouTubers and turtle riders are doing just to either stay on his good side or get attention from him. Yeah. I want attention from Turtleboy. It's not great. Seems like you're just mad that Karen didn't throw a verdict party and give you all the opportunity to get applauded, etc. It's what struck me about how much y'all were lapping up the attention on Saturday night. Well, first of all, it was Friday night. You love being treated like VIP celebrities. That's the difference. Karen never asked for this attention. Aidan craves it, and seemingly so do you, Melanie. It's like, haters are our biggest fans. Oh my God, girl. Thanks so much for watching. Smash the like button. Like, for somebody to take the time and take the time to type out this long ass comment underneath a video. To take the time to do that is a special kind of ridiculous. It's a special kind of ridiculous. Wow. Yeah, it's right. You know what I should have done? I should have hid in the corner and not let anybody take a picture and not spoken to anybody and not listened to their stories and not shaken hands. and hugged it out with all of the people that have supported Karen Reed and all of the creators throughout this entire mess of a 2-year debacle. That's what I should have done. I should have hid in the corner. Maybe I should have just stayed home. Nobody paid for me to be there. We all went there because we all wanted to be there to support the First Amendment and Aidan Kearney and all of you who showed up for all of the streams during this entire debacle. And guess what? We're not done. We're not done. Karen Reed is free. We got other people to free now. We got other people to free. We got Kelsey Fitzsimmons. We got Turtleboy to free. We're freeing the turtles. That's why we're here. We're reading his papers. We got Kelsey Fitzsimmons to free. We got Aaron Spencer to free. We got other people to free. Okay. We move on. We move on to the next one. And that's what we do here. And so, I mean, unless people hate you, I guess you're not doing it right, right? So funny. Yeah, we're pandering. Jesus Christ. Yeah, I paid for my ticket and I got on stage and I paid for my hotel and I drove 6 hours each way to be there, paid for my gas, paid for my ferry, paid for my tolls. Go F yourself, okay? How about that? Give me a ridiculousness. You're here for the papers? Thanks, none of your business. Reminding me to get back on topic. All right, here we go. This is the affidavit in support of the motion. All right, what's the timestamp? 3:15:42. Oh, did you see my silver play button? There it is. Thanks for the hate. All right. 3:15:55. And here we go. We're going to skip around because this is the affidavit signed by Mark Bederow in support of the memo of law that we just read about all the reasons why Aidan Kearney's indictments should be dismissed, the shenanigans in front of the grand jury, the fake evidence that was submitted to the grand jury, in addition to such things as the failure to turn over exculpatory evidence during the course of discovery. And for all these reasons, you should dismiss the indictments against Aidan Kearney. And that's what we want. That's why we're here, for all the reasons, and disqualify Ken Mello. So dismiss the indictments because of the shenanigans with the grand jury, for impairing the integrity of the grand jury proceeding. Dismiss the indictments for their Commonwealth's pervasive failure to disclose evidence, specifically requested Brady and Giglio material, and disqualify prosecutor Ken Mello, special prosecutor Ken Mello, because he's in violation of Rule 3.7, and he is going to be a witness to the defense. And all of you know the background about Aidan Kearney and what he does, his YouTube presentations, and that his YouTube videos are sequentially numbered in episodes, and each one has its unique title, as you know. Mr. Kearney's investigative reporting has exposed numerous examples of fraud, corruption, and wrongdoing. He often intersperses his journalism with elements of comedy, satire, and activism. Not surprisingly, many people who become the subject of his reporting and content don't like him. In April 2023, Mr. Kearney began researching the Karen Reed case, which at the time appeared to be a straightforward, open and shut vehicular homicide case. Many of us thought that. We heard the news. The news said there's ring camera footage of the incident. News at 11. And we all thought, oh my God, that's so terrible. This drunk girl mowed down her boyfriend in the snow, and terrible case. But it wasn't true. They didn't have any ring camera footage. After he reviewed publicly filed court documents and acquired information from sources he generated, Kearney quickly realized that the case against Ms. Reed was far more nuanced than had been publicly reported up to that point. Since he first delved into the circumstances surrounding how John O'Keefe, a Boston police officer, ended up dead on the front lawn of fellow Boston police officer Brian Albert, shortly after Ms. Reed dropped him off at Mr. Albert's Canton home in her Lexus SUV, Mr. Kearney's reporting and content creation has centered on his unabashed belief that the Norfolk County DA's office and the MSP framed Ms. Reed with assistance from Jennifer McCabe, members of the Albert family, footnote 1, and others who participated in Mr. O'Keefe's death and or helped cover it up. Footnote 1 says Ms. McCabe's sister, Nicole, aka Coco, is married to Brian Albert. 507. On April 18th of 2023, Mr. Kearney published his first article about the Reed case. Canton Cover-Up, Part 1, Corrupt State Trooper Helps Boston Cop Cover Up Murder of Fellow Officer, Frame Innocent Girlfriend. Oh, thanks, Lynn. She says, that ugly comment, in my opinion, XOXO. Thank you. She has an idea who it was. Sweet Caroline, you're the best. Thank you for your very generous memo. I don't know. I didn't even think about that, but who knows? You may be right. I may be crazy. So he didn't publish his first article about Gary until April 18th of 2023. Mr. Kearney's initial Canton cover-up report was primarily sourced by the April 12th, 2023, 90-plus page court filing from Ms. Reed's defense, and of course there's a hyperlink to that, which consisted of an affidavit from her attorney supported by numerous exhibits, including police reports and data from an extraction report of Ms. McCabe's cell phone. He went with the papers too. Mr. Kearney reported that Brian Albert, Ms. McCabe, Matthew McCabe, Chris Albert, Colin Albert, and Julie Nagel were definitely in the house, in quotes, definitely in the house at the time Mr. O'Keefe was killed, and that all of them witnessed the murder or are aware of it and have said nothing. Most of them were not questioned by now terminated and disgraced Trooper Michael Proctor. Tracy Steedman is here. She's gifting 5 memberships. Thank you, Tracy. And to the 5 new members, welcome. You guys are amazing. Okay. Thank you, Lisa, for this. We addressed that. Oh no, Catherine Smith says my daughter died 15 days ago from complications of chemo. Damn chemo. So your channel has been a wonderful distraction lately. Very grateful for humor in these trials. Her 19th birthday is September 20th. Oh, stop. My condolences to you. I don't even know what to say. No parent should ever lose a child. That's not the way it's supposed to be. Not a 19-year-old or an 18-year-old, and not to cancer. And she died 15 days ago from complications of chemo, not even from the cancer. Prayers up for Catherine Smith. So sorry for your loss. And heaven just got a whole lot more awesome. It's not fair. It is not fair. Sending all of our love and sympathy and prayers to you. Oh, that sucks. In Mr. Kearney's article highlighted the Reed's defense's claim that Ms. McCabe Googled Hoslong to die in the cold at 2:27 a.m. on January 29th of 2022, which, if true, was damning evidence of her complicity in or knowledge of the circumstances surrounding Mr. O'Keefe's death. Most of the individuals criticized in Mr. Kearney's April 18, 2023 article for their alleged involvement in Mr. O'Keefe's death or its cover-up later became the allegedly, in quotes, intimidated victims in the indictments against Mr. Kearney. Indictments related to Mr. Kearney's purported intimidation of Mr. Proctor and Sergeant Yuri Buchanan were later dismissed by the court. So of the 16 indictments that he originally was charged with, I think only 10 are remaining. I think the ones against Proctor and Buchanan were dismissed, maybe a couple of others. I can't remember how many are left, maybe 11. He's still facing over 100 years in prison because he hurt some people's feelings. All right, moving on. Mr. Kearney's well-sourced, dogged reporting and outspoken support of Ms. Reed's innocence lit the spark that quickly ignited the Free Count Reed movement, a phenomenon which galvanized worldwide support for Ms. Reed and relentless, blistering criticism of the DA, MSP, and the civilians whom Mr. Kearney and many others believe concealed the truth about Mr. O'Keefe's death. Mr. Kearney's coverage of the Reed case, which to date includes 528, count them, Canton cover-up articles and hundreds of video episodes, virtually overnight transformed a mundane Massachusetts criminal case into perhaps the most high-profile and scandalous murder prosecution in the United States in decades. And ain't that the truth? And so much more has yet to be uncovered. So much more will be coming out. Do I have access to the links? I do, but only if I open it in a browser. And so because I have it downloaded and in PDF form so that I can highlight it as I go along, I can't click on them from here. So we're not going to do the hyperlinks right now because I like to highlight as we go along so that I know where my place, I keep my place and I don't get lost. Mr. Kearney's frequent reporting on the Reed case has played a substantial role in the public's loss of confidence in the integrity and competence of Norfolk County law enforcement, an ongoing scandal that continues to plague the DA and MSP in the aftermath of Ms. Reed's acquittal. Footnote 2. Mr. Kearney's exposure of the DA's and MSP's misconduct in the Reed case has complicated the murder case against Brian Walsh and Miles King. It has led to significant criticism of the DA's investigation into the death of Sandra Birchmore, which it classified as a tragic suicide, but which many believe was a whitewash. A whitewash. Sandra Birchmore was a whitewash. In 2024, the U.S. Attorney's Office thoroughly rejected the DA's findings and indicted former police officer Matthew Farwell for Ms. Birchmore's murder. It could be said. I don't know. It could be said that Turtleboy is the reason Matthew Farwell was arrested because of his exposing all of the corruption in the Karen Reed case, and that maybe, I don't know, because we don't really know how the FBI got involved or what they got involved in or why they got involved, or if they stumbled upon Sandra Birchmore while they were looking at other stuff, or if Aidan's reporting had anything to do with the FBI being like, things that make you go, should we take a look here? I have no idea. I mean, if you listen to Kate Peter and her friends, they will say that Alan Jackson, Karen Reed's father, was the one who called the FBI in to take a look. And that is absolutely not true because that's not the way that it works. Oh, there's a Sandra Birchmore story on Dateline tomorrow night. Okay, good. Everyone tune in for that. Maybe somebody will have a watch party. Today's National Cheeseburger Day. Is that true? All right. Everyone have a cheeseburger. Teacup Pug is paying. So, all of these things intertwined inextricably at this point, and we don't know how they got involved, but we do know that if it was left up to the MSP and the Canton PD, Sandra Birchmore's death would still be ruled a suicide. But for Mr. Kearney's reporting, disgraced former Trooper Proctor would still be investigating serious cases for the MSP. Other members of the MSP, including Detective Lieutenant Tully, the lead investigator against Mr. Kearney, and Sergeant Buchanan, wouldn't have been publicly disciplined for their misconduct, and the Norfolk DA's State Police Detective Unit wouldn't have been dismantled due to their misconduct in the Reed case. Although Mr. Kearney's reporting on the Reed case raised disturbing questions about the possibility of systemic corruption in Norfolk County and gained him tens of thousands of supporters, the public officials and private citizens he is accused of wrongdoing, and the microscopic segment of the population who remain convinced of Ms. Reed's guilt despite her acquittal, despise him for his coverage and opinions. Wow, that's well done. A microscopic segment of the population. How do you think they feel about being called microscopic? That's fantastic. Since Mr. Kearney exposed the scandal surrounding the Reed case on April 18th of 2023, the DA, MSP, Ms. McCabe, and the Alberts have repeatedly used the criminal justice system as the instrument to silence Turtleboy and end the persistent criticism his reporting has caused and still causes them today. Summary of the motions. Well, we've already read all the motions. We know about the papers, and so I don't think we need to do summary of the motions. And so I'm going to skip right through that. Except to say about Kate Peter. Ms. Peters' dreadful credibility included incidents in 2020 and 2023 where she falsified and forged evidence to harm Mr. Kearney. So the 2020 incident was her submitting that fake federal lawsuit to YouTube to get it stricken. And then her audacious defamation and exploitation of Colin Albert and Chris Albert to further her insatiable urge to embarrass Mr. Kearney. We're going to get to that. But I think it's alleged that she made up a rumor that Colin Albert was dealing drugs. Well, we call him Colin because that's what Cosgrove called him in open court all the time. Every time he would talk about Colin Albert, he would say, Colin, Colin, Colin. And he does it. And so now we do it. And it's like, I guess he's thinking of maybe Colin Powell, who spells his name the same way, Colin, but pronounces it Colin and not Colin, but we know it's Colin Albert. Ms. Peter provided D.L. Tully and Mr. Mello with video and audio evidence, including edits from Mr. Kearney's lengthy episodes, which she believed evinced Mr. Kearney's intent to intimidate witnesses. As detailed in the accompanying affidavit of Courtney Healy. Oh, I didn't know Courtney's in here. Courtney is Mr. Bradle's paralegal. She was in that picture that I showed you before of Tim Bradle and I signing that T-shirt. She has been working 24 hours a day to try and get Kelsey Fitzsimmons out of jail. She's amazing. According to D.L. Tully, Ms. Peter directed him to specific timestamps of Mr. Kearney's episodes, which he located and edited rather than review the linked files provided to him by Ms. Peter. Letteros by Bederow, filling in the blanks before we get to it, that Kate Peters sent Aidan phony texts from someone claiming to have bought substances from Colin. She's a sick one. Jason Smith says she sent Aidan a spoof email claiming she was the witness to Colin selling substances. He read the email claiming it may be fake, and she thought that was funny. Oh. Did the McCabe's and the Alberts know that she was the one who did that, who started those rumors? Did they know that until before now? Because, they've been simpatico. They've been like a team, Jen McCabe and Kate Peter and all those people together. Did they know that she was the one that started that rumor until this just came out? I need to know. D.L. Tully apparently renamed the edits he made from Mr. Kearney's episodes. Oh, yeah, so it was Tully who did the renaming. It was like the rehoming of Chloe. He did the renaming. That came out more than a year ago, says Jason. Look at Jason has his finger on the pulse of every single date in this case. So Tully was the one who renamed all the files because they were not accurate, but they made him look guilty, and they named the file intent. The edited and renamed files and the intent folders that Tully created were the exact files that became the exhibits for the grand jury that Mello introduced and Tully described. Mello's direction of the grand jury proceedings made a mockery of Mr. Kearney's right to due process, the cumulative impact of which impaired the integrity of the grand jury proceeding and prejudiced Mr. Kearney. Mr. Mello littered the grand jury proceeding with his improper comments, his unsworn opinions of the evidence and Mr. Kearney's intent, and by twice eliciting Tully's opinion that Mr. Kearney intended to intimidate witnesses. And this was all in the other papers that we read, so we don't have to read through this again. Mr. Mello dedicated the first day of the grand jury proceeding to dirtying up Mr. Kearney, talking about the uncharged allegation of wiretapping Steve Scanlon, had Steve Scanlon come in and testify, and told the grand jury all the stuff about the videos, which were mislabeled at least 28 times. Mr. Mello elicited from Tully materially false and misleading testimony about Kearney's YouTube episodes, which gave the grand jury the false impression that he created the episodes to document his alleged intimidation of witnesses. I mean, I can't even express in words how egregious this is. I can't even. Oh, KBD. I don't want that second name in your comment even mentioned on this channel. Oof. Sorry, I have to delete it. I can't even look at that name. Yeah, everyone's like, Wet Wipe says WHET wipes. You guys are so on it so quickly. Telly has told K. Peter to lay low. Gail says, wonder why K. Peter is laying low. Bederow's telling them everything. This is just Irish. And they do. They lead very, very sad lives. It's very sad. It's okay. I got it. I got you, KBD. No worries. I just like Coffindoffer is one name that I don't like. Yeah, that is the other one. Despite numerous defense demands for specific evidence from September to August, September 24 to August 25, the DA has failed to disclose all of the stuff and things that we said before. The defense made a prior defense motion to dismiss the indictments, but we didn't have all this important evidence because they hadn't disclosed it yet. That's why we're doing this all over again. Communications between Kate Peter and Bederow is so nice because he says Ms. Peter, Mr. Mello, and DL Tully. You know, only the New York Times still does that, calls people Mr. and Ms. And he even says Mezzers when he says more than one Mr. Like, he's so old school, and I love that. Communications between them, which are relevant to the incident motion to dismiss the indictment, have been in the Commonwealth's possession, custody, and control since 2023, and were the subject of specific demands on September 12th, 24, October 8th, and October 17th. Those were Bederow letters, but were not disclosed until months after the court decided our initial motion to dismiss, right? So now we got to move again. Now we got to remove. We got to remove because they didn't turn this stuff over. Mr. Mello forwarded many of the communications relevant to this motion to dismiss the indictment to co-counsel Robert Cosgrove on December 16th of 2024, but Mr. Cosgrove didn't provide them to the defense until July 7th of 2025. Notwithstanding specific defense demands for that exact evidence addressed to both months before the defense filed the first motion to dismiss the indictment. Cosgrove is like, oh, let me hide the ball so they make their motion to dismiss and they won't have all the evidence that will actually get the case dismissed. And then, you know, they won't make the motion again. Surprise! Remember Cosgrove. Remember the trial that we watched, the trial, Aidan's trial that took place during the Karen Read second persecution. And it was a trial, and it was the trial of whether or not Aidan violated the restraining order against Lindsey by showing up to court the day that Paul O'Keefe and the O'Keefes brought Lindsey with them to court. And Cosgrove was examining someone. He was cross-examining someone, and he said, "Surprise!" Remember? Oh man, that was great, man. That was great. That was Judge Pomeroy. It was a bench trial, and he acquitted Aidan of that charge, but Paul O'Keefe had to come in and testify, and he was not happy. He was not happy. On September 4th, it was Meredith that he was cross-examining. Okay, thanks. Yeah, that's crazy. September 4th, 2025, defense learned for the first time that Tully apparently edited and renamed Mr. Kearney's content. Right? We watched this hearing together. September 4th, 2025. He apparently edited and renamed Mr. Kearney's content, and that this altered evidence later became the exhibits used by Mr. Mello and Tully to mislead the grand jury about Mr. Kearney's alleged intent. You tell me if you think that this is enough to get this case thrown out. Because Bederow is telling them everything. Everything. Charlie Lynn says, Tully said he renamed everything because they are embarrassed they listened to Kate Peter, and to say they never clicked links now erased, and claimed Tully looked it up himself and renamed everything. Communications between and among Ms. Peter, Mr. Mello, and Tully recently disclosed by the Commonwealth established that the defense still hasn't been provided with A, private video links Peter sent to Mello and Tully, photographs and other evidence Ms. Peter sent to Yuri Buchanan, and communications between Peter and Tully regarding the assistance she provided Tully immediately before he accessed Mr. Kearney's actual episodes and edited them change their names, and place them in an intent folder that he created for use in the grand jury. I mean, listen, you need look no further to determine how sucky these police are at their jobs if they decided to use Kate Peter as their not so confidential informant. That just goes to, I mean, that directly speaks to how badly they suck at their jobs. I mean, there's really, you can't get around it. The DA now claims that numerous private links containing discoverable information about Mr. Kearney that Ms. Peter provided to Mr. Mello and Tully has since been deleted by a private party, i.e. Ms. Peter, blaming her for deleting evidence. Ooh, so sorry. So sorry that all the links we gave you and what weren't the blank pages don't work because they were deleted by, oh, sorry, Kate Peter, because, you know, now they're going to roll over on her. They were so desperate, so desperate. Evidence tampering? Sure, could be. BL could be. Like the way you're thinking. The Commonwealth has represented, and this was in open court, we remember it because we watched, that that Tully has never opened any unsolicited links emailed to him by Ms. Peter. Notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Ms. Peter, but sent them to DL Tully for him to review. Oops. There it is. I mean, hold on a second. I get more spam calls in a day than I've ever had, like, in my entire life lately. Anybody else get more spam calls a day? People want to give me loans, all kinds of craziness. All right, so let's see. I'm going to pull it up in another window with the hyperlinks in case there's anything that I want to look at, like, right away. What page are we on? 13. Oh, this is fantastic. All right. Okay, I see what you did here, Olivia. I see what you did here. So when you click on the link that says the Commonwealth has represented that DL Tully has never opened any unsolicited links, it takes you to here. Oh my God. This is glorious. And to the exact timestamp of where he says that.
Attachment is, some of the attachment is, depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Bederow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't.
Resurrect. We'll stay on the Catholic theme. Talk about resurrection and the blessing of the Commonwealth.
Worked my way entirely through his letter. But what happened, Your Honor, is this.
What happened was
Lieutenant Tully, who was the recipient of most of these, has a practice of not clicking on unsolicited links that are sent to him on email.
Even by your not so confidential informant who is gathering information for you? Anybody believe that? Anyone? Bueller? Anyone?
So he doesn't access them. Now, if someone is sending him.
Oh my God. And Olivia actually cut this down to a 3-minute clip. So that's all that's in this clip. It's not the whole entire hearing. I'm getting chills right now.
A reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury.
His YouTube presentations. This is where it comes from, the YouTube presentations. Well, here's the thing. Bobby, what should we call him? Fababio? Fababio, here's the thing. If he did go and look for them himself, then by all means, what happened was he would have seen the real titles of the real videos, but he didn't because he changed the names to make him look guilty.
All of those were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them, may have been pointed to them by multiple sources. But he never clicked on whatever it was that was
So who else was sending Tully information? Other people too, huh? Okay, well, he just admitted it, right?
sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead, presumably because whoever sent them took them off the internet. So,
Kate Peter.
This would be some text from somebody with a link to a video or something else. And so you'd have the text, but not what the attachment is?
you'd have the
That's the judge. And you can see Bradle's head bobbing behind Fababio.
text, you'd have a link to a video.
I get it. Okay.
You click on the link now and nothing happens. Whether if Lieutenant Tully had clicked on the link 6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay. Gotcha.
Would have taken him somewhere, like a magical
Mr.
mystery
Bradle.
tour. And that is Olivia. And I love how after we play that little piece of the court document, my video comes right up. Oh, two of my videos did. Look, one on the left and one on the right. Olivia, did you make that happen too? She's my girl. Love that girl. Love that girl. This is fun. Clicking on hyperlinks is fun. Notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Ms. Peter, but sent them to Tully to review. Hold on, we got to click on that now, right? How do we not? I mean, how do we not click on that? Oh, it's redacted. Sorry. Not allowed to look at that. It comes up like a big thing that says redacted. That's okay. All right. I feel you. Well, we're not allowed. We're not allowed to see that. Sorry. It's redacted. And then, therefore, favorable evidence was in the Commonwealth's possession since 2023, and apparently it's no longer available for, well, now I'm curious about some of these other links that we didn't see about the colon, the stuff about colon. That's on page 8. It might be redacted also, so oh, it's not. Okay. So this is apparently the message that Kate Peter wrote to Aidan that is untrue. I've never seen this. So this is interesting to me. I don't know if all of you have seen this except for me. I don't know. So when they talk about Kate Peter, and the defamation of Aidan Colin Albert. Hold on. This is an email that Kate Peters sent under a different name to Aidan, and it says, "Hi, Sunday, May 28th, 2023. Somebody named Mia Rose. Hi, I've been really scared to talk to anyone about this, and I know I'm not the only one, but I see that you're keeping people anonymous, and I think it's important people know. The problem that Colin Albert had with John O'Keefe was that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs with Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop, and from what I've heard, the whole Albert family makes money from it. And I don't know if his Uncle Brian knows or not, but I think he probably does and explains what they are really covering up. I have screenshots of Colin selling drugs and stuff because sadly I have bought from him before, but I don't really want anyone to know that or know I said anything. Colin talked a lot about getting of John because Colin thought John had him under surveillance, but I don't know if he really did. He was also a huge part of bullying this girl, Erin Beatty, pretty bad. Shows what kind of person he really is. I really think what happened is he followed through with what he was saying about John. And then she attaches these fake messages. Do you need any pure? Got the power, the proper power. Chong, bit of flake if you need. Banging, bit of sniff in, can do deals too. About all night from 8. Same banging bit of pure stuff and skunk. Same bit of pure and skunk. Sour diesel plus pure will be about within the hour. And then Aidan apparently writes back to this person, Mia, and says, "Hi, Mia, you are safe here. I never reveal the names of sources. I'm interested in seeing the screenshots of Colin selling drugs if you'd feel safe sharing them." And then she did, because we just read them. Yeah, I saw that, Kel. I saw that. That's kind of weird, but okay. Did Colin ever say anything about John in writing? And what exactly did they do to Erin Beatty and why? So Kate Peter, when all of these rumors were flying around about Colin and the McCabe's and Alberts were blaming people for making up these rumors, they've got no one to blame except Kate Peter, who actually befriended all of them. So there's that. This is so twisted. It's so twisted. I mean, you can't script this. And he goes on to talk about why Aidan is prejudiced by all this stuff and that Kate Peter has doctored evidence against him at least on 2 occasions involving, for example, the one that we just first saw, and also the YouTube stuff that I told you about earlier. Mr. Mello also made himself a material witness when on November 5th of 2023, he, in his official capacity as Mr. Kearney's prosecutor, he called the police advocating on behalf of witness Chris Albert by seeking to have peaceful protesters assembled across the street from Mr. Albert's pizza shop charged with witness intimidation. Oh, okay. Well, hold on, because we have that video too. Let's go to the tape. Oh man, this is fun. So many of you are like, you haven't seen a lot of this stuff because there are many of you, I think, who have not been following Aidan Kearney and his journalism for years. And so this may be all new to you. So if all of these receipts are new to you and you didn't know that Memo called the police advocating on behalf of Chris Albert because people who were across the street from his mediocre chicken parm pizzeria were out there peacefully protesting. Here's the phone call. It's Young Jerks gets credit for this. And there's a hyperlink.
Speaking.
Yeah,
Yes, Sergeant, is that what you have?
Hold on.
Yeah, this line recording Sergeant Sylvester speaking.
Yes, Sergeant, is that what you have?
Who would you like to speak with, sir?
My name is Ken Mello. I'm a prosecutor with the Norfolk DA's office. Can I speak to your shift commander?
Well, I'm on duty right now. We have a lieutenant too. Well, how can I help you?
I'd like to speak to your manager.
Okay. There's a protest going on outside D&E. Would you mind sending a car down there just to make sure that they're
We'll take a look.
not intimidating?
And what's your name again?
My name is Attorney Ken Mello.
And who are you working for?
I'm the special prosecutor
Oh, okay.
regarding Aidan Kearney.
Got. All right. So the prosecutor, you said there's people outside D&E.
Right.
Okay.
Just have a cruise go by, make sure there's nothing.
We'll check it out.
Thank you very much.
Take care. Bye bye.
Make sure there's nobody out there intimidating him.
Roger. Hey, Mike. I got a call from Kenneth Mello. He's the special prosecutor, I guess.
686 has that. Let me know.
Anyways, there's some protesters out in front of D&E, so Zeph is going to take a drive-by.
Yeah, they can protest.
I know, we're just going to take a drive-by. Just get the attorney's voice. We just be sure we stop by, take a look.
Yeah.
So,
all right.
I'll catch you. Bye-bye.
You might have heard of the Canton 9 before. These are the Canton 9. 9 people across the street from D&E Pizza with signs. Mello calls Canton PD on behalf of Chris Albert and sends them over there. And these people, did they get arrested? They had charges. This was the Canton 9.
Slops.
Hi, Mr. Mello. It's Sergeant Sylvester. I just spoke to you. Oh, one second.
Yes, sir.
One second, sir. Roger. An officer swing by. I said there's 4 people like across the street holding signs. That they weren't right in front. They were across the street. They're not impeding traffic, but so it seems kind of mellow. A small group now.
All right. Okay. Very good. If they could just swing by there once in a while, I'd appreciate it.
We'll keep on making passes. You know.
Very good.
All right.
Thank you, sir. I appreciate it,
sir. Have a good day. Bye-bye.
You too. Bye-bye.
Canton Police Officer Nick's recorded line.
Hi, Officer Nix. This is Attorney Ken Mello. I believe I just spoke with your sergeant there. Is he still available?
He's not. He just stepped out. Actually, he's walking back in the room, sir. Hold on.
Okay,
let me put you on hold and I'll have him pick up, okay?
Thanks very much.
You're welcome, sir.
How can I help you?
Hi, Sergeant Ken Mello again.
No problem.
Do me a favor. Take a look at Chapter 268, Section 13A.
268.
13A.
He's telling him what statute to look up.
Okay. I'll go ahead and get a book. Oh, 1 second, sir.
Okay. You give me a call back if you want, okay?
Okay, yes, sir, Mr. Mello. All right.
Okay. All right. Thank you. Yes, sir.
Hey, Mr. Mello, Sergeant Sylvester. So, it looked up. So what do you want? What are you thinking of doing?
I think they're good enough to charge them, to be honest with you, at least this person.
Oh, really?
I mean, that's my take on it,
yeah.
You know, but it looks like they meet every single requirement of that statute.
Okay, so we just go up there. You want us to write a report and try to document who's there?
Yeah, if you could do that, yeah, please, if you can do that. I mean, check with your lieutenant. I don't want to, I'm not an officer.
I don't want to show a picture of the Canton 9 because I don't want to out anybody that doesn't want to be outed. So, I mean, all their charges were dismissed. It looks like in August of 2024. And so I don't want to do that. But if you want to see a picture, I'm sure you can Google it.
Your department. Mm-hmm. But I'm looking at that statute and saying they're across the street. They're certainly near Albert's place.
All right.
He's a witness and they're certainly there for purposes of influencing or whatever else the statute states. Yeah. They're not there for any other reason.
All right. So it's punishable by no more than a year in prison and a fine of no more than $5,000. So,
correct.
All right. So we can go up there. We can try to figure out. I mean, I think we could probably figure out a couple of them. Maybe not all of them where they are, because we can ask them and they can just tell us, pound sand, not tell them, and we try to find them, see where cars they go to or whatever.
Yeah.
And then I guess. We can go from there and just
sure. I mean, I don't know if you can reach your chief to see how she feels about it, or Okay, great. I appreciate it very much, Sergeant.
No problem, sir.
Thanks.
Bye-bye.
Bye-bye.
But who's pushing Mello around? Who's telling Mello what to do? Chris Albert? Like, this is outrageous. You should be outraged. And all of the receipts are hyperlinked in this amazing document. Let's keep going. So now you know why they were arrested. The Canton 9 was arrested because Ken Mello called Canton PD and several times and told them what statute to prosecute them under. And then, according to my Google search, the young judge did a show on August 16th of 2024 where the charges were dismissed for the Canton 9. But again, they had to pay for attorneys. It was a thing. Ridiculousness. Absolute ridiculousness. Mr. Mello must be disqualified pursuant to Rule 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. And then she even hyperlinks all of the cases. This court has disqualified Mr. Mello from prosecuting Mr. Kearney in docket number blank for the exact same reasons, and that's probably hyperlinked to the decision, which we've read. Accordingly, for the reasons herein, they should dismiss the indictments against Kearney, disqualify Mello, or in the alternative, order an evidentiary hearing on the motions because they've done all of these things to prejudice him intentionally. And then the next section is called the need to silence Mr. Kearney. On April 10th, 2023, Ms. McCabe and the Alberts learned that they were subjects of a federal investigation into the Commonwealth's investigation of Mr. O'Keefe's death and its subsequent prosecution of Ms. Reed. That's before Aidan wrote his first story. So Ms. McCabe and the Alberts knew they were subjects of a federal investigation before his first article. And they try and blame their harassment on him. Wow, that's rich. On or about April 10th of 2023, Colin Albert was served with a federal grand jury subpoena. That is a hyperlink to Bridgewater State University PD call number. I remember this, 81723. And they went to Bridgewater State to serve him with a subpoena to testify in front of the grand jury. On information and belief, on the morning of April 10th, 2023, Ms. McCabe was served with a federal grand jury subpoena. Sometime thereafter, Brian Albert, Mr. Proctor, Brian Higgins, Kerry Roberts, and others were served with federal grand jury subpoenas. On information and belief, Ms. McCabe was briefly interviewed by FBI agents on the morning of April 10th, 2023. Well, we remember because she lied to the FBI. And don't worry, because we have a hyperlink to that. It says, as detailed in her testimony at Ms. Reed's 2025 trial, Ms. McCabe told at least 2 material lies to the FBI. Motion to play that testimony from Jennifer McCabe trial 2. If you'd like to hear it, it's 22 minutes. Put a 1 in the chat if you'd like to hear it. I'll entertain the motion. I've got it pulled up so I can do whatever you want. This is the ice cream truck. The ice cream truck comes in. You might not remember, but April 10th of 2023. Okay, motion granted. This is before Aidan Kearney ever wrote his first article. That mug. Oh, that mug. Here we go. I'm here to refresh your memory. I mean, if you want me to speed it up, I will, but it's only 22 minutes of delight. So let's enjoy. Let's enjoy. Grab your popcorn, get your cocktail, get your coffee, whatever you need. Here you go.
You were contacted by another law enforcement agency that was not Massachusetts State Police and not Canton Police Department at one point in April of 2023. Do you remember that?
Yes.
I want to talk for a second about that series of interview or that interview. You were contacted at your residence by these members of this law enforcement agency, correct?
Yes.
All right. Later that same day, you did sit down with those same law enforcement officers for a formal interview.
On that
same day that you were contacted by them, they also went into your home and actually interviewed you, correct?
Yes, it was brief.
All right.
I mean,
There is no story.
wait a
there.
second. Sorry.
They walked up to your car.
Hold on. I mean, it's so interesting to listen to this again. I don't think I've ever listened to this a second time,
They were not involved.
but knowing that Alan Jackson has these bombs like in his back pocket, and the way he savors asking every question that he already knows the answer to is delightful. And he's not allowed to say FBI, so he has to skate around that a little bit. Here we go.
With Canton Police Department either, correct?
Correct.
Completely separate agency, is that right?
Yes.
During the course of that interview, those officers informed you very specifically, Ms. McCabe, that it is a crime to lie to them, even during an interview, correct?
Yes.
Those law enforcement officers informed you that they were investigating certain circumstances attendant to John O'Keefe's death, correct?
They were very vague on what they were.
Understood.
I don't know what they were investigating.
But you did understand that it was having something to do with your involvement at 34 Fairview on January 28th, 29th, 2022. As a witness or otherwise?
Objection. Sustained as to certain terminologies.
Sure. Let me see if I can rephrase that, Ms. McCabe. You were aware of the subject matter of their interview, right? They weren't interviewing about a car you bought last year, correct?
Correct.
They were interviewing you basically about what you're testifying to here, correct?
When I first spoke with them, the conversation was pretty vague.
But the subject matter, vague or specific, was about this subject matter.
Yes.
Okay, fair enough.
Thanks, Emmy, for gifting a membership.
They first contacted you telephonically, called you on the phone. Is that right?
Actually, they walked up to my car.
They walked up to your car?
Yes.
Okay, that was the very first introduction, correct?
Yes.
At that point, they had not identified themselves, correct?
They didn't know.
All right, and at that point, you told them that you were not Jennifer McCabe. They asked you who you were, and you said, I'm Nicole.
I thought they were like selling something. So I was like, oh, no, I'm not the homeowner.
Fair enough.
So instead you said you were Nicole, your sister? You tried to be your sister? Oh, man.
Fair enough. However, after you said, I'm not Jennifer McCabe, you walked into the house, they then called you on the phone.
Yes.
They were
Correct.
still sitting outside your house.
I don't know where they were, but they did call me.
They were close by.
I'm not aware.
Well, the call came almost immediately after you walked back in the house, correct?
I'm not sure how much time had passed.
The call is coming from inside the house. Remembers that movie? The call is coming from inside the house.
Give me an idea. It wasn't an hour. It was
No, it was
5 to 10
soon
minutes.
after. I'm just not sure. I can't tell you where they were located. I'm sorry.
Okay. They told you that they would, at that point, they identified themselves as being law enforcement agents, correct?
When they called me, yes.
And they told you at that time that they were not with Canton Police. You knew at least they were not with Canton Police Department. They were not troopers with Massachusetts State Police, correct?
Yes.
Okay. And they told you that they would like to have an interview with you. They'd like to have a sit-down talk with you, correct?
Yes.
You told them that you would be willing to submit to an interview, but you needed about 10 minutes to get ready, correct?
Yes.
You ultimately did allow them into your home, and you did sit down for a formal interview with them, correct?
Yes. Brief, but yes.
And it was during that formal interview inside the home that it was explained to you that it would be a crime for you to lie to them on any material issue, correct?
Yes.
During the course of your interview, your husband, Matt McCabe, came home. Is that right?
Yes.
As these law enforcement agents continue to question you, as law enforcement officers continue to question you at some point, you inform them that you did not feel comfortable with any further questioning and you suspended the interview, correct?
Yes.
Before leaving, however, those same law enforcement officers asked you if you had contacted anyone in those 10 minutes when you indicated, I need 10 minutes to get ready, between the time they called you and the time that they showed up and came inside your house, correct?
Yes.
You told them that you had contacted your husband, Matt McCabe.
Yes.
Which is why he came home, right?
Yes.
And you told them that you had called Carrie Roberts before they interviewed you, correct? At that moment.
I'm not 100% sure, but if you have it, it seems like something I would do, but if you have it, could show me.
Absolutely.
Mm-hmm.
Absolutely. Her first instinct is to lie. How's your day going, Jen? Hey, Jen, how's your day going?
I may have just a moment, Your Honor.
Okay.
She's panicking. Oh, she's looking at the jury. Look at the eyes. Ooh, darting around. Lally, help me. Oh, it's not Lally anymore. It's Brennan this time, remember? This is the second trial. She met with the FBI on April 10th. Turtleboy harassment. This is before Turtleboy even wrote his first article.
May I approach briefly?
Yes.
Wow.
First, I'm going to ask you, Ms. McCabe, if you recognize that as being a report of that interview, just generally. Yes or no?
It appears to be, yes.
May I approach the witness stand and stand by the witness stand for a couple of questions?
Yes.
Turtleboy. Harassment.
Direct your attention, if I may, for court and counsel, page 3 of 4, starting with the second to the last full paragraph, going into page
She looks
5,
terrified.
I'm sorry, page 4, top full paragraph.
Okay.
You could review those 2 paragraphs, read them to yourself, and then look up and let me know when you're finished.
Boy. Death by 1,000 cuts. She probably read this 100 times before, and now she's reading it. She's trying to think, what am I going to say? 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 No. Turtleboy wrote his first article April 18th, 2023. She was lying to the FBI. The FBI came to her house April 10th of 2023. So she's lying to the FBI before he ever wrote his first article, which makes it ring hollow when she says she got all of her harassment. She was harassed by everything having to do with Turtleboy. Boy, it's like the longest, 30 seconds ever. Steve says, the phlegmatic Bobby Bud Melman Cosgrove. Thanks for Super John. Thanks, Vicky Watkins, for gifting a membership. And Jen McCabe is still reading the papers, trying to figure out how to talk her way out of this one.
May I approach, Your Honor?
Yes.
Thank you. Thank you, Ms. McCabe.
Yes.
So this is the same day she
Review
served.
those paragraphs, refresh your recollection as to what you told those agents initially. I'm sorry, what you told those officers initially from that other law enforcement agency, about who you contacted in that 10-minute interval.
Yes, I told them.
And you told them that you had contacted your husband, Matt McCabe.
Yes.
And Carrie Roberts.
Correct.
I want to stick with that for just a quick.
Watch her face as she slowly realizes that the entire world is about to know that she had big enough balls to lie to the FBI. April 10th, 2023, the same day they served her with a subpoena was the same day of this interview, which again, something like 8 days before Aidan Kearney ever wrote an article on the Karen Reed case and the John O'Keefe murder.
Second, one of the first calls you made after being contacted by these other law enforcement officers from a different agency. One of the first calls you made was to Carrie Roberts. Is that right?
She was the first one.
That's what I'm asking. One of the first 2 calls you made, your husband,
Right.
come home, there's law enforcement outside my door, I'm guessing is what you said, correct?
I don't remember my exact words now, but I did ask him to come home, correct?
And
Yes.
Carrie Roberts.
Okay. Yes.
Okay.
You wanted to let Miss Roberts know that you had been contacted by certain officers from a different agency, correct?
I was curious if they had already been to her.
That was
Because-
my-
What did you
that was
tell
my
them?
next question.
yeah.
You also wanted to find out had these law enforcement officers from this different agency contacted her, correct?
Yes, because typically if
I
you
just
enter
asked
our
yes or no.
town, she's,
Ms. McCabe, yes or no?
oh, sorry, I was just trying to
That's okay.
explain. I'm sorry.
Is that why you contacted her, to find out if in fact they had contacted her before you? Yes or no?
Yes.
And you also wanted to find out what she told them, if she had been contacted by them, correct? That was your motive in calling her.
No.
So you just wanted to find out, had she been contacted? But if
Yes.
she had said yes, you weren't going to say, and what the hell did they say? What'd they ask you?
Well, I can't say what I would have answered, what I would have asked her, but I know I was calling to see if they had been there. Yes, that
was
is
your
correct.
that was your intent.
I called to ask her if they had been there. Yes.
So that was your intent. Yes.
Yes.
Okay. Your motive in calling Carrie Roberts at that moment before your interview was to ensure that your story would line up with her story, Ms. McCabe. Isn't that right?
No, that is not.
You wanted to find out if she had talked to these particular law enforcement officers and what she had told them, so that your story could somehow align, or it could inform how you responded to questions that they asked you. Isn't that true?
That's not true. We both know what happened. We don't have to have a story.
Oh.
There is no story. There's what happened, and that's it.
So if that's true, Ms. McCabe,
Mhm.
you have no reason to call Carrie and ask her if she had been contacted by these law enforcement agents. Because
Right.
it's just the truth, correct?
We're going through this whole experience together. We call each other about everything.
There would
That's
be no
nothing
reason
more
to
than
ask.
that.
So
I'm
let her
sorry.
let her finish her answer. Go ahead, Ms. McCabe, you can finish that.
There's nothing more than me calling and saying, hey, did they come to your house? That's what we did when the media showed up, when Miss Reed's private investigator showed up. We just give each other the heads up, hey, somebody's coming. Because we're just like normal moms. We're not used to this.
And that's helpful in
We're just like normal moms. That's where it came from. Normal moms.
making sure that the stories she tells are consistent with the stories you tell to different law enforcement agencies, correct?
No, we are not telling stories.
So let her finish. You said no what?
I said, no, we're not telling stories. We don't have to compare.
And if in fact what you were telling was just the truth, there'd be no reason for you to inquire about who's contacted her when. Would there? There'd be no reason.
There's no inquiring. It's like when you're when the ice cream truck was at the street next door and I'm saying, did the ice cream truck come? It's really that simple.
So
It's really that simple. It's just like an ice cream truck. This Chaka is up in the corner, but I think this is better. This is a special box of shut the fuck up cakes. Normal mom said no one ever. And she's looking at the judge like, Auntie Bev, can you help me? Can you help me? Can you help me?
you asked a question.
Not about an ice cream truck.
An ice cream truck.
argumentative Question. and
This
she
is
was
not about an
saying,
ice cream truck.
Next question.
Thank you. You also testified in your direct examination, staying with Ms. Roberts for just a second, about a timeline that you and Ms. Roberts put together, correct?
Yes.
That's another example of the two of you talking about your own perceptions and comparing and contrasting those perceptions and putting it down on paper, correct?
No, I
Okay, yes or no?
It's a no. Can I explain or no?
No.
I'm sure Mr. Brennan will have follow-up questions. After you gave that answer to those law enforcement officers at that separate law enforcement agency, they asked you, was there anyone else that you contacted in that 10-minute period before we got a chance to talk to you? And your answer was no, correct?
Correct.
And that was a lie, correct?
It wasn't a lie. No.
Was it true? Was it the truth or a lie?
It wasn't a lie.
Okay, so it was the truth. You had not spoken to any other person between the time they contacted you telephonically and you said, I need 10 minutes, and then they came in the door. During that arc of time, you didn't talk to anybody else or contact anybody else other than Matt McCabe, Kerry Roberts. Now you're testifying that was a true statement.
I can't answer that yes or no.
It's pretty binary. Had you talked, well, let me ask you this. In point of fact, you did talk to other people. You contacted others in addition to Matt McCabe and Kerry Roberts, correct? Yes or no?
Yes, I did.
Okay. So when you said no to the answer, did you contact anyone other than Matt and Kerry? That would be, by definition, Ms. McCabe, a lie.
You lie.
Correct?
No.
You lie.
It's not a lie. Is there some shade of lie that I'm not aware of?
It's the way you're asking the question. If
Okay,
I
let
could
me ask it a different
explain,
way.
if I could explain,
Let me ask it
it
a
will
different
make
way.
more sense to you.
The agents asked you, I'm going to go over this one more time, then I'm going to move on. The agents asked you, in fact, did you contact anyone between the time we called you and set up the interview and the 10 minutes before we walked in the door? They asked you that question, correct?
The objection sustained. Watch the choice of language.
I'm sorry. I meant the law enforcement agency. That law enforcement agency, the members of that law enforcement agency contacted you.
Wait, she just gave Brennan the death stare. Hold on. Look at that right there. Oh, my freeze game on point. Giving Brennan the death stare. Like, are you kidding me? You're allowing this to happen to me?
The members of that law enforcement agency contacted you. Sorry. They asked you who you had contacted between the time they first telephoned you and walked in the door 10 minutes later. Correct?
Correct.
Okay. Data point number one. Data point number two, you told them Matt and Kerry, correct?
Correct.
You had actually contacted, they then asked you, did you contact anyone else other than Matt and Kerry, correct?
Correct.
And you said no. Is that correct?
At that moment, I said no. Yes.
Correct. At that, or any moment.
No, at that moment, because they had just come in my house.
I asked you,
Only one person can talk.
She's going to cry.
you said the word no.
She
correct?
was finishing her answer. Finish your answer.
I had said no because I was in a situation where there are two.
We pointed this out at trial too, because we don't miss a beat. She was about to say, I'm going to be completely honest. I'm going to be honest with you. And because she's probably watched a million videos on how to testify, how to lie on the stand, or she's been prepped. Don't ever say, I'm going to be honest with you, because the next thing to come out of a person's mouth when they say, I'm going to be honest with you, is a lie, right? She's watched all the videos. She's probably watched Sergio Denaro's video, Truth Revealed. His channel is really good. She's probably watched the body language experts. She's very well prepped. She's had quite a glow up since trial one. She got some highlights. She got a spray tan. She's dressing in softer colors. She doesn't look as harsh. Her makeup is very natural. But she almost said, I'm going to be honest with you. Listen.
She was finishing her answer. Finish your answer.
I had said no because I was in a situation where there are two officers from a different agent had come in, were asking me questions, or they had said, can I come in and ask you questions? At first, I thought they were selling something. Then they identified themselves.
I want to point out to you that it's 9 a.m. when they're interviewing her. Do you really, is somebody really selling something at before 9 a.m. on your street? I don't think so.
I just dropped my kids off at school. Going to be completely honest. I hadn't brushed my teeth. So I kind of made some phone
Objection, Your Honor.
calls.
This is
That-
non-responsive.
so
I hadn't brushed my teeth. She had to throw that in there.
next question. Mr.
Thank you. Ms. McCabe,
Mhm.
after you said no, that you hadn't contacted anybody else,
Mhm.
those two law enforcement officers from that separate agency who had told you it was a crime to lie to them, they left, correct?
Yes.
Subsequent to that, Mr. McCabe, your husband,
Objection.
Sustained.
Why? Why are you objecting about
they left
anything
you their
having to do with
card
Mr.
so you could
McCabe?
call them if need be, correct?
Why? What? See, this is what pisses me off about them not being able to state the basis for your objection. The question was after that, your husband, Mr. McCabe, okay, what's the objection? Anybody give me a valid basis for that objection? And why would it be sustained? That's a weird objection. I don't get it. If anybody can give me a basis for that objection, please feel free to chime in. Let's play it back again. It's only about 5 more minutes left of this, but this is fun. I enjoy this tremendously.
Yes.
Subsequent to that,
Spousal privilege?
Mr. McCabe, your husband,
Objection.
Sustained.
But if Mr. McCabe told you or you said to Mr. McCabe, that would be objectionable under privilege. But something that they do, Mr. McCabe came home, that's allowable. Because he didn't say what Matt said. He said subsequent to that, your husband, Mr. McCabe, he never got to finish because the objection was sustained. So you cannot, until he finishes the question, that was Brennan, not Lally. It could be privilege, but only if it's with regard to what he told you. Your husband told you this, or you told your husband this. But your husband walked through the door, that would not be privileged, right? It would be an observation. So again, this is a good example of Judge Cannoni trying to help Spanky. It's not hearsay
they left you
because
their card so you could call them if need be, correct?
Yes, they did.
And you in fact did call them back, correct?
Yes, I did.
Without telling me the content of the conversation you had, did you have a conversation with Mr. McCabe?
Objection.
Sustained.
so the conversation is privileged, and you don't have to be accused of a crime to assert privilege. Somebody asked that question. I saw that fly by. The conversation would be privileged, but your husband walked through the door. That's not privileged. See what I'm saying?
Did you call them back and say, I'm calling you back because my husband told me
Objection.
that I lied to you and I better clear that lie up?
So sustained. Jurors, remember I told you before that only answers to questions are evidence? Be mindful of that.
Look at her
Next.
death
yes.
stare to the jury. There's McLaughlin. And they go. Oh, and there's Karen. Powder blue suit. Misty and Nutty smiling and helping her with the chair. And Erin is looking at the ceiling. Erin O'Keefe, like she would rather be anywhere else. Paul's looking at her like, sorry, I was messaging that girl on Facebook, sending her my shirtless bathroom selfies, and you're embarrassed in front of the whole world, babe. Do you think we could get back together? Can you let me move back in? She's looking at the ceiling like she would rather die than be there. Look at poor Erin O'Keefe. I don't know what their status is now, and I don't really care. But Peggy O'Keefe always has a face on, and she has a face on here too. She is shaking her leg. Everyone's having deja vu. And oh my, could the three of them look any more uncomfortable? And I think that's the only time Paul O'Keefe may have sat next to his mother in court. Do you remember any other time Paul O'Keefe sat next to his mother in court? There was usually always a buffer zone there. There was a buffer zone between Paul and Peg often. And I don't know if they ever, and Aaron's still looking at the ceiling. Sometimes people do that when they're trying not to cry. They look at the ceiling or look at a light or something to try not to cry. And people say, nope, that's the only time I ever saw them sit together. And then, yeah, eventually he did get moved to the back row. That's right, Elizabeth. Oh my gosh, this is like deja vu all over again, isn't it? Because he got moved, right? Because he used to be down right next to Karen, so he could stare at her the whole entire time. Yeah, pineapple slushy says they look like three strangers on a train. Weird. Let's use in the court. Oh, there's DePietro. Oh, Emily C did the best impersonation of DePietro at the roast of Turtleboy on Friday night at the Wilbur. It was fantastic. She came with props and everything. We played her rehearsal tape the other day. And here they come. Alan Jackson dressed in the nines. Sartorial splendor, pocket square. Chef's kiss. He is going to be on Billy Bush at 5 o'clock. I don't know for how long. But, Billy wasn't going to do it live.
Yes.
He was going to tape it. I don't know if he's doing it live.
You ultimately called these officers back, correct?
Yes.
And you explained to them that you had been untruthful with them, correct?
Listen, Turtle.
I explained that I had forgotten to mention a couple of people that I had reached out to.
You had forgotten. Is that your testimony?
Yes.
You had forgotten. You remembered Matt and you remembered Carrie, but you had forgotten the others that you had just contacted maybe 30 minutes before.
Yes.
There were 5 people that you contacted, weren't there?
I contacted Matt.
Let's go through them. I'm just
Yeah.
asking yes or no. You know them?
I know 4 off the top of my head.
Okay, let's go through them.
Okay.
You contacted your husband, correct?
Yes.
You contacted Carrie Roberts, correct?
Yes.
You contacted Peggy O'Keefe, correct?
Yes.
Then, Ms. McCabe, you contacted the district attorney's office, correct?
My witness advocate.
The district attorney's office.
My witness advocate who works for the district attorney's office.
Thank you, Ms. McCabe.
Yes.
And you also left out that you contacted Brian Albert himself, correct?
Yes, my brother-in-law.
For some reason, your brother-in-law, who's the 30-year Boston police detective, correct?
Yes.
And on whose lawn John O'Keefe was found dead or dying. Objection.
I'll allow that.
Correct?
Yes.
Allow it. Oh, that's good stuff. Ooh, that's such good stuff. And look, again, 2 of my videos pop up on the end screen. And in case you're wondering what this is, in the little corner over here. Oh, why is it not allowing me to make it bigger? It did before. Hold on. The little box of says, I baked you some shut the fuck up cakes. And there's a box, some chocolate. It looks like Little Debbie in the corner, and there's some chocolate cupcakes there. All right, back to the papers. We had a little side quest because we clicked on a hyperlink because this is going to take 2 days. We're going to do this again tomorrow for the whole day because it is so good and we need to click on these hyperlinks because we need to know more. And so then we already watched the testimony from the 2025 trial, so we can skip a couple of paragraphs about how she lied and said she was Nicole, and then she called Brian Albert and Carrie Roberts. Why do you think that she called Peggy O'Keefe? What do you think the purpose of her phone call to Peggy O'Keefe was? I'm curious what your thoughts are on that. So can you guys tell me why the FBI comes to her door April 10th, 2023? Why did she call Peggy O'Keefe to say what? In Lemonade is here. She says, we need to make a record. We met on Friday night, didn't we? Yes, we did. It was so nice to meet you. And I loved all of you that came up to me and told me your usernames because then I could totally put a face with the name. And that was awesome. To test the temperature, Jen and Toxic says. Damage control says Gray Space, Sarah Be Creative, triangulation. Script change says Mitchell. The virtual juror says the FBI is sniffing around, but we didn't do anything. Jessica to say the feds are asking questions. Nikki says damage control. David Reese said to see if the ice cream truck was there. Scott McGinnis says controlling Jen as she always did or does. D1111, how is Peggy not giving these people a major side eye? I don't know. Carla says to warn her. Peggy O'Keefe never got a subpoena to testify in front of the federal grand jury, right? And so Ms. 86 Scorp says to manipulate the information out of her. Marcy Cruz says wanting to see if they were still good. Yeah. To keep the story straight. Yeah, but Peggy was not ever, thought to be any part of this. So maybe it was just to see what Peggy knew, to continue the lies she's feeding Peggy. Yeah, Melissa says maybe to see if she had been visited by the FBI, to see if the FBI had said anything to her. Like, we're questioning, like we suspect that the McCabe and Alberts might be involved in this, like that. Right, booyah. Ask if the feds are investigating if Trump went into the house, AKA, did she hear anything? Hold on. Jenna, I like this. Jenna says to say the FBI is looking into Karen and probably lied about it being them. There you go. That's good. All right, here we go. So it's 9 a.m. at April 10th, 9 a.m. on Information and Belief. Immediately after Ms. McCabe called Ms. Roberts while the FBI agents were waiting to speak with her, a call Ms. McCabe lied to the agents about, Ms. Roberts asked Steve Nelson, the DA's victim witness advocate, blank. See what happens when I click on that hyperlink. I don't think I can. Yeah, it won't let me click on that one. It must be redacted. It doesn't let me click on it. So something underneath there is very incriminating to Jennifer McCabe. On April 10th of 2023 at 12:03 p.m., Ms. Roberts and Ms. McCabe, again, I can't click on that. It won't let me. 12:03. Okay, so 9 o'clock is when the FBI is waiting outside her door. She said it was really, really quick, right? Really quick. 10 minutes go by. They get into her house at 9:10. It's really, really quick. But then at 12:03, that same day, Ms. Roberts and Ms. McCabe, what? Had some kind of communication, and it's all redacted. It's all redacted, and we don't know what it is, but I can't wait until it's unredacted. But okay, wait a second. I misunderstood something here. So after Jen McCabe called Kerry Roberts while the FBI agents are outside, Kerry Roberts called the victim witness advocate or asked him something that is redacted. So it's not Jen McCabe that reached out to Steve Nelson. He's the victim witness advocate. I'm having redaction distress too. So Kerry reached out to Steve Nelson and said something interesting. And then at noon, there's some communications, I imagine, between Kerry Roberts and Jen McCabe that say something that we can't know right now. And then Ms. Roberts did something else that we can't know about. But after that redacted part, there's a footnote number 3 that says Ms. Roberts did speak to the FBI. As revealed in her testimony at Ms. Reed's 2025 trial, she repudiated her 2022 grand jury testimony, where she falsely swore that she heard Ms. Reed ask Ms. McCabe to Google how long to die in the cold sometime after 6 a.m. on January 29th of 2022. In 2023, after being read 18 USC 1001 warnings by the FBI, Ms. Roberts admitted she didn't hear Ms. Reed ask Ms. McCabe to make the Google search. Mysel says, no, Jen called the advocate too. According to Jen, it was just Carrie asking whatever this question was. Right. So both things happened. She called him within the same time frame that she called Carrie, and then Carrie called him too. Yeah. Yes. Turtleboy does have an unredacted version of this. Oh, and then there's a hyperlink to Carrie Roberts' testimony, but that's 3.5 hours long. We don't have time for that. Ain't nobody got time for that. On April 12th, 2023, just 2 days after Ms. McCabe had been rattled by the FBI, Ms. Reed's defense filed its lengthy motion, which, among other things, alleged that significant and reliable evidence implicated her and Brian Albert in Mr. O'Keefe's death. And that's an affidavit of Alan Jackson filed in support of the order to get Brian Albert, Verizon, and AT&T records. Yeah, this went all the way up to the SJC when it was denied. And that's a lengthy motion. Ms. Reed's motion accused Ms. McCabe of Googling Hosslong to die in the cold at 2:27 a.m. on January 29th, 2022, and alleged that other data demonstrated that Mr. O'Keefe was inside Brian Albert's house when he died. Ms. Reed's defense further alleged that A, it had uncovered significant evidence that Ms. McCabe had taken affirmative steps to delete and tamper with evidence, and B, it had a good faith belief that Brian Albert had taken affirmative steps to destroy evidence. Suffice to say that between April 10th and 17th, 2023, Ms. McCabe and the Alberts had strong reason to be concerned about their legal situation and the adverse impact on their public reputation that would result from media coverage of scrutiny they received from the FBI and or from the Reed defense's allegations of their complicity in Mr. O'Keefe's death. Footnote 4. Ms. McCabe was concerned with being publicly associated in any way with Mr. O'Keefe's death. On January 30th of 2022 at 8:06 a.m., and this is the same day that John O'Keefe's body was found, she Googled BPD and John O'Keefe. On February 1st of 2022 at 11:23 p.m., she Googled John O'Keefe. On February 2nd, 2022 at 10:54 a.m. in a text message to her daughter, blank, she said something else. February 2nd, 2022 is the day Karen Reed was arraigned. She was not arraigned, I believe, until later in the day, in the afternoon, something like, tell me, chat, because I could be conflating the two arraignments because she was arraigned once in February and then another time in June. What time was her arraignment on February 2nd, 2022? Because she texted one of her daughters at 10:54 a.m. And she did testify that before she willingly turned over her phone around this day, she was allowed to delete all the communications with her daughter. And, the internet or these things don't disappear forever. So whatever it was that she deleted has been recovered. 10 a.m. Okay. So this was after Karen Reed was arraigned. If she was arraigned around 10 a.m., 10:54 after the arraignment, she sent her daughter a message. And Melisa says maybe she sent her message to her daughter to see if she was shown on the newsfeed at the arraignment because she was there. She texted after she came out of court. Well done, well done. Because of course, when I click on it, I can't because it's impounded. But what's not impounded is the Google searches of Jen McCabe, which we can look at right that are mentioned right here. January 30th at 8:06, she Googled BPD and John O'Keefe. Let's take a look. This is called the Jen McCabe Googling herself exhibit. Oh, the Raining Men search. Remember the Raining Men search? Let me get my head out of there. So at BPD and John O'Keefe on January 30th, 8 a.m., Apollo Pizza, Canton High School, John O'Keefe, 2122 at 2323. John O'Keefe obituary, 2222. And then she Googles herself, Jennifer McCabe. Shortly after Googling John O'Keefe's obituary, I guess to see if she is in any way connected to the story yet. I don't know. Some people might call that consciousness of guilt. I'm just pointing that out. On February 2nd, 22 at 11:37 a.m., Ms. McCabe Googled Jennifer McCabe. Despite their concern with being mentioned in the growing media coverage, less than 72 hours after Mr. O'Keefe's death, Ms. McCabe and Ms. Roberts did a whole bunch of stuff that is completely blacked out. What did they do? I don't even want to guess. I really just want to know. I'm really nosy. What did Jennifer McCabe and Carrie Roberts do less than 72 hours after Mr. O'Keefe's death? What did they do? I'm sorry, what? Club P. I'm very capable of making my argument if attorney Melanie Little prefers to ignore the elephant in the room. Oh, well. I'm sorry. I have no idea what you're talking about. I have almost 7,200 people chatting. So if you had put something in the chat when I'm reading a document, I'm not going to see it. If you'd like to put it in there again, I'll stop the class and wait for you to put it in. I don't know what elephant you're talking about in the room. But if you'd like to put it in there again, we'll all give you the attention that you so desperately deserve or desire. Yes, the judge can see the redacted part, and Cosgrove can be the redacted part, can see the redacted part. Just the public cannot. That is something that is publicly not available. Hang on. Troll. Oh, that's so funny how, like, because I have it set to I don't know how many hours, and then they just, wait 5 hours to be able to come in and troll. Oh, here it is. Here's the argument. Here it is. Because I'm able to see every comment this person ever made, and there's only 3 in the entire history of this person subscribing to this channel. It's 24 hours. This person waited a whole 24 hours. The elephant in the room, he says, is Karen Reed case is nothing compared to the government silencing Jimmy Kimmel. Really? Is that the elephant in the room here? Because I'm not here to talk about Jimmy Kimmel. I'm here to talk about Aidan Kearney's case. So there's no elephant in the room because that's not what this stream is about. And quite frankly, Mr. P, I really haven't even followed up on the Jimmy Kimmel story because I'm so neck deep in so many other things that I'm covering right now. So thanks, but it's not the elephant in my room because I haven't even looked at it. I don't even watch late night television. And that's not what the subject of this stream is. But that is kind of funny. I mean, it is kind of funny. Jimmy Kimmel's the elephant in this room. I really don't. He got fired or he got suspended. Like, I don't even care. That's not the elephant in my room. Oh my God. People who need people. So weird. It is funny, right? It's funny. You just got to laugh. You got to laugh. On April 18th, 2023, Miss McCabe and the Alberts' concerns were amplified when Mr. Kearney, citing the publicly filed defense motion and exhibits as his primary source, blew the lid off the Reed case by publishing his first Canton cover-up article. Ain't that the truth? After Mr. Kearney posted his first story about the Reed, I wonder if I click on Hyperlink Exhibit A. Will it take me to the Jimmy Kimmel story? Because apparently that's the elephant in the room. That is the elephant in the room. Melanie can take a side, period. First Amendment or no. I just told you I haven't even read the story, dude. Dude, I have not even read the story. I yesterday was busy all day driving in my car. I haven't even looked at the story. So I'll take a side. You know I'll take a side. I do not sit on a fence because the only thing that happens from me sitting on a fence is I get splinters. And there is nothing more annoying than a splinter to me. So after I get the opportunity, with your permission, of course, Club P, I will be happy to take a side for you and your elephant in the room. But really, do you think you're going to come on and troll me into like taking a side on something that I have not even read one article about? I don't know if the guy was fired. I don't even know what he said. I have no flipping idea. So don't give attention to the trolls. No, I do, because clearly these people need to be called out because they can't allow this behavior. We can't allow this behavior to continue. Oh, he says, call me troll. Obviously not working with the brain trust. I don't even know what a brain trust. I don't even know what that means. All I know is that you are in the wrong place. You're in the wrong place. This is not the place for you. Seeking attention really is real. Hold on to your pee, Mr. Cup. And enjoy Block Island because it is so lovely this time of year. But it's funny every now and then. You are the weakest link. We are now. What do they used to say on Survivor? We are snuffing out your torch. And Elaine is here. She's like, "Hey, Kate, leave Melanie alone." Oh, Elaine, I love Elaine so much. Elaine is so amazing. It is. Kate would be Kate would not be talking about an elephant in the room or anything to do with Jimmy and Kimmel. She would just come in here and straight up attack me. And I don't know where she is, but I'm starting to wonder if she's like in jail because she has been so quiet out there that it's weird. Yeah, read the room, Club P. The tribe has spoken. That's it, Patriotic. The tribe has spoken. The tribe has spoken. We are going to snuff out your torch, or they put out their torch or whatever. The tribe has spoken. Club P. Peace. No, the only problem is that trolls thrive on attention. No, it's just listen. Oops, where did I go? I went somewhere. Back to me, Carolyn, come back. That's funny. Listen, I mean, if the person is that sad, if their life is so sad, if their life is, you are the weakest link. If your life is so sad that really you're just looking for like 3 seconds of attention from a girl, a lawyer screaming into her mic on the internet, on the tubes of you, and their life is that sad that 3 seconds of my attention will make them happy. Who am I to deny them? Who am I to deny them? Really? After Mr. Kearney posted his first story about the Reed case, the DA sought to muzzle him in response to numerous complaints from Ms. McCabe and the Alberts, who had substantial access to and influence with the DA. Oh, yeah, we know. They were on speed dial. Ken Mello calling up about the Canton 9. We just heard it. And that footnote says Brian Albert was a longtime Boston police officer who had a personal relationship with Canton Police Chief Ken Berkowitz. His brother Kevin Albert was and is a Canton police officer. In April 2023, Chris Albert had recently been elected to serve as a Canton town selectman. Members of the Albert family had a personal relationship with Mr. Proctor. Yes, we know. Ms. McCabe had personal relationships with members of the Canton Police Department who were involved in the Reed case. And that is true. And since Mr. P Cup, or whatever that person's name was, Cup P Cup, P in a cup, doesn't really seem to understand the First Amendment, let me just explain something to you. Your right to freedom of speech is one such as that the government cannot incarcerate you for things that are considered freedom of speech, but you do not have the constitutional right to a job. And so therefore, if you say something that your employer deems offensive or something that your employer doesn't like, you can be fired from that job. And I'm assuming that's what happened here. I don't really know. Like I said, I haven't really looked at this. And so while whatever it is that Jimmy Kimmel may have said on his show does not subject to him to criminal charges and arrest, his employer has the right to say, we don't want you working for us anymore, and fire him. Okay. There could be some civil actions. Maybe he's got a contract, but there's always a morals clause, by the way, in these Hollywood contracts. So if you do something immoral, they have the right to fire you and not pay you on your contract. We see that happen a lot. And so what happens is the First Amendment protects you against the government arresting you and throwing you in jail for saying something that you have the right to say, which is exactly what happened to Aidan Kearney. Do you see the difference? The elephant in the room here is you not understanding the obvious difference between some of these teachers that are getting fired from their jobs for things they are publicly declaring on the internet because it's not a good look for the school or whatever, and somebody being incarcerated for saying things or hurting people's feelings that they are totally entitled to say under the U.S. as such, Constitution of the United States as such, of America as such. Okay? Because we do have the maps, and the maps we absolutely know are the maps of, as such, the United States of America and as the Iraq. And if anybody knows what that's from, move on, please. Oh, you must be new. Oh, you must be new. You must be new. But at least you've been here for 24 hours. So peace. The quickest way for me not to move on is to tell me to move on. Okay? Moving on. On April 20th of 2023, no doubt concerned about the viral dissemination of Mr. Kearney's article. Oh, and here I have a special treat for you. It's up in the right-hand corner of your screen. And its detailed exposure of the Reid defense motion. Ms. McCabe did something that is also redacted, but it's in Exhibit B. But I'm pretty sure that I cannot get to Exhibit B. No, I can't. April 20th. So this is 3 days after his first article. Ms. McCabe did something, communicated with someone, because all those communications are now impounded, under seal, sealed up, locked up tight, in the vault. We can't see this. So there's that. I want to know, what did she do? Who did she talk to? What did she say? Are we ever going to know? I'm really dying to know. That's my elephant in the room. What did Ms. McCabe do? Who did she contact on April 20th, 2023? And what did she say? Because it's explosive, because it's redacted. On information and belief in response to Ms. McCabe's blank, I don't know, phone call, text messages, email, which would become a constant refrain. Oh, can you get Kearney to stop blogging about me? Can you arrest him? Can you throw him in jail? I'm just spitballing with you. Elaine says, Melanie, can you hold the paper up to the light and see if you can see through the Sharpie? Oh, Elaine, those are the olden days of the Ditto and the Xerox machine. I wish I could. She's telling me. Dang, she was screaming, do something, do something. Oh, look, the Canton ice cream truck is here. I love when the ice cream truck comes. You ring that bell. So some of the ice cream trucks nowadays have the creepy clown music, which I really don't think is something that kids want to hear. Smelling the mimeograph, yes. Mitchell just got spitballs on his screen. Queen Frosty says, you need an honorary Massachusetts plaque. God love you for diving so deep into the mess. Congrats, Mel. Thank you. Music to my soul says, I think music can feel good to the soul too. Yes, it absolutely can. You know me. I mean, look at my posters. I'm all about the musics and the concerts and buying the tickets. Trixie says, where's Auntie Bev to go after these people for deleting evidence that they were obligated to save for discovery? Well, it's not up to her to go after them. First of all, she's been demoted to civil court in Plymouth. And second of all, it's up to the DA to bring charges. Third of all, This case is in front of a different judge. It's in front of Judge Doolin. We like Judge Doolin. Mrs. Bederow. And Auntie Bev had her opportunity in the Karen Reed case to have an evidentiary hearing about all of the mysterious video that surfaced after this first trial, all the Sally Port video that was hidden, the inverted video, and she didn't do it. She didn't do it. She didn't allow an evidentiary hearing. She had her chance. She didn't do it. And she will go down as being, I don't know, fill in the blank. Thank you, Trixie, for your $25. Josh says, Peter and Tully were working together, so wouldn't they be solicited links? Yes, of course. That's why Cosgrove's argument in open court was so stupid. Mike B from the 413 says, have you heard Chris's most recent actual 911 call? Maybe in passing, but I'm not really. Was it something he was calling up, complaining about somebody being out? No, I can't really speak to that. Mike B from the 413. Thanks for the deuce. Mitty says, just want to let you know, Jason Broyles doxed me on January 16th, which stemmed from criticism of what he allowed to happen to you. Oh, sorry what it did to you and for handling it with grace. Well, I'm sorry that you're all the way in Canada and that happened to you. And is that Anna Kendrick in your profile picture? I can't see. I'm sorry that happened to you. I listen, it's so hard to control other people's behavior, as you can see by the people who actually wait 24 hours to go here and say like dumb stuff. I'm sorry that happened to you. Libra Lady 1214 says, I miss AJ and the team. Mel, are you going to cover his upcoming case? I'd also like to get a membership. Well, Libra Lady 1214, if you're looking to have a gifted membership, it's not up to me. YouTube does that randomly. When people are kind enough to gift memberships, they are randomly distributed. You have to be somehow opted in to accepting gifts and also be participating in the chat. If you want to join for a monthly fee, I think the $3.99 is like the lowest tier of membership. The link is in the description below the video. If you have an iPhone, you have to go into Chrome. It's like a whole thing. You have to go into Chrome. Don't do it from your app. I don't know. iPhones do not play well with YouTube because YouTube is owned by Google. See how that works? And also, I will cover his upcoming case. However, none of that's going to be televised because California, and they've kept the cameras out so far. Court TV did run a little piece on it the other day, but none of it was from inside the courtroom, or maybe something very, 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 very little. So I'd like to cover it. The other problem with that Frazier Bohm case is it's nearly impossible to get documents. I actually was in contact with someone who went to the Van Nuys courthouse to have them pull the file because you can't order the documents online. You have to physically go to the courthouse. It's in Van Nuys. And she went there only for the clerk to tell her, oh, sorry, we only have one public computer terminal for you to like print up documents and it's broken. So unless somebody's got documents on Frazier Bohm, like the accident reports, the investigative reports, it's going to be very difficult to cover that case. So there's that. Elaine says, did you see that Court TV will have a pool camera in the courtroom for the upcoming civil trial, September 22nd? Is it going to be specifically for the hearing next week? Or are they saying we'll cover it when it goes to trial? Because that trial could be 2 years out. I want you guys to like just know that the wheels of justice in civil court turn very, very, very slowly. Of course, I will cover it if they're going to cover the hearing. It's not even a hearing. It's probably just a status conference and it's going to be super boring. But you never know. There could be something explosive if Alan Jackson shows up. He could have things to say and stuff. And, you know, he's never met a camera that he doesn't like. So, of course, if they are going to televise that hearing, which is on Monday, I will cover it. It's at 2 p.m. Plymouth Superior in front of Judge O'Shea. At least that is what my internal calendar says. So of course we will cover it if they're going to be in there on Monday. So, thank you, Elaine. West Virginia country guy says, if she didn't need to know what Carrie said before she spoke with the officers, why not just call after instead of making them wait for her to call? Right. Right. Listen, they got to keep their story straight. These are the two that had a timeline, a written timeline that we never got to see. And the scribe of that timeline was the sister. What was her name? Denise. It was Denise who was the scribe, right, of the timeline. Nobody ever called Denise in. Nobody ever showed us an exhibit of the timeline. Getting those the headache where you have like ice picks on the side of your temples. Must be the elephant in the room throwing ice picks at me. Hold on. So I think that it was, did you talk to the FBI yet? Because we got to keep our story straight. Maybe, in my opinion. Libra Lady 1214, I want to kick and scream at my phone again at Beverly. Thank you. Tyler L says, my sincere condolences to Catherine Smith on her loss. Oh, you're so sweet. I lost my son last year. He took his own life. I'm so sorry. The pain never goes away. But I too used Melanie's channel as a distraction through these difficult times. Well, you guys are awesome. And nobody should ever lose a child. That's not the natural order of things. That is not how things should happen. I am so sorry. I can't imagine the anxiety and the what ifs and the guilt that you must feel, even though it probably has nothing to do with you and there's nothing that you can do to prevent that from happening. And I'm so sorry, Tyler. I'm so sorry. Thank you for your super chat. Texas Prime became a member. Welcome. We coming. We coming. That's what Coach Prime says about the Buffs, but so far they're not coming very far because can't seem to win a damn game. Go Buffs. Didn't Karen Reed testify? She called the witness advocate about replacing the cameras. Oh, Carrie Roberts. Whenever I see KR, I think Karen Reed. Carrie testified, yes, that she called the witness advocate about replacing the cameras at the O'Keefe's home. Maybe Gemma K panicked and told Karen Reed to Carrie Roberts to call and ask. No, because I don't think that those cameras were replaced until a long time after that, but I'm not sure. I'm not sure, but yeah, you know what? I don't know. I don't know when those cameras were replaced. I have it in my head that it was later on. That was later on when they were reconstructing, like when ARCA was in there reconstructing the accident. I mean, not ARCA, Aperture. The Aperture people were reconstructing the accident between Karen Reed's car and John O'Keefe's car in the driveway, but I don't know. But listen, I think also Carrie Roberts testified that she called that guy like 150 times or something. If anybody knows the number of times that Carrie Roberts testified that she called the witness advocate, remind me. Because it was a lot. Thanks for your super chat. Boston to Banger became a YouTube member. Welcome. Mello's Wetting the Bed with WHETTING. That is fantastic. Mello's Wetting the Bed. You whet my appetite with your username. Is it illegal to unredact stuff if they screwed up with the process? Not saying that happened, but I'm super curious about what is blacked out. No, but eventually this stuff may come to light. Right now, the protective order is in place. For what reason other than protecting the people who did this stuff, in my opinion, but it may be lifted at some point by the judge. But for now, it's in place. And Bederow did not want to wait until the protective order was not in place anymore to file this mega motion. And so the mega motion is done, and we got to do what we got to do. We got to do what we got to do. If the judge says redact it, we got to redact it. Olivia spent a lot of time doing this and hyperlinking it. And I'm super curious too. I am nosy as hell. I want to know all of it. And Lola says, thanks to Mel, I now often ask myself, WWCD, what would Cardi do?
Hello.
Hello. Hello, I'm here.
I'm sorry. It's never going to not make me laugh. And then people are like, I can't believe you even play that. She's such a mean person. I don't know. I don't know her. All I know is that she entertained us for a couple of days when we watched her trial. I don't like her lyrics. I think they're dirty. I would never let my kids listen to them. But I thought that part was funny. Shoot me. I mean, don't. But Melanie Little's left swipe to Club P has changed her name to fit the day. I need to be Melanie Little's left swipe in StreamYard because that happens sometimes when I'm getting excited about documents and I just swipe myself right out. And she threw in a buck there just to tell me that she changed her name because she's hilarious and you're all hilarious. And then we all have a similar sense of humor, which is why we all get along. Why can't we all just get along? Marianne says, when will we ever see the blacked out words? Yeah, if ever, they absolutely unseal, unimpound. We go to unimpound town, babe. I'm ready for it. I'm ready for it. I'm going to give Nurse Kim all the credit for the phrase unimpound town because that was all her. So we will eventually, hopefully, unless they drop the charges, in which case maybe they wouldn't, but I don't know. I want to see it. It makes me laugh every time too. Justice is my bias says Melanie Little sees trolls and attacks with comebacks that smack them right back. Her humor is precise like a legal device. She leaves them online eating her facts. Oh, I love that. Can I put that on a shirt? Justice is my bias. Love that. Well done. Emily had a good comment that I saw fly by. Hang on. We needed Cardi B's trial as a little palate cleanser. We needed it. Emily says, I think the reason Kerry made a big deal reaching out about the cameras was to imply that Peg was being harassed and needed a new system. Or maybe there was something on the old system they didn't want anybody to find. I don't know. I don't know. Hold on, we got another name change. Another name change. Club P's elephant is here. Cardi B wants Melanie's BS button. Cardi Club P's elephant. Thank you, Club P, for the entertainment today, because you have made a spectacle of yourself just like you wanted. And Owling Dog says, the system was changed after John. I love it. Emily says, can someone please change to Mr. P, PEA in a cup? She's not doing it. Emily's not doing it. I mean, should we play a little Emily? Should we play some Emily right now? Emily, did you put the Bradle stuff on your is it on your YouTube or on your Twitter? Because we need at least another full day to get through this. And we're only on page we're only on page 20 out of 88, and this is so fun. So let me just finish this page, and then we're going to play a little Emily for you. We're going to do a little Emily as Bradle and the mean witch in Club Salem, the one who sits in Salem Superior Court. Club B is getting on the ferry with the elephant now. Oh man, this is so good. You guys are so good. You're so good. What time is it? Let's see. I mean, it's only 3:11. I mean, this is only 5 hours and 11 minutes, right? We need an Emily C break. I mean, this could be like a whole series. We could do this hyperlinking stuff because it's so much fun to go back and rewatch. It's so much fun. Oh, Tom CPU is streaming the vigil for Charlie at Boston City Hall. That's very nice. For those of you who want to join, Tom CPU. Tom CPU, I don't know where you live, so I don't know if you're going to be going to like the Kelsey Fitzsimmons and doing like the outside the courthouse stuff, or if you're going to be going to. Emily says, this is why the cupcakes are my favorite people on the internet. I got to hug Emily at the roast that we both took part in of Turtleboy, and it was the first time we ever got to meet in person, and she is so amazing. And we bonded. All right, so Ms. McCabe did something that we can't say. And then on information and belief, in response to Ms. McCabe's blank, I guess her email, the DA publicly stated it would disprove the Reed's defense allegations about the timing of Ms. McCabe's Google search. Oh. Make them stop talking about my Google search? Exhibit C. Well, I mean, I got to see Exhibit C now. Is it the hostage video? No, it's an article from Boston 25 from April 19th of 2023. Prosecutors say they will disprove explosive allegations by a Massachusetts woman who said she was wrongfully charged in the death of a Boston police officer last year. Wow. When Jen McCabe says jump to Michael Morrissey, he says, how high? Quick, let me call Boston 25 and get them to write an article about how we're going to disprove it. And then they went out and hired, what's her name? Jessica. Notwithstanding the DA's attempt to triage the metastasizing scandal. I mean, I don't even know if I can pick my favorite quote today so far. Notwithstanding the DA's attempt to triage the metastasizing scandal. This is like the finest I am clicking all the links, babe. Girl, everyone tag Olivia in your post and tell her how amazing she is and how much fun we've had today. We're only on page 20 because we read the memo of law first that didn't have hyperlinks. And now we are relishing every bit of testimony, every document, everything we can get our hands on. You have blocked us from some of it, but that's okay. How long do you think that it took Bederow to come up with the phrase triage the metastasizing scandal? That's Hollywood writing right there. By publicly defending Ms. McCabe, things continued to get worse for her and the and the Alberts by the day. I mean, just kept getting worse and worse and worse. Mr. Kearney's reporting led to Ms. Reed's modestly attended court appearances becoming newsworthy events, overflowing with supporters and media. Her support became so great that before both of her trials, the court ordered that a buffer zone be created to prevent jurors from being exposed to and influenced by Ms. Reed's vocal supporters. Footnote 6 says, although the DA literally responded to the April 2nd, 2023 defense motion, Ms. McCabe didn't demand that the DA do something. Oh, it must have said, you better do something about that little turtle. Listen, turtle. You better do something. Until Mr. Kearney's reporting emphasized her Google search and implicated her in the cover-up of Mr. O'Keefe's death. The DA's knee-jerk defense of Ms. McCabe occurred weeks before it hired a digital forensic expert, which occurred on or after May 7th of 2023. Well, that's really not that far. I mean, May 7th, he started reporting. April, 18th, 17th, 18th, 30 days. Has to remember, it was just those 30 days in April. So, 13 days plus 7, like less than 3 weeks later, they're going out and hiring Jessica Hyde. May 7th, the day DA Marcy excitedly instructed his team to hire Jessica Hyde because she anticipated an opinion that might support the DA's position on Ms. McCabe's Google search because of a possible time zone issue. Well, doesn't time drift after all? And of course, wouldn't be complete unless we go to the hyperlink. So let's do that. And then let's share the screen and go here to Mr. Marcy's email from his official email. May 7th, Sunday, May 7th, 2023. Wow, he's working double overtime. Do you think he's charging time and a half for a Sunday morning email on behalf of protecting Jennifer McCabe? Sunday, May 7th, 9:01 a.m. He's up early working for the McCabes and the Alberts. From his official email to Brian Tully, CC Adam Lally, Proctor Michael, Lynn B. Land, subject Digital Expert 2. Attachments, Exordia rate sheet with law enforcement discount sheet. Oh, and it says, hire her immediately. Micah Marcy, District Attorney. Oh, but before that, sorry. I got to read from the bottom up. Oh, there's a lot, but it is first. May 5th, 2023. I guess Tully reached out to Jessica Hyde first. We are identifying experts. Hi, Jessica. He just says, hi, Jessica. He doesn't say Ms. Hyde. He doesn't say, hi, Jessica. We are identifying experts that can take a look at some data, write a report prior to May 25th, and be available for the trial in the distant future. It's 2023. We have a murder case where the defense is alleging many things, including a police cover-up and attributing parts of his conspiracy to cell phone data obtained from a witness. Long story short, we downloaded the phone when we got consent over a year ago. We ran it through Celebrite and provided a copy of the report to the defense. Fast forward 1 year, and defense asked for the raw data, which we provided. When their expert ran it through Celebrite, PA parsed out a wall file with information of internet history. That wall file was not parsed out in our original report. Not a big deal. Celebrite has updated PA in the interim. Remember, they said that they updated their software just because of Jennifer McCabe? We can deal with that issue. The reason I'm reaching out is what was found in the wall file. There are a series of entries with timestamp of 0237 hours in the wall file, one of which is a Google search of the phrase "Haas long to die in cold," spelled the same way in the file. A check of the Knowledge C database shows a Google search of Haas long to die in cold at 0635 hours. The witness had told us about that Google search, which she conducted at the request of the defendant shortly after the victim is found dead, covered in snow. I'm sorry, did she tell them about it? Did she tell them about it? Because that's not in any of the original 4 or 5 witness statements of Jennifer McCabe. And it was 227, you're right. But he's got in his email 237. I read it right. He wrote it wrong. I don't think Jennifer McCabe told them that. I think the defense team found that, and then she had to admit it. But I could be wrong, but Elaine says no, she did not tell them. I mean, she did call back Lank and say something like, "Oh, I forgot to tell you that she said, I hit him. But she never said, I forgot to tell you that she told me to Google how long does it take to die in the cold." Right? And Emily says, what's stopping Brian Walsh from using that version of Celebrite and saying he watched a horror movie in November and Googled all those while watching it? Right. It came in the TUI dump. That's right. That is right. That's when it came out from the feds. Thank you, Kooky Carolinian. Yeah. It came out in the TUI dump. She did not. No, it didn't, because this isn't, wait, hold on. Now I'm so confused. This is in 2023. When was the TUI dump? The TUI dump was when I was already covering this case, I pretty much think. And that was 2024. February 2024, right? So this is before that. All right. Olivia says, Jen told Trooper Kathleen Prince in her February 2nd interview, but she said it occurred in the back of a police car, which became a problem when she learned of the dash cams. Okay. So she did tell Kathleen Prince that. That was one of like the 5 original interviews. Okay, good. Thank you, Olivia. We have since learned a lot about the wall file. Our belief is the wall file timestamp is associated with the creation of the file and not the time the Google search occurred. I have digital forensic people who work for me who helped research that topic. The reason I'm reaching out is that the DA's office is in search of an outside expert. Given the allegation of police corruption and the deep dive nature of the explanation, we need someone on the books who is not my sworn personnel. Oh, because, you know, he's looking at Trooper Paul going, yeah, I got to get a guy. I got to get a guy who's got a little more credibility than Trooper Paul and or Garino. We need someone on the books who is not my sworn personnel. We have an evidentiary hearing on 5/25. We're looking for an expert to review the data and provide a written report. For the purposes of the 5/25 hearing, my guy would testify and the expert report would be used to support his testimony. I would imagine come trial time, we would need the expert to testify. If this is something, is this something you'd be interested? If you would like to talk, my cell number is, oh, damn it, you redacted that, Olivia. XOXO, Detective Brian Tully. Oh, and then Jessica writes back. Brian, oh good, she's not calling him Sergeant, Detective, Lieutenant, or anything else. Brian, hi, I just received your message. How can I help? Oh, so maybe he called her, and then she emailed, and then he emailed her back, And then they go back and forth. And then she says, Brian, happy to help with this. What kind of image do you have? Is it a full file system? How does your agency typically engage with outside experts? Meaning, how much are you going to pay me? It is a full file extraction using Gray Key. This is what Tully says. Again, Sunday at 6 a.m., May 7th. We do not use typically outside digital experts. We have sworn personnel who are experts. But given the allegation of corruption and the technical nature of the issue, we are in search of someone who can really explain databases and how iOS stores information. I have a question. Olivia, you're wicked smart. Some other people in the chat are also wicked smart, but please don't answer this question unless you really, really know the answer. He says it's a full file extraction using Gray Key. I thought they had a Celebrate extraction. Is Gray Key only used when you have to jailbreak the password? I don't know why my chat just froze. Is Gray Key only used when they need to break into the phone, or is Gray Key used interchangeably with Celebrate and Axiom and all that stuff? I don't know the answer, so I'm curious. Yeah, we need you. Our guy missed 34,000 texts in our last case, so that's Cosgrove's reverse mortgage who said that. Brian, thanks, she says, Jessica Hyde. With the FFS extraction from Gray Key, we should be in a great place to engage for work. Yeah, Olivia says Gray Key is the unlocking tool to get into phone data. But if this was Jen McCabe's phone and she turned it over willingly, she would have given them her password. So my question is, would they have had to use Gray Key even if they had a password? Maybe. I don't know. I mean, I'm focusing on the elephant in the room here. Pardon. Gray Key is how they download the phone. Celebrate is the software to read the data. Thank you, Josh. Thank you for dumbing it down like I'm 5. Okay. Yeah, Gray Key can take months if it has to, rainy day. Gray Key is the machine that pulls the info out of the phone. That data is unfed then fed into analyzer programs. Okay. All right, cool. At first glance, this may potentially be a time zone issue in which some data is UTC and some is EDT. However, we won't know until we take a look at the forensic image. We're happy to assist in this matter and conduct the analysis as well as testing and verification to ensure a true understanding of the timeline of the internet search in question and produce a report. We have strong capabilities in the area of iOS system artifacts, browser artifacts, and SQLite analysis. I have attached our rate sheet for your review. We do provide a 25% discount to law enforcement, which is reflected on the attached. Please let me know if you would like to proceed, and we can work out the best method for Hexordia to obtain a copy of the evidence and begin analysis. XOXO, Jessica. I'm just going to say, Jessica, call the cops, girl. Call the cops because you've been robbed. You've been robbed. They paid Aperture like $600K, like for, blue paint nonsense that Everything Trooper Paul did and stuff. And they were billing them like $75,000 a month. Girl, you were robbed. Because I think they only paid you something like a couple grand. Don't call these cops, though, because they won't, solve it or anything. And, of course, you should have never told them you would give them a discount. Because then, of course, Tully writes to Marcy, May 7th at 8:47 a.m. Referenced to me, I should say referred to me, by Ed Keefe. She apparently is big in this field with lots of articles and a turban. He didn't say turban. And then that's when Marcy writes back at 9:01 a.m. on Sunday, May 7th. Hire her immediately. Do not pass go. Do not collect $200. It is Sunday, May 7th, and I must do everything within my power to protect Jennifer McCabe. I must protect Jennifer McCabe. Too sweet. Hire her immediately. Immediately. Who's Ed Keefe? That's a good question. I'm not really quite sure, Kate. Anybody know? Maybe a cop? Maybe he's a cop? He's law enforcement? I don't really know. Over 40 grand for Jessica Hyde to regurgitate Tully's lies. Over 40 grand, says most talkative. However, It's just a drop in the bucket, really, as compared to what, Aperture. They were billing 8 hours a day. They were billing some days 24 hours a day. We went over the bills. We know. Cherie gifted a membership. Thank you, Cherie. And Adelnet became a new member. Welcome. And Faye gifted a membership. Thank you, Faye. You're the greatest. David Reese says the elephant in the room is where are the socks? Oh. Man after my own heart. Where are the socks? We still don't know. Iceman became a member. Thank you so much. Cats Meow 420 gifted 5 memberships. Thank you. Thank you. Hello, Sissy, who's been here for a year. Happy anniversary to us. Amy with a Y became a member. Kathy says we need a Melon Nurse Kim slumber party. We do. We really do. We got to plan that. We got to plan it. Wet my whistle, WHET says my new name. Love following you. I love you following me. And I love that you play along and change your username at the drop of a hat just to make us laugh. And Helen is here from Sweden. And she says this incredible, bombastic mega motion almost deserves its own playlist. I'll start. Do something, Britney Spears. Help. That's awesome. All right. We're gonna look at a little Emily C because we need a little Emily C palette cleanser. Was talking, it became a YouTube member. Let's get Emily C's subscriber count up on the tubes of you, shall we? I think we should. And here's Emily C. She's going to make us laugh for 3 minutes and 13 seconds. And this video is entitled, Tim Bradel asks Judge McCarthy Naaman for an alcohol test that doesn't torture Kelsey Fitzsimmons. And here's her YouTube channel. It is Emily SEE. All right. She's got 2.55 thousand. She's got a little over 2,500 subscribers. We can do better. You can go there. You can support our girl. See how many subs we can get her today, because we like to do this because it's fun. It's fun. And because she's so entertaining. Ready? Here she is.
Good afternoon, Your Honor. Timothy Bradel on behalf of Kelsey Fitzsimmons. She's present in the court. I've received the...
Hang on. Sorry. I don't know why I did that. Wait a minute. I just boosted the volume way too high. Okay. Here we go. Here's Emily. Okay. Back to 1.
Good afternoon, Your Honor. Timothy Bradel on behalf of Kelsey Fitzsimmons. She's present in the court. I've received the defendant's motion for emergency release from the scram order. Thank you so much, Your Honor. Kelsey has been passing the alcohol testing, but the scram method has been causing her hours of pain and dizziness. So I see this as a simple adjustment of term. I don't see it that way. If she cannot or will not be alcohol-free, then that changes everything. She's happy to be alcohol-free. We just want to adjust the method of testing to one that doesn't cause her pain because she's still recovering from being shot. Okay, so you're asking the court to adjust an order that's been in effect for 3 days with no evidence about the fact that she cannot do it? Well, you have 2 affidavits and the email from probation. An email from a probation officer? The court gives that 0 weight. What evidence do I have that she has broken ribs? The other day, I submitted instructions from Mass General about her broken ribs. Okay, I want to hear about the one that she had difficulty with. I don't want to conflate having difficulty with passing. She's had difficulty with every scram test, but I'm more than happy to submit this that says that she's passed every test. It's not about more than happy. Either you're doing it or you're not. My job as the probation officer is that when we have an incomplete test, I need to gather more information, which is that she is in genuine pain. What I have in front of me is an incomplete test at 3:09. So it says that the test was attempted, but she was unable to blow for as long and hard as she needed to, and the test was eventually completed at 3:50. Commonwealth, do you want to object? This wasn't noncompliance. She took the test and doesn't have alcohol in her system. Well, that's your position. It's really up to me. Your email is excluded. I just want to clarify, Officer January, nobody is asking you questions. Your testimony is complete. We just want Ms. Fitzsimmons to submit to alcohol testing. Mr. Bradel, is Ms. Fitzsimmons able to do the scram? That depends if the court is willing to tolerate. The court is not tolerating anything. Let's be clear. I am not tolerating anything. Ms. Fitzsimmons is a defendant. My order is that she submit to a scram. Can she do it or not? She can do it, but with significant pain and dizziness. And I would submit that there's other ways that are not torture. It's not the court's intention to torture Ms. Fitzsimmons. We just want to make sure that Officer Noonan is safe. Well, that's an Eighth Amendment issue, I suppose. I would submit that there are alternatives to scram, like urine test and other things like that. Okay, I'll be right back. I've reviewed everything, and because we obviously don't want Fitzsimmons to be subjected to cruel and unusual punishment, the prior order is vacated and I order her to be held without bail. That's the court's order. Bye-bye.
If we love Emily, if the jury has reached a verdict on Josh Hubert, and I can't find anything. Like, I can't find anybody. Oh, she says we're the best people in the world. You guys are the best people in the world. Thank you, Kel, another one of my amazing moderators, for your sweet email. She missed the unboxing of the silver play button, but she's congratulating me. She is an amazing moderator, as well as Scott Messerschmidt. I don't know if Scott's here today. We got two Scotts and a Kel, Team Brittany, Little Cupcake, Grace. All you guys are amazing. And you guys are the best people in the world. You absolutely are. Women lifting up other women. That's what we do. Thank you, Mastad. Called the clerk's office on Hubert to see if there's a verdict. And so far, there is not. Because that's what we do here. We call the court. I call the court. They must be so sick of my voice. Hi, can you give me the Zoom information for courtroom 25? Well, now I know it's the same for courtroom 25 every time. So when I know it's in courtroom 25, I already have it. But some counties, the outer counties that we don't deal with very often, I have to call there, like, Salem. And then some of them don't even have Zoom, and they don't do it, and they don't have it. And we can't. They're like, yeah, no. David Reese says the other elephant in the room is, why was one of John's socks upside down in the photo in the ER? I know. I still have so many unanswered questions. And Paula became a new member too. Melanie, Skylar, and Dizzy, you are all set because you knew how to follow the instructions and you sent me your link to your channel. I don't know what is going on with YouTube because my mods just don't go around blocking people for no apparent reason. So I don't know what is going on, but it's weird. It's weird. So all right, here's what we're gonna do. We're gonna say goodbye for now. We're gonna come back tomorrow. Tomorrow's Friday, right? Why don't we, same bat time, same bat channel? We're never gonna know about the socks. And if you missed it, I unboxed my silver play button that I received from YouTube for 100,000 subscribers. Here it is again. And it says on here, which you can't read because my ring light is in the way, presented to attorney Melanie Little for passing 100,000 subscribers. And I received this a long time ago during the Karen retrial. And now we're up to, like, I don't know, 127, almost 128,000. And I just opened it today because there's just never been the right time. So thank you. And if you're not subscribed, why aren't you? It's free. Just hit that button. It's not hard. Let's come back tomorrow at 10 a.m. and we'll continue. We're only on page 20. We went through a lot of it today, but it's really fun. And saying goodbye is the hardest part. Now, listen, if a verdict happens on Hubert, I'm going to come back. Okay. Because it just so happens that I don't have anywhere to go right now. So if a verdict happens, we can come back. Also reminding you that Alan Jackson's going to be on Billy Bush at 5 p.m. AJ. I don't know what he's there to talk about. I don't know what's happening over there. But if you want to go watch it, go watch Billy Bush. Billy Bush has always been very nice to me. I've been on his channel a couple of times. He's on a psilocybin journey. He went and did the thing with the anybody watch 9 Perfect Strangers with Nicole Kidman? Billy Bush went and did that. Like he went to a place with a guy who gave him psychedelics and he's working through all of his trauma. And it was fascinating to listen to. I don't understand why he doesn't have a bigger audience. I don't understand. I don't know why. I vote we watch Emily's video every day until every stream until she hits 50K. Truckers against tie clips. I mean, who am I to say no to you? Look at this guy. Look at his profile picture. Look at his cowboy hat. There was a day when I said I am not a fan of tie clips, and what did he do? He went out and he changed his username to Truckers Against Tie Clips. He is driving an 18-wheeler on one of the many highways, listening to us, keeping him company too. And so I don't understand why Billy Bush doesn't have more viewers. But when I turn into his live show, he's got like only 200 people watching. I don't know. I don't know why. Yes, I saw that was an incredible testament that Billy Bush gave about his therapy. I also, Melissa, if you listen to Billy Bush, you know that he seems to me to be very sober curious. Do you notice that? He did an interview with, was it Rob Lowe, talking about his sobriety. And the way he talks about his drinking, I feel like he's sober curious. And I feel like he would probably be much happier if he really did stop drinking. I don't understand why people are just like, it's like the pressure from other people to drink is so much more than the pressure of the person who's not drinking. And it's like, if you're not drinking, there's like, why aren't you drinking? And I'm like, why do you care whether I drink or not? I don't drink because I get so congested now when I drink. And so if I drink a glass of wine or a vodka and whatever, or a beer, it doesn't matter. I will use an entire box of tissues at the end of the night. It's not worth it. I feel like garbage. And I don't know why. If anybody knows why that's happening to me for the first time in my entire life, let me know. But I just decided it wasn't a conscious decision. Like I joined the program, not that there's anything wrong with that, but I'm like, I get so like physically sneezy and allergic. Is there such a thing as an allergic reaction to wine and beer and vodka? I thought if I drink vodka, okay, I won't be allergic. Maybe it's the sulfites. Maybe it's the this. Maybe it's that. It doesn't seem to matter what I drink. And it's never a problem. Listen, I've always been a drinker. It's a relatively new thing since like 2020. And then also during, the lockdown, I was like, why am I going to drink? It just makes me sad. I don't need to be sad and mad and angry. I'll just not drink. And it could be the gluten, but vodka, there's some vodka made from potatoes, some from grapes. I don't know. Objection 403. So I think Billy Bush should consider just not drinking. He seems to be very curious about it, but he doesn't want to do it because he thinks he's not going to be any fun. And then, if I'm not drinking, people are like, why aren't you drinking? I'm like, why do you care? I can have fun without drinking, right? So I don't get it. Could be a hormone change. Oh, okay. I didn't know that, Ruby. I'm going to have to look into that. I'll fall into a rabbit hole. Objection 403. Melanie, me and my daughter are coming to New York next week to see Hamilton. Oh, that's amazing. You're going to love it. Our first time in New York, her first time flying. So excited. Okay, I'm going to recommend something to you. Are you going to a matinee? Here's what I'm going to recommend. I did this with my daughter recently. We did a 2 a day. We went to see a show about Mary Todd Lincoln for the it's called Oh Mary. It's a comedy. It's funny. For the matinee. And then we were done and it was only like 5 o'clock. And I'm like, we went out to eat. And then I was like, looking at StubHub. I'm like, you want to go see Chicago at 7? Because we hadn't seen Chicago in a long time and you can get good deals on StubHub like last minute. And so we did a 2 a day. We went to see Oh Mary in the afternoon and then Chicago at night. Highly recommend. It's like you're in New York City. Just do it. Buy the tickets, do the things. Oh Mary, it was hilarious. And we actually saw the understudy and she was great. Usually it's a man who plays Mary Todd Lincoln in the play. And it's funny. And we really had a good time. So there's that. Right. Truth Seeker says I have a knack for having fun and it doesn't require alcohol. I know. People get so offended when you don't drink and it's just like, I'm having fun. Why do you care? I don't get it. Oh, the verdict was reached. The verdict was reached. Hold on. The verdict has been reached in Joshua Hubert. Hold on. Okay, are you ready? Here is the verdict on Joshua Hubert. Thank you to Mass Dad, who called, the clerk called Mass Dad back to say, Joshua Hubert has been convicted of everything except the 2 charges of aggravated grape. So the jury did not believe the grape charges, which may have a lot to do with the seminal DNA that was found in the victim, the 7-year-old victim's underwear, which belonged to her father. And perhaps the delay in disclosure of 5 years, but he was convicted guilty on the kidnapping charge. I'm trying to find out what are the other charges were. Must be assault. This article is not telling me. So he got convicted of some stuff. Listen, he's been out on bail since 2017. So I guess he got cuffed. But again, Mass Dad coming to us with the immediate information from the clerk. He's been found guilty of 6 charges. Oh, and this is weird too. The guy who's tweeting this, his name is Craig Seaman, Semon. Joshua Hubert has been found guilty of 4 of 6 charges, including 2 attempted murder charges, kidnapping and suffocation or strangulation. Found not guilty of the grape charges. Hang on, because let's give Craig Semon credit, because he also has attached a photograph from inside the courtroom as I guess the verdict is read. So hold on. Thank you, Mass Dad, for that. I usually sometimes don't even look at it's a histamine response. I don't even look at my emails, but it just popped up right in front of me. So here we go. Give this guy a follow. Craig Seaman, Semon. Joshua Hubert, 4 minutes ago, has been found guilty of 4 of 6 charges, including 2 attempted murder charges, kidnapping and suffocation or strangulation. Found not guilty of the 2 aggravated grape charges. There is a defense attorney in a pinstripe suit, Kevin Larson, and the defendant, Joshua Hubert, and the court officer. This is day 3, I believe, of deliberations. They went out on Tuesday. Oh, and now WCVB is picking it up, but they're not getting the correct story because this is September 17th, yesterday, when they were just waiting for a verdict. They didn't, by the way, report on this at all during the pendency to the trial, right? During the pendency of the trial, I don't think. Yeah, there's also no DNA in the car. Yeah, I'm like, hello, breaking news, breaking news, breaking news. And Cardi B is like,
Hello.
Hello. Hello, I'm here.
So there you have it. Convicted of everything except the grape charges. Let's see. And that's the latest tweet. And he's the only guy. He's the only guy, aside from Mass Dad, who got a personal call from the clerk in Worcester, who's out there on the Twitter reporting about this because he was in the courtroom. Let me see what his bio says. Craig, Semon. It doesn't say that he's a reporter or anything. So I don't really know. He only has 1,700 followers, but he lives in Worcester. So maybe that's why it's a local story for him. All right. Well, I'm glad we were able to cover what we could of that case together because nobody else was reporting on it. We all have questions. We all have questions. Music to My Soul says, speaking of the socks and the other things that might have been covered in the sidebars, did the court ever rule on the motion to unimpound the sidebars? I don't think so. I don't think so. Unless anybody has any different information. I don't think the unimpounding the sidebars has been ruled on. Debbie says alcohol triggers the inflammatory response. I can't have it due to endometriosis inflammation. That's interesting. I don't have endometriosis, but maybe an age-related allergy that has just about developed. And thank you, Boxer's mom, for also becoming a member. And if you're just tuning in now, first of all, where you been all day? And second of all, Joshua Hubert has been found guilty of 2 counts of attempted murder, kidnapping, and suffocation or strangulation. I don't know how much time he's looking at. I don't think he's going to be sentenced today. I think usually what they do, I don't know about Worcester, but usually they get a pre-sentencing report and then they come back. But he will be taken into custody today. He will be taken into custody today. And maybe somebody out there in the universe will actually report on it. Yeah, I can't drink Gavel and Gloss because when I do, and this is only something that's happened like in the last 5 years, I get very congested. If I have even one beer, one glass of wine, a vodka martini, I get so congested by the end of the night, it takes an entire box of tissues to blow my nose. And Elaine says it's called menopause. We have to put the alcohol away when we hit it. I had no idea. Elaine, I did not get the memo on that. Nobody told me about that. I mean, listen, not having your period anymore is a pretty amazing thing. I'm not going to lie. Amazing. I never had any other bad symptoms like night sweats or having to stick my head in the freezer, anything. Never had any other symptoms ever. This is the symptom. This is my, whatever. It doesn't matter. It doesn't bother me. And I get congested every single time. So I don't know, but it doesn't bother me because you know what? Who needs a hangover? Number one, who needs to get sad or angry? Number two, and, ain't no thing. It doesn't bother me. Not drinking doesn't bother. It bothers other people more than it bothers me. Right. And Club P's Elephant says, being sober now is very socially acceptable. I love how that has changed. The mocktails are amazing. Yeah. You know, it's interesting because my older kids who are millennials, their generation, big drinkers, and my younger kids who are Gen Z, they're not so into drinking. Yeah. So there has been a shift. And there's a lot of people who it doesn't have the thing. It doesn't have the cachet, like the social cachet anymore that it used to. Are they making it differently? Maybe. Are they putting more histamines in there? I don't know. I tried organic wine. I tried it all, but it doesn't, whatever. Yeah. You see that too, right? In the generations, like the millennials and the Gen Z, totally different. Mitchell says, I am your number. You envy me with the allergy. I'm getting allergic right now, and I didn't even have a drink. I'm drinking nice coffee with you all day. Mitchell says that it is number one source for news. Thank you. Thank you. Thank you. Thank you. So we don't have to come back because we just saw the verdict on Hubert. So there's that. All right. Everyone plan to come back here tomorrow at 10 a.m. And we're going to start at page 20. And we're going to keep going with the hyperlinks. Could be another full day. Today was 5 hours and 52 minutes. And then there's always going to be the people who is reporting. It is somebody who was in the courtroom. Megan. Craig Seaman, Semon. I'll put it up again because nobody else has picked it up yet. This is it. When you search up Joshua Hubert, this is the only thing you're going to find. Joshua Hubert found guilty 11 minutes ago of 6 charges, including 2 attempted murder charges, kidnapping, and suffocation or strangulation. Found not guilty of 2 aggravated grape charges. He did throw off a bridge. The grape part, obviously. So Scott McGinnis was not proven by Worcester County DA Joseph Early, possibly a failure of DA Early's own in-house state police detectives. So there's that. And of course, Mastad got a call from the court, and he notified us immediately before we even could find anything on the As Such socials. Okay. Please return for Mega Motion episode 2 to convene tomorrow at 10 a.m. I love you all with all of my heart. And if I will see you in the morning, thank you, moderators, for keeping it classy today. Thank you for celebrating my silver play button 100,000 subscriber milestone achievement with me because you were all amazing and you were all part of that. And I love you all with all of my heart. I'll see you tomorrow at 10. Thanks, moderators, for keeping it classy. Thank you, moderators, also for being with me for all of this time. Many of you since the very, very beginning of this channel. And without you, I couldn't do it. I couldn't do it. There's no way I could do it. I can't watch the chat because the chat distracts me. And I can't do it. So tomorrow at 10, I always say that I'm saying goodbye and then I keep talking. So like, oh, Teresa, thank you so much. Thanks, Teresa. That's okay. That's all right. I'll see you in the morning, you guys. All right. Stay cool, stay kind, stay classy. Who knows what else could happen today? So just stay aware and, stay safe out there, my friends. I will see you real soon. Smash the like on your way out. If you don't mind, smash the subscribe button if you haven't already, because if you haven't already, then you're missing out on a lot of really fun stuff. All right, my guys. I'll see you in the morning. Good night, everyone. Peace.